100+ documents. Haven't given sufficient time for argument. It's posted on Monday.
Dharwad matter. Alle move ಮಾಡಿ. Dharwad matter. Parole extension. File ಬರ್ಬೇಕು ಅದೆಲ್ಲ ಆಗಲ್ಲ. Give it. It will come. Whenever the file comes, it will come. So. All right, we'll see. Payroll. Yes. Good. Kodi.
It's coming before trial.
Let it come Monday. Yes. Monday. Yes. No. Give it. Nothing.
This is CRP, not the
Fresh matter. Successive rate. Successive rate. Wash ಮಾಡಿದೀವಿ. ಕೊಡಿ ಬರುತ್ತೆ.
This is CRP, not the tomorrow.
It will come on Tuesday.
This CRP, not tomorrow, not the.
CRP ಕೊಡಿ tomorrow.
You know, writ petition fresh matter.
CRP ಕೊಡಿ.
Writ petition fresh matter. It is posted for evidence in trial courts. So kindly have it on 13th. You know,
Monday.
But one alternate matter, my lord, which was from the previous poster. Then Lordship may kindly push it on some day, which is.
482 na. GM.
ಅದಕ್ಕೂ ಮತ್ತು GM ಅಲ್ಲಿ.
ಕೊಡಿ.
Lord, my pleading application to bring some defendants has been dismissed by the trial court. I filed a writ petition. There's no order of stay, my lord.
Odd one rule 10 ಹಾಕಿದ್ದು ಯಾವಾಗ?
Lord, evidence is going on. It's on 19th.
Correct.
We've taken on Monday. Please.
great extension of parole.
Give it. Extension parole.
Extension.
One matter for 230 minutes.
ಏನು?
There's an invocation of a pledge. Act, but this is not a proceeding taken under Surface Act. And on that ground, Lord refuses interim order to me.
What is the proceeding taken?
They have invoked a pledge, my lord. We had given a pledge to the creditor.
Now what has happened now?
Now they have given us 3 days.
No, it is rejected.
It's rejected. It's
230 in urgency.
Today is the last day. 3 days they gave us saying if you don't pay within 3 days, the pledge will stand in. That's the reason.
230.
Complete.
My lord, one clarification application in a disposed matter, my lord.
Oh, yes, madam. When do you want it?
My lord, 24th or 25th, my lord.
I thought whenever madam wants, post that matter.
Grateful, my lord.
ಅವ್ರದೇನಾ? Yes. ಅದೇ madam. Clarification with that special court matter, right?
Yes, my lord.
All right. We will post it on 24th.
Very well, my lord.
All right.
Obliged.
Yes.
Serial number 56. Serial number 56.
Adjournment ಕರೆದು ಬಿಡಿ madam.
Lordship, in this matter, Lordship.
Preliminary hearing ಬಿಟ್ಟು.
Lordship, this is the transfer matter. The respondent has enclosed a public plan and he has filed a suit before the civil court. And we have LGT matter is pending before them. They are seeking a transfer of civil matter to LGT, Lordship.
Monday.
And this another matter is a long pending matter, Lordship. This is covered matter, stamp duty matter, where the court.
GM ಯಾಕೆ ಇಲ್ಲಿ ಬರುತ್ತೆ?
It's CPC. It's a CPC.
ಅದು ಮಂಡೇ.
Obliged.
Preliminary hearing of admission ಬಿಟ್ಟು ಯಾವ್ದಾರು ಇದ್ರೆ ಕರೆದು ಬಿಡಿ madam. Today time is
adjournment. Page 6, 33, 34. Page 7, 35 to 37.
Your lordship, serial number 35, your lordship. I'll comply with the office objections. A week's time.
2 weeks time is granted to ಅಲ್ಲ interim order ಇದೆಯಾ?
No, your lordship. I had filed NOC.
2 weeks time is granted to comply with the office objections. Yes.
Much obliged, your lordship.
Next.
Page 8, 38 to 44. Page 9, 45 to 48.
My lord, serial number 47, my lord.
Ah.
Appearing for petitioner, my lord. My lord,
vacating interim order, sir.
My lord, the counsel on record is hospitalized, my lord. She has been
Senate
admitted.
counsel for the petitioner submits that the arguing counsel is hospitalized and therefore seeks 2 weeks time. Less the matter 2 weeks ಆದ್ಮೇಲೆ ಒಂದು ಡೇಟ್ ಕೊಡಿ.
Interim order may be.
ಅದಕ್ಕೆ ಗೊತ್ತಾಯ್ತು. Yes, 2 weeks back ಡೇಟ್ ಕೊಡಿ.
27.
27th. It is made clear no further adjournment would be granted in the matter. Yes, next.
Okay, sir. Great.
On the aforesaid condition.
Same ground last time they took the adjournment, your lordship.
Same hospitalization.
Seriously, my lord, she has been hospitalized. My lord. Yesterday she called me.
Your colleague or what?
She's not my colleague, my lord. She has instructed me to take adjournment.
Make alternate arrangements. I'll take it finally on 20th. If you don't come on 20th, It is made clear if any further adjournment is granted in the matter, is sought in the matter, the interim order would get automatically vacated. Yes,
Interim order
next.
may be extended.
On the aforesaid condition, interim order extended.
Grateful.
Page 10, 49 to 53, page 11, 54 to 59.
56 you have to give.
Uh,
1 week you have to give.
A week's time is granted to do the needful. Yes, next.
Interim order with him.
Page 12,
Extended.
60 to 63, page 13, 64 to 69.
60? Yes, sir.
I appear for respondents. Due to
62
personal-
I appear for
to
petition.
personal inconvenience, senior is not unable to attend today. So 2 weeks accommodation.
No, ಅದೇ ಇವತ್ತಿನ ಕನ್ವೆನ್ಷನ್ 2 weeks ವರ್ಗೂ ಅದೇ ಇರುತ್ತಾ? List the matter next Wednesday ಬೇಡ. ಅದು list the matter on 19th. 19th end date.
Senior ಇಲ್ಲ so.
ಪರವಾಗಿಲ್ಲ ಸರ್, ನೀವು ರೆಡಿಯಾಗಿ. List the matter on what date is that? June 20th. Yes. At the request of the council appearing for the respondent, it is made clear no further adjournment would be granted in the matter to the respondent. Interim order, yeah?
Interim order.
Sir, yes, next.
Obliged.
Any other?
Being spoken to. Still number 1.
Yes, sir.
Appear for the petitioner, my lord.
My lord, my learned friend has given a list of URLs also.
In fact, on May 14th, my lord, the client has written to the Google's official ID with the
You
same
have blocked
URLs.
those URLs?
Lords, I will block these URLs. My only difficulty is this. Once the original file is masked, then I may be
That we
granted.
will direct the court to do it, don't worry.
Lords, once it is done, your lordship may give me liberty to bring them back because at that time, name will not be shown.
All right, no problem. That I will dispose it on that. Yes.
The other thing is, Indian Kanun does not appear to have been served.
They will not appear also even if served.
Yes, my lord, your lordships had observed the same thing. My lord, one specific observation about additional cases that I had filed in my memo, my lord.
Well,
The names in
we'll
that also may be masked.
To this court, we will direct, looking at this stage, only if you are acquitted in all the cases. Or all the cases are closed. Pending cases.
All are
will
closed, my lord. I have personally checked, all are closed.
Fine.
And hence I have submitted the memo, my lord. Those cases may
will
also be
answer that.
masked.
Yes.
Much obliged.
Great.
In Vijay. Yes.
Number 2, preliminary.
CRP is maintainable is.
Question was already
It
raised.
is.
my lords.
CRP is maintainable.
Yes, my lords. Because, my lords, I raised a question of maintainability of the AA filed under section 9 before a civil court, my lords, because it's a commercial dispute.
Either this is other.
Please,
Same problem. This
same
is part of
agreement.
it. But a section 9 application, anything, my lord, will have to be challenged as a writ petition itself.
That's
It's a CRP. Whether in an arbitration section 9 application you can file a CRP will be a question.
writ petition is GM.
Writ petition, it will be arbitration.
CRP then is.
CRP
Plus,
ಬರಲ್ಲ.
if the
Arbitration.
application, with the maintainability question which I raised, if it is answered in my favor, the proceedings before that court gets terminated.
So in a suit, yes, no, that would apply in a suit, but not in a section 9, I'm saying. Everything else is all right. In a section 9, it may be difficult.
May be right. File a writ petition.
This could be converted as a writ petition.
Allah, if we'll do that, you can convert it to a writ.
Whatever.
File a memo, we'll answer.
Please,
Counsel for the petitioner files a memo seeking conversion of the subject petition to be a writ petition, as the order that is called in question is an application, rejecting an application in a section 9 proceeding.
Not an application, it's only a memo.
Rejecting a memo in a section 9 proceeding. In that light, in the light of the memo so filed, petitioner is permitted to convert the subject petition to that of a writ petition, and the matter be posted before the court having appropriate roster. Ordered accordingly.
for my lords only writ petition. GMC.
GMCPC ಅಲ್ಲ, GMCPC ಆಗುತ್ತಾ?
Arbitration ಆಗುತ್ತೆ.
GMCPC ಆದ್ರೆ will take it Monday, no problem. Appropriate roster ಅದಕ್ಕೆ.
Because same
ಅಲ್ಲಿ ನೀವು
question,
ಮೆಮೊಲ್ ಹೇಳಿ GMCPC ನ GM ಅಂತ ಹೇಳಿದೆ.
this matter is posted before the commercial court where I filed the application. my
That's
lords. That's
different.
Monday.
today.
That's a different matter.
Monday.
That's today, my lords, because this issue will have their bearing there also. my lords,
Monday, sir.
therefore.
We'll post it on Monday.
Friday.
Friday is again a half day. We have started at 12. We will end at 1:30 that day. Yes. ಇದಿನ್ನೂ ಪ್ರಾಬ್ಲಮ್ ಮುಗ್ದಿಲ್ವಾ?
ಇನ್ನು ಜಾಸ್ತಿ ಆಗ್ತಾ ಇದೆ.
It's becoming worse every passing day.
No student is troubled, right?
No, man.
Teachers and principals and workmen are troubled.
No.
That's the
Principals.
principal in Mysore and Bangalore.
Oh,
3 schools, my lords, totally.
that's why when you commercialize education, this is what is going to happen. All for money.
True, my lords.
You're all fighting for money.
No, I'm fighting for the school, he's fighting for the money.
Oh, he will tell the other way around.
No,
Anyway,
no. He
Monday.
says he wants
Anyway, it's my school.
minimum revenue
Monday.
guarantee. Minimum revenue guarantee he wants. With that guarantee, he'll permit me to run the
ಅದೇ
school.
ಅವ್ರ ಮಿನಿಮಮ್ ರೆವಿನ್ಯೂ ಗ್ಯಾರಂಟಿ, ಮಿನಿಮಮ್ ಎಜುಕೇಶನ್ ಗ್ಯಾರಂಟಿ. ವಿಲ್ ಸಿ.
Education ಕೊಟ್ರೆ ಸಾಕು ಅಂತಿದೆ.
Yes, yes.
Please.
Close. Statistical.
3.
My lords, for the petitioner, my lords.
I'm appearing to the resolution.
Yes.
This is an order, my lords, transferring the suit from commercial court to the civil court, which is under challenge.
According to you, it is a commercial dispute?
Yes, my lord. The reason is, my lords, the plaintiff is a firm which is in the textile business and it had a current account with the defendant number 1 company.
All
The
right.
accountant of the plaintiff has forged certain signatures and the defendant number 1 bank has passed those checks, my lords, amounting to a sum of 4.5 crores. The employees of the defendant number 1 bank is also involved. I issue a legal notice saying the bank is negligent in passing these checks under the NI Act. It's not passed bona fidely. So therefore compensate me. The ICICI Bank and its directors, they refuse to do that. I file a suit, my lords, initially before the city civil court rural, and it gets transferred to the commercial court. Commercial court on its own frames a issue on jurisdiction and passes this impugned order, my lords.
Yes, madam.
My lord, jurisdiction issue, they have to convince this honorable court, my lord. I have no objection.
They have not objected either before civil court or before the commercial court. There's no objection of the bank at all, my lords.
But
How
what
does it
they-
become a commercial dispute and 2-1C? Tell me.
My lords, it's a dispute arising out of a banking transaction. I have a current account.
What
It's not a
Commercial Courts
savings
Act,
account.
Commercial Courts Act.
The lordships may see section 2CI, 2C1, I'm sorry.
2-1CI. Yes.
Correct.
Hmm.
Commercial dispute means a dispute arising out of ordinary transaction of merchant, bankers, financiers, traders, such as those relating to mercantile documents, including enforcement and interpretation of such documents. This is a banking dispute and the mercantile document is the checks which
How
are
is it a banking dispute?
My lords, because I'm alleging that the bank has passed the checks negligently, my lords, and vicariously the
How
bank
will
is
that
liable.
become a commercial dispute, sir?
My lords, because it's
Now,
a
bank has passed the checks, forged documents or whatever it is. How will it become a commercial dispute?
My lords, because there's a contract between the bank and me, my lords. When I open a bank account, there is a contractual relationship
See,
between the
for-
bank and me.
Your allegation is offenses of forgery, misappropriation,
Yes,
cheating,
yes, yes.
and all those things, result of which the checks have gone on.
My lords,
That does not become.
my lords, on the
Right,
same ground,
Rightly sent to the regular court,
may just make one submission.
unless you give me something.
On the same ground, my lords, the commercial court has observed that since allegations of forgery and fraud is involved, it cannot be a commercial dispute.
Correct.
The Bombay High Court as well as the
Padi,
Madras High
ellide
Court
adu?
had given, my lords, it's in the file itself, my lords. The 2 judgments of Bombay High Court.
No judgments are here, sir.
My lords, last time
I
had given-
search for the judgment.
madam, madam. One is of the Bombay High Court and the other is of Madras High Court. Your lordships may see the Madras High Court judgment first. The facts are at paragraph 9 of that judgment, my lords. In the present case on hand, the court below held that the plaintiff company was a customer of the 8th respondent, 1st defendant bank, and the 10th and 11th respondent, 4th and 5th defendant, who are the ex-employees of the plaintiff, had colluded with the employees of the defendant bank and siphoned off money in their own personal accounts. Then the ratio which is laid down is on the next page. Your lordships may come to the bottom of that extracted portion. my lord.
No, your customer and banker relationship will be there.
Yes, ma'am.
Bank employees collude with the customer,
Yes, ma'am.
indulge in so many acts of forgery or anything which results in a loss or siphoning off of funds.
Yes, ma'am.
That becomes a commercial dispute.
My lords, because this is a current account, my lords. Merely because there are allegations, it won't take it outside the purview of a commercial dispute. The definition says arising out of a.
ಇಲ್ಲಿ ಸ್ಪೀಡಿ ಡಿಸ್ಪೋಸಲ್ ಇದೆ ಅಂತ ಎಲ್ಲ ಕಮರ್ಷಿಯಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ಅಂತ ಕಳಿಸ್ಬಿಟ್ರೆ
My lords,
ಅಷ್ಟೇ.
my lords, it
We'll have to
says.
answer this. No,
the
no.
dispute.
See, this is a misconduct by the employees.
Yes, ma'am.
All right.
Yes.
Which has resulted in siphoning off of the bank, your funds held in the bank.
Correct.
So the ciphering of funds will become a commercial dispute between you and the bank.
Yes, ma'am.
We'll have to doubt.
Because it's a current account, my lords. Current account, only businesses have current account for the business purpose. It's for a commercial purpose. I have opened the bank account with the bank, my lords. And there is a contractual relationship between the bank and me. The
This-
Bombay High Court as well as the Madras High Court say merely because allegations of fraud is involved, it does not take it outside the purview of a commercial dispute.
Let me see, we'll have to answer this.
Both those judgments are on the same point, my lords. And the mercantile document is involved. Check is a mercantile document, my lords. The crux of
No,
the
that
dispute is
21C definition, yes. Mercantile documents including enforcement, interpretation of
Correct.
those documents.
whether the check is passed in a bona fide manner or not is the crux of the dispute. So check is a mercantile document, my lords, and therefore it comes
Then
within
this
the
will
definition.
open Pandora's box before the commercial.
My lords, if it's a savings bank account, I understand it has no commercial flavor. This is not between an individual and a bank. I am a business entity which had opened a bank account with the bank, my lords. It's a commercial transaction. It's a commercial bank account.
We'll see.
I produced, my lords, your lords may see from
We'll answer it.
ICICI Bank's website. I produced a definition of that current account, my lords, from their website itself.
No, that's all right, we'll see.
Annexure E.
You have no objection either ways, madam?
No.
Yes. I'll post it on Wednesday next.
Next Wednesday, madam.
List on Wednesday next. In the same stage, we'll dictate it. Because any answer here may open the floodgates for.
If it's
litigation.
savings banks, then it will open,
Well,
my lord. This is a current account. That is the distinction, my lord.
Let's see.
And also mercantile document check is involved, my lord. If check is not involved, then I wouldn't have a case.
If it's in your favor, we'll dictate it straight away.
I'll leave it to my.
Yes.
For
Petitioner, this matter.
Respond.
This is a writ petition by the defendants. An application for impleadment of defendants who are petitioners 2 and 3 has been permitted. Plaintiff is a respondent here. Suit is for declaration and injunction. The ground on which they've sought to implead me is that during the pendency of the suit, allegedly the suit scheduled property was gifted to me. Kindly see, my lords, the plain schedule is in survey number 3/5. The property gifted is in 3/2. The
Now,
property,
order 1 rule 10 is allowed?
yes,
All right.
I'm challenging that. My lords,
What was the suit is for?
suit is for declaration in possession, declaration and injunction
All right.
by the plaintiff who's the respondent.
What is the suit schedule property?
Suit scheduled property, your lordships will find it in the plaint.
Page?
Your lordships will find it at page 47. Site number 44 in 3/5.
Prayer is to declare 2 sale deeds.
The sale deed are in my favor and also declare her as the owner and permanent injunction.
No, 2 sale deeds are sought to be declared to be null and void.
Yes,
Correct?
yes,
Who is the beneficiary of the sale deed?
me, my sale deeds.
Your sale deed?
Yes.
You ought to be a party.
No, mine as in defendant number 1.
Huh.
2 and 3 are not the beneficiaries. The newly impleaded.
Now 2 and 3 are here. is
Yes,
it?
petitioner
Who are
number
2 and 3?
2 and 3 are supposed to be beneficiaries under a gift deed of the same property according to them during the pendency of the suit.
No. Now these 2 sale deeds
Yes.
are in favor of defendant number 1.
Yes,
Defendant number 1 executes a gift deed in favor of defendant number 2 and 3.
of a property which is not the suit schedule.
Not the
property.
suit schedule
No.
property. Yes, sir.
No. Suit schedule property only.
Now come, that's why I asked you, what is the suit schedule
The
property?
gift deeds are also produced.
Now,
Kindly see the
come
schedule
to-
with the gift deeds.
Suit schedule property is site number 244.
244.
In assessment 3/5.
All right. Assessment
The old
3/5.
survey number.
Your lordship may
Where is the
kindly
gift deed,
measure-
madam?
Measurement.
Deed, my lords, my learned friend has produced it on 8/2/2023 with a memo. But those gift deeds have been subsequently rectified. He has not produced the rectification deeds. I have it here.
Survey number 2/2. Where is the rectification deed?
My lords, the rectification deeds are here. I may be permitted to.
B.S. Shekhar is defendant number 1, is it?
No. Vijay Lakshmi is defendant number 1.
Then who is this donor, B.S. Shekhar?
My lords,
Gift deed.
he's her husband.
Husband.
She has a property which is not the suit
Now it
scheduled
is
property.
gifted to B.S. Raghavan. That is which,
Ultimate beneficiary.
that is the defendant number 2 and 3
Yes,
now?
they are now sought to be impleaded. My lords, there's
No,
also the.
if it's the same suit schedule property, yes, you have to be impleaded.
Not
But if it is
necess-
not,
It is
then we
not.
will
Kindly
see,
see
yes.
the schedule in the rectification deed. It's site number 244 in a different survey number, 3/2. My property is
Illiraದೇನು 3 bar?
2,
Oh no, what is the suit schedule property?
ಅವ್ರದ್ದು 3/5. Assessment number 3/5, that's the old,
Declare suit schedule property, one moment, madam.
at page 47.
3 bar 5 old 3. And this gift deed is
3/2.
bar 2.
It's written as 2/2, but rectified later as 3/2. Not the same property.
No, that rectification deed for the first time they are producing before this. We are not looked into the document.
It is 2019.
No,
One
no.
copy ಕೊಟ್ಟು.
Our copy code,
I'll give a copy.
we will look into it. I'll make some.
My lords, secondly, my lords, limitation. Kindly see when the gift deeds were executed.
2019.
Yes, and kindly see the application made. It's beyond the period of 3 years.
That we'll see. Now let him go see.
Limitation is also an
Heard the
issue.
learned counsel, Nayantara BG, appearing for the petitioner. The petitioners are defendants 2 and 3, who are now defendants 1, 2.
Petitioner, please, my lords,
Petitioners are defendant number 1 and proposed defendants 3 and 4. Are calling in question an order passed by the concerned court allowing an application under Order 1 Rule 10 of the CPC filed by the respondent plaintiff. The learned counsel submits that the suit schedule property and the property that has now fallen to the hands of defendants 3 and 4 by way of gift deed are entirely different, and therefore proposed defendants 3 and 4 are no way concerned to the suit schedule properties, and they are bringing in to contest this suit is contrary to law. The learned counsel would also further place reliance upon certain rectification deeds, 2 rectification deeds rectifying the survey numbers in the gift deed from 2/2 to 3/2. The suit schedule property concerns survey number 3/5 in a different assessment number. In that light, further proceedings before the concerned court shall remain stayed till the learned counsel for the respondent would justify the action of filing the application and bringing proposed 3 and 4 on record as defendants 3 and 4. ಯಾವತ್ತು ಬೇಕು? We'll
My
take
lords,
it on.
may I suggest this, my lords? The suit is actually progressing. I did not have an interim order. Now it's reached the stage of defendant evidence.
ಮತ್ತೆ ಈಗ
My lords, your lordships may post it any day next week. It's anyway defendant number 1's
Correct, I'm
evidence.
posting it next week.
After
Please,
10
my
days,
lords,
10
because
days,
if the matter.
Based on-
schedule are the same measurement.
Next
is same,
Wednesday.
Except the
Very well,
assessment.
my
Next Wednesday in same preliminary hearing
Because
stage.
the parties, my lords, are senior citizens. I don't want to stay. But
Then interim order ಬೇಡ, list next week ಅಂತ ಮಾಡಿ ಸಾಕು.
very well.
Please.
5,
Ex parte interim order is refused.
Rejected.
Reject, not reject, issue, notice has been issued.
ಅದೇ
My lord,
without
this is a-
considering anyway.
Yes, my lord. Annexure J is the sale deed impugned, my lord, which is at
ಈಗ
page 8.
are the respondent defendants represented there?
In there, my lord, not yet.
What is the suit for?
My lord, suit is for cancellation of the sale deed, my lord, challenge to the sale deed and, my lord, the declaration and
Cancellation of sale
injunction.
deed. Sale deed is in favor of the defendant?
Yes, my lord, respondents 1 and 2. My lord, what has happened, my lord, is I purchased this property in 1992. My lord, now the contention, my lord, is there was a special power of attorney given in favor of respondent number 4 by my power of attorney, and it is an unregistered document. That document is at Annexure H.
Those are matters that are there. What is who is in possession?
Lord, I am in possession.
How?
Lord, I have stated, my lord, that
You have asked cancellation of a sale deed.
Sale deed
of the year 1992.
Yes. Only prayer that I'm making, my lord, is they should not create further third party rights, because they could not have sold this property by an unregistered power of attorney at all. Kindly see Annexure H, my lord.
That is in 1992.
92, I purchased it. There is a power of attorney of 2018.
Where is the GPA?
Lord, that is at page 76.
76.
76.
Just a moment.
This is of 2018, unregistered. Based on this unregistered special power of attorney, my lord, sale deed seems to have been.
Telangana.
Yes.
Idu sale ellagirodu.
Illi, my lord, Bangalore, with properties in Bangalore.
Where is the sale deed pursuant to this GPS, sir?
My lord, 83, my lord, page 83. And this also sells properties which don't belong to me also. Schedule is at page 94. 87 is my.
The learned senior counsel as Sriranga appearing for the petitioner. The petitioner claims to be the owner of a property which is now the subject matter of proceedings before the concerned court, having purchased it in the year 1992. It is the contention of the petitioner that pursuant to an unregistered general power of a special power of attorney, the property in which the petitioner, property that belonged to the petitioner is sold to third parties. The suit is registered for cancellation of those sale deeds made of the petitioner. He would further claim that the petitioner is in possession of the property. In that light, the court ought to have considered grant of a temporary injunction. The court ought to have protected the petitioner. I therefore deem it appropriate to direct that the beneficiaries of the sale deed, which is now subject matter of the suit, shall not further alienate the property till the next date of hearing. One
Alienate or encumber, not in any.
Alienate and ella aguttalla. Alienate/create third party rights. Yes.
Okay.
Emergent notice to the respondent returnable by the 1st July. The petitioner shall serve on the counsel who represented the respondents before the concerned court. Innu agilwala
bandila.
Sari sir.
Notice
notice returnable by. Next.
Great.
The petitioner.
In appeal, it is reversed.
Yes, Lord.
Yes, sir.
Lord, agreement of sale and power of attorney on the same day it has been registered without the knowledge of the petitioners. The general power of attorney has been registered, and the plaintiff came to know about this only after second respondent came near the land to take the possession of the land as he has purchased the property. Thereafter, our inquiry,
What is the date of sale?
Lord, date of sale.
And who are you?
I am the owner.
Owner.
I am the plaintiff is the owner of the land. He entered into agreement of sale. He borrowed amount for the celebration of his daughter's marriage.
All right.
2,16,000 was the consideration amount.
2,16,000.
16,000. Out of 2,16,000, he has paid 2,10,000. 6,000 was not paid. So he was paying interest for nearly about 2 years. Thereafter, he could not pay. So the first respondent is a businessman in Bangalore, and he has lent the money. So he has sold the property in favor of the second respondent through the sale deed dated 27/6/2019. So agreement of sale is 5/3/2013.
Agreement was with possession?
No, possession was not there. I got the RTC in my hand.
The agreement is with possession.
No.
Then that requires to be protected. The first appellate court's order is correct.
My lord,
Where is the agreement?
It is agreement is produced at page 20. Annexure B. ನಾವು ನಿಮಗೆ ಕ್ರಯದ ಕರಾರು ಮಾಡಿರುವ ಸೊತ್ತು ನಮ್ಮ ಸ್ವಾಧೀನ ಅನುಭವದಲ್ಲಿಯೇ ಇರುತ್ತದೆ, ನಿಮ್ಮ ಸ್ವಾಧೀನ ಅನುಭವಕ್ಕೆ ಬಿಟ್ಟು ಕೊಟ್ಟಿರುವುದಿಲ್ಲ. At page 26 in schedule.
I have produced my statement of objections along with affidavit that is dated 13/11/2024. I have produced, my lord, the
Page?
page number 11. Annexure R1 and followed, my lord, at the last two lines. ಈ ಕರಾರಿನ ಪೂರ ಹಣವನ್ನು ಈ ಪತ್ರದ ರಾಜು ಒಂದು ಸಾಕ್ಷಿ ಸಮಕ್ಷಮ ನಗದು ನಿಮಗೆ ಸಂದಾಯ ಮಾಡಿರುತ್ತೇವೆ.
ನೀವೇ ಸಂಪೂರ್ಣವಾಗಿ ಹಕ್ಕುದಾರರಾಗಿ ನಿಮ್ಮ ಪತ್ರ
ಈ ದಿವಸ ನಿಮ್ಮ ಸ್ವಾಧೀನಕ್ಕೆ ಬಿಟ್ಟುಕೊಡುತ್ತೇವೆ.
Anything else, sir?
Please. Lord, suit for declaration.
ಪರವಾಗಿಲ್ಲ, suit ಅಲ್ಲಿ ನಡೀಲಿ. I am not on this suit.
So let
order of the first appellate court is correct.
No, my lord, for this reason, when the fraud is alleged,
ಅಲ್ಲಿ
right?
Yes.
Till this, the adjudication of the matter before the trial court,
correct.
Let there be an let the interim order granted by the trial court be continued, because the RTC still stands in my name. Yes.
RTC ಮೇಲೆ ಏನೋ
ಅಲ್ಲ, RTC has got presumptory.
ಕೆಲವು RTC ಗಳು 10 ವರ್ಷ ಆದ್ರೂ ಚೇಂಜ್ ಆಗಿರಲ್ಲ.
My lord, in the schedule
the
itself,
instrument on which you are claiming your right itself says everything is given to them. What else you need, sir?
Instead of filing a suit for specific performance, how can he exercise the rights of ownership? That is the reason. That is the reason.
Agreement with possession.
No,
it is just a step below that.
Lord, in the schedule itself, it has been clearly stated at
schedule
page.
ಬಿಡಿ sir, come to the narration.
ನಾವು ನಿಮಗೆ ಕ್ರಯದ
ನೀವು schedule title ಎರಡು ನೋಡೋದು ಬಿಟ್ಟು you see the narration, everything will be fine. As simple as that.
Lord, in the agreement of sale, it is not stated. So in the schedule itself, it is made very clear.
Agreemental, it is very clear.
Lord,
possession and enjoyment is with them.
No, possession was with the landowners.
6 years later.
The amount was borrowed for the celebration of marriage of his daughter.
ಅದೆಲ್ಲ ಅಲ್ಲಿ ನೋಡ್ಕೊಳ್ಳಿ. Yes.
Sari.
Registered agreement, Lord, 2013, Lord, and 2013 to 19.
Kindly appreciate the order passed by the trial court, the reasons given.
Agreement dated?
Agreement dated
5/3/2013.
5/3, correct. 5/3/2013.
Yes.
Tail deed is 27/6/2019.
Sale deed is dated 27/6/2019.
6 years, my lord, they have not sought for any cancellation of the agreement or power of attorney. It's a registered sale deed.
Loan transaction. Lord, it's not a sale transaction. Loan transaction.
Correct.
Agriculturist. Unless his rights are protected. Lord, see,
our rights protect ಮಾಡದು.
ಅಲ್ಲಲ್ಲ, you lordship may kindly appreciate 6,000.
Rights are rights
no,
to
no,
be protected
6,000
both of the plaintiff and the defendant.
Lord, admittedly, in the
balance of
agreement of sale,
convenience.
6,000 is the amount payable. Instead of filing a suit for specific performance, he executed the sale deed in favor of second respondent. And what about that 6,000? He has not paid.
Yes, that's subject matter of the suit.
That is, Lord, in
there's nothing wrong
the
with
given
the
circumstances,
nothing wrong with
the
the first
trial
appellate
court, after appreciating everything,
Yes.
has passed a discretionary order. The appellate court, having heard the matter, keeping the matter for 1 year.
That is the only problem in this.
And the appeal has been allowed. Lord,
They write a complaint to the police saying that ಸ್ವಾಧೀನ ಬಿಡಿಸ್ಕೊಡಿ ನಮಗೆ ಅಂತ.
ಈಗ ನೀವು what's this? What are you doing with the property?
I mean, occupation of the property.
Don't create further third party rights.
Lord,
just simple.
Allah,
he will not
possession we have not yet given. They are trying to
6 years ಏನ್ ಮಾಡಿದ್ರಿ sir?
It is with us. It is with us. We have been in possession. We are cultivating the land.
Continue to be asked.
Just let me.
Whoever is in possession will continue to be in possession.
Let that observation be.
Yes, that I will.
Please.
We'll close it. Yes. The petitioner is before this court calling in question an order of the first petitioner plaintiffs are before this court calling in question the order of the concerned order of the first appellate court by which the first appellate court sets aside the order of the trial court granting temporary injunction under order 39 rule 1-2 of the CPC. The learned heard so and so. The plaintiffs are said to be the owners of absolute owners suit schedule property. It transpires that the plaintiff enters into an agreement, registered agreement.
Please.
A registered agreement of sale in favor of the present defendant.
First defendant.
First defendant. The registered agreement of sale is appended to the petition. Appended to the statement of objections by the defendant. The registered agreement of sale prima facie indicates that the defendants are handed over possession of the property and are left to the enjoyment of the said property. The on GPA agreement is dated 5/3/2013. It is sold to defendant 2 and 3.
Only two.
Or defendant number 2 on 27/6/2019.
19.
27/6/2019. After the sale, it transpires that the petitioners have then woken up and instituted the suit in OS.
OS number
102 of 2009.
OS 102 of 2019. The
2019. Please.
2019. The concerned court grants a temporary injunction in terms of its order dated 15th February 2020, which is tossed by the defendants before the first appellate court. The first appellate court appears to have taken 3 years to consider the applications filed by the defendants seeking to set aside the order of temporary injunction, and finally does it in terms of its order dated 1/8/2024, after having kept the matter for 1 year without passing any order. The observation of the first appellate court is that the defendants have been handed over possession pursuant to the registered agreement of sale, and therefore the trial court could not have granted a temporary injunction. Since the matter suit is at large and is of the year 2019, to protect and preserve status quo between the parties, I deem it appropriate to direct the concerned court to dispose the suit itself expeditiously, as 6 years have already passed by, and in the interregnum direct the parties to maintain status quo the property, which shall however be subject to the result of the suit.
Much blessed.
With the aforesaid observations, the petition stands disposed.
Much blessed.
7.
Kindly pass on, my lord.
My lord's plaintiff's petition.
Kindly pass on, my lord. Let's check that.
Yeah, no, or what is the order and challenge?
IA for appointment of court commissioner, my lords, which was filed by
whom?
Plaintiff.
You are the defendant.
I am for the plaintiff.
What
My
happened?
IA for appointment of court commissioner was
What's wrong
dismissed.
with that?
Was dismissed, my lords.
Dismissed and yes. At what stage?
After evidence, my lords.
Evidence is still pending, my lord, sir, because there is one more writ petition filed by the very same petitioners. Two petitions are there, my lord.
Number ಕೊಡಿ.
ಇಲ್ಲ, first petition is 27706.
ಎರಡು ಇದೆಯಲ್ಲ ಇಲ್ಲ.
ಎರಡು ಇದೆ.
Adರಲ್ಲಿ one of the application, one of the petition is with regard to recall and reopen, which was allowed by court to lead further evidence of defendant, my lord.
ಆಯ್ತು, we'll see. Pass.
My lord, pass.
Pass over ಇವತ್ತೇನಾಗಲ್ಲ. It's very difficult. We'll see. Pass over ಮಾಡಿರ್ತೀನಿ.
Please.
Next.
8.
ಎಲ್ಲಿ ಅವರ objection? Yes, sir.
My lords, this is regarding the VC.
Video conference.
I found out the schedules, my lords. My lords,
We'll record that and close this, I told last time.
please, my lord.
My lord, there was a direction to, my lord, my learned friend had said that she'll keep the petitioner present in the court, my lord.
Petitioner present? She never said that.
My lord, in the trial court, my lord.
Did you say you'll keep the petitioner present?
My lords, this is
To
the
fix
one.
a date for physical.
My lords, I had initially sought for video conference. The alternate submission I made was that, subject to my learned friend's cooperation and of course the discretion of the court, that he will come physically for evidence.
ಅಲ್ಲೇ physically ಇಲ್ಲಲ್ಲ.
ಇಲ್ಲ.
My lords, my
Yes.
client can be present either in the week of 21st of July or 28th. Then, my lord, your lordships may say that they'll undertake the cross-examination on successive dates without adjournments and close it within a week.
All right.
If the judge is on leave, in-charge court can take it up because that.
We'll observe everything and close it.
Please, my lords, and if they don't cooperate, then VC will be permitted.
That's the result of that will be permission through VC.
Yes.
The petitioner we'll close it then.
Please, my lords.
The petitioner is before this court seeking the following prayer. The heard, the learned counsel Nayantara BG appearing to the petitioner, and what's your name?
Surya S, my lord.
And Surya S representing the respondent. The issue lied in a narrow compass as to whether the petitioner should be permitted to appear through video conferencing for the purpose of cross-examination. The counsel for the respondent had serious objections to allowing the application. Therefore, to give acquietus to the issue, at least for the present, the learned counsel for the petitioner submitted that she would secure instructions with regard to the arrival of the petitioner on the shores of this nation, and has sought instructions that between 21st July and 28th July, the petitioner would be in India, and also request the concerned court to take up the matter for cross-examination between 27th and 28th on day-to-day basis and close the proceedings, close the cross-examination.
Even chief evidence also, evidence of the plaintiff.
Close the examination, both examination chief and cross-examination. The learned counsel appearing for the respondent has no objection for the same. The learned counsel for the objection, in that light, I deem it appropriate to dispose the subject petition, directing that the petitioner shall appear before the concerned court on the 21st of July, 2025, and the concerned court to conclude the examination and cross-examination in the on or before the 26th of July, 2025. It is made clear that the respondent shall cooperate for examination, for cross-examination, as is directed by the concerned court on all those days. It is made clear the concerned court shall not grant any further adjournment to the respondent. In the event there is non-cooperation from the hands of the respondent before the concerned court, the only option would be to record evidence to video conferencing in terms of the rules, in terms of the rules of video conferencing notified by this court.
May I request your lordships may also say that the in-charge court may also take it up.
In the event the regular court is for any reason not holding proceedings on those dates, and the matter is posted before the in-charge court, the in-charge court also shall, the in-charge court shall equally be bound by the observations made in the course of the order. Yes, ordered accordingly. GP holder represent ಮಾಡ್ಬೇಕಾ?
Husband.
Respond ಕೇಳ್ಬೇಕಾಗಿಲ್ವಾ? ಬರ್ಬೇಕಲ್ಲ? Friday ತಗೊಳ್ಳುವ? Yes, list on awaiting the appearance of the KVA to respondent, list the matter on Friday. Yes, next.
Interim order.
Interim order ಇದೆಯಾ? ಹಂಗಾರೆ Monday ಬರಲಿ. We'll dispose it on Monday. Yes, interim order subsisting will continue to the next date of hearing.
10.
My lord, I filed my synopsis, my lord. Synopsis. My lord, suit for bare injunction is filed by the respondent number 1 against, my lord, the other respondents herein. The petitioner, my lord, was not made a party. Now your lordship may kindly turn to the memo, my lord, which was filed.
First, who are you?
My lord, we are, my lord, owners of survey number 2/3B, measuring 1 acres.
Now, order 1 rule 10 application is rejected.
Has been rejected.
Rejected in the execution proceedings. We wanted to enter in the execution proceedings.
Yes, ma'am.
That is why you should show who are you to
Yes,
enter into the.
Yes, ma'am. Now, my lord, the suit, my lord, has been filed. If your lordship may kindly turn to, my lord, the memo which was filed, my lord, in the connected matter, my lords, in 7124, my lord, along with certain documents.
Yes, it is here.
Yes. Now, may I request your lordship kindly turn to page, my lord, 9. Page 9, the suit schedule properties in the order, my lord. Page 8 onwards, they clearly say, my lord, the suit schedule property, they are all the site owners. They say, my lord, site was formed in survey number 2/3D. My lord, in one of the schedules in page 9, they say the site is formed in survey number 2/3D, new number 2/3B. If your lordship may kindly see, my lord.
Yes, I'm seeing.
So, my lord, now I am the owner of survey number 2/3B. In all, my lord, there are 12 suits which was filed. In all the suits, my lord, the schedule which was shown is 2/3D. As far as 2/3D is concerned, my lord, I have no objections at all. The injunction granted, my lord, can go on.
If it is 2/3B, you have.
Because my lord, the suit is filed for 2/3D. But in one of the survey numbers, in one of the suit, they mention the new number has 2/3B.
Otherwise, the suit is, in all these cases, is 2/3D.
3D, for which we have no objection. Now, the suit, my lord, your lordship may kindly see, is only for bare injunction.
Correct.
Is not for a declaration and injunction. Now, my lord, in the suit, I was not made a party. The injunction is against those persons who are there as respondents therein.
2/3D.
2/3D. Now, when after the injunction order has been passed, they, my lord, file an application for police protection. Your lordship may kindly look into the application, my lord, which is at page 155. Page 155 of my memo, my lord. Before that, my lord, may I request your lordship kindly turn to the order, my lord, which was passed, which is at page 34, the final order, page 34, my lord.
Yes, sir.
The defendants or their henchmen or anybody claiming through the defendants are permanently restrained from interfering with the peaceful possession.
All right.
So now what they're trying to say is that we have, that is the petitioners before your lordships, have right over the property through one of the my lord vendors of the respondent. Therefore, we are also permanently, my lord, restrained from interfering with the possession.
Judgment debtors appears to have set you up.
My lord, now your lordship may kindly see, my lord, how I got the title of the property. It is not that, my lord, if your lordship kindly see the
prima
facie, my lord. Now, my lord, it is a sale deed of the year 2000. My lord, the one Venkatappa got the property, my lord, on 27/4/59. This Venkatappa, my lord, sold 1 acre property on 22/12/2004 to, my lord, one Kirti Hasan. This Kirti Hasan, my lord, sells it to V. Nagaraj. My lord, I have stated, my lord, in my synopsis of argument in, my lord, para 2.
Synopsis argument?
Synopsis, my lord, I had filed it. May I give a copy?
Our ಕೊಟ್ಟಿದ್ದಿದೆ ನಿಮ್ದು ಯಾವುದು?
I had filed it in the court, my lord.
ಇದು ನೀವು ಕೊಟ್ಟಿರೋದು ಇದು ನಿಮ್ದಲ್ಲಿ?
ಅಲ್ಲ, court, I had filed it anyway, my lord.
ನಿಮಿಷ. Memo of respondent judgment.
Pass on, my lord.
ಕೊಡಿ. ಇಲ್ಲ. ಟೋಟಲ್ ಕೊಟ್ರೆ ಅವತ್ತು ರಿಜಿಸ್ಟ್ರಿಲ್ ಫೈಲ್ ಮಾಡಿ ಚೆಕ್ ಮಾಡಿ ಮಾಡಿ. Yes.
In paragraph 2, paragraph 2, how, my lord, we have got the property. Though, my lord, it is not a suit for declaration, it is only a suit for bare injunction. Though we are not going into the title. Now, my lord.
No, in some cases, court is permitted.
But, my lord, since, my lord, it is a registered sale deed, since we are not the parties to the suit, I am trying to bring it to the notice of this court. Now, my lord, 27/4/59, Venkatappa, my lord, got the right. Subsequently, my lord, Kirti Hasan, my lord, got it on 22/12/2004. My lord, V. Nagaraj purchased from Kirti Hasan on 1/12/2011. From V. Nagaraj, my lord, we have purchased on 25/2013.
The suit is between whom?
My lord, suit is between the owners of survey number 2/3D and, my lord, the respondent number 1, who claims, my lord, he has purchased the site, purchased one of the sites, because there are 12 sites. They say, my lord.
These 12 petitions of each site.
Each site.
All right.
Now, my lord, we have got the land converted.
When did he purchase it?
In 2014. We have purchased, my lord, in 20. My lord, he has purchased earlier, but 92. But the suit is filed in 2014. My lord, and the sites have been purchased from by the GP holder. Therefore, my lord, the suit, though it is filed in 2014, we, my lord, have purchased.
You are the subsequent purchase.
Exactly. My lord, the question would be, my lord, that the court has to, my lord, say whether this is the same property. The identity of the property is in dispute. When the identity of the property is in dispute, they have to, my lord, should have made us a party. Now, my lord, a cohesive decree has been obtained.
Collusive decree.
My lord, the respondent number 1 and 2 were placed ex parte in the suit for bare injunction. My lord, therefore, my lord, now, since I have a right over the property by way of a registered sale deed, and the suit, my lord, is only in respect of survey number 2/3B through 2/3D. Therefore, my lord, I filed an application for impleading. Now, if your lordship may kindly turn to the Application, my lord, filed by them.
Filed by them.
Filed by them, my lord, page 155.
Advan rule 10 ಹಾಕಿರೋದು ಯಾರು?
ಅಲ್ಲ ನಾನು ಹಾಕಿರೋದು ಅಲ್ಲ filed by them for police protection.
Police protection.
Page 155.
That is to enforce execution.
Execution. If they are in possession of the property, page 155 might be kindly be seen, my lord. Page 155.
Of the compilation?
Yes, after. Yes, my lord. Document number 16. 155.
Yes.
My lord, the affidavit, page 156. Pleased to pass an order, provide police protection to the decree holder for implementing, enforcing the judgment and decree passed in so and so. My lord, next page, last two lines, your lordship may kindly see. Since the judgment debtors and persons claiming under them are continuing to violate the judgment and decree of this honorable court by changing the number of the property and its boundaries and transferring the property, such transfers made without title to the property is resulting in multiplicity of the proceedings.
Yes, sir.
Now,
what is the date of the suit?
My lord, it is in 2014, my lord.
No.
2004. Sorry, my lord.
Execution in 2015 and 2004. So what is
Yes, my lord.
See, 2004 suit. When did you purchase?
My lord, in 2013, 25/2013.
ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ. To your peril you
My lord, the first execution. I will show the order of the first execution.
My lord, now the question would be whether this is the same property or not. Now, my lord, it is in a execution proceedings. They want to, my lord, if they are in possession.
Judgment debtors will set up such defense. Can't
Lord,
help.
it is, my lord, we are bona fide purchase of the property because there are 3 sale deeds much prior to that. If your lordship, as I stated earlier, my lord, one in 2004, one in 2011, one in, my lord, 2013. My lord, we, my lord, have got the property
all after the decree.
My lord, decree, my lord, is in respect of survey number 2/3D.
Where is the decree? Decree admali you applied for correction?
No, it is not done.
My lord,
That is new number.
New number. My lord, we obtain an injunction against Venkatappa and his family members.
Correct.
My lord, after the decree is passed, my lord, they change the number and sell it to them. My lord, first round of execution, my lord, they are imprisoned, sent to civil prison.
They are Venkatappa and others.
Although they would come before this court. This court takes a lenient view and say, okay, we let you off. My lord, please see that order.
Page?
My lord, that order, my lords will get it, page number 201. In our compilation, my lord.
You nimdondu compilation is it?
Howದು documents ಇದು 7124 ಅಲ್ಲೇ.
ನಿಮ್ದೇನು convenience compilation inconvenience compilation ಅವ್ರಿಗೆ
inconvenience to the other side, convenience to the court.
Yes.
There, my lord, page number 201, earlier round, my lord, they are imprisoned. My lord, the court, my lord, takes a liberal view, my lord, and my lord
lets them off.
2 months after this order, my lord, they sell it to these persons.
Should not have been let off. Yes.
2 months, my lord, I have produced this next sale deed. Just 2 months after the Honorable High Court, my lord, passes the order at page number.
Where is your list of documents?
Yes, my lord. Yes, my lord. Please take, my lord, 201. The order's date, my lord, is 1st of February 2013.
Yes.
Now, please take, my lord, page number 208, para 3. Learned trial judge ordered for committing the petitioner to civil prison for committing acts of willful disobedience. This whole, my lord, then, my lord, they are let off. Page number 210.
10,000 fine impose
ಮಾಡಿಬಿಟ್ಟು Then please see 211, my lord. 20th of May 2013.
ತಕ್ಷಣ ಕ್ರಯ ಪತ್ರ.
These very same, my lord, petitioners. These very same petitioners, my lord, purchase it from Venkatappa and family. That is first aspect, my lord. Now, ultimately, their intention is to grab the property. What they would do is, my lord, they would institute a comprehensive suit. My lord, in 86-78 of 2014.
They are Venkatappa and family.
Illa, alli, both the parties to maintain status quo anta agate. They get an ex parte order where they are also.
I will submit, my lord. I have not yet finished. I have not yet finished.
No, I wanted some clarification. Yes.
Now, my lord, if your lordship may kindly turn to the order, my lord, which was passed, page 18. In the order, my lord, dated 21st July 2007. There is, my lord, discussion about the survey number 2/3D and 2/3B also. And the court has given a clear finding, my lord.
2007 da.
2007 order ಅಲ್ಲಿ. Page 90, page 18 and 19, if your lordship kindly sees.
Natarajan.
Natarajan.
Yes.
My lord, paragraph 8, last paragraph, page 18. The exhibit D1 is the general power of attorney executed by defendants in favor of PW8. He also admitted there was no conversion order in the land in survey number 2/3D. He also admitted that he has not mentioned survey number 2/3D in the sale deeds. The lordship got it, my lord?
Yes, sir.
Sale deeds executed by him and he also further admits that since he has not stated the survey numbers in the sale deed due to the ban on the registration of agricultural lands by the government, he also submits that there was no layout plan approved by the deputy commissioner or the corporation authorities, but he has stated that the layout plan was approved by the village panchayat, but admits that he has not produced the layout plan before this court. Now, my lord, on 5 lines subsequent to that, on the other hand, the contentions of the defendant is that the land in survey number 2/3D now changed to 2/3D.
Who defendant was Venkatappa.
Venkatappa, my
Venkatappa
lord,
and family.
And family.
One of the family members of
Plaintiffs
Venkatappa.
Bureau.
Plaintiffs.
It is decreed. Come to page 34, 35. On the reasons would be from paragraph 12, 33, 34.
27, page 27, their contention is negative, that there is a change in survey number. That is negative.
Allah, that is what I want to show, that there is, my lord, the survey number negative, that is what I wanted to show. My lord, he was aware, now page 32, if your lordship may kindly see, he is aware, my lord, if your lordship may kindly see one paragraph. Or the,
What happened to this decree?
My lord, this has become final.
Final.
RFA haki final.
RFA haki final.
RFA.
Dismiss ಆಗಿದೆ.
RFA dismiss
Produce
ಆಯ್ತಾ?
ಮಾಡಿ.
My lord, Venkatappa family, it is not us, my lord, we are not the parties at all.
ನೀವು ಆಗಕ್ ಸಾಧ್ಯವೇ
ಆಗೋದೇ
ಇಲ್ಲ.
ಇಲ್ಲ. No, my lord,
Suit is
we are,
between Venkatappa and them.
my lord, my only submission is, since the suit for bare injunction is only against survey number 2/3D, now, my lord, with the help of police, they cannot come and take possession of survey number 2/3B. Because, my lord, the suit, the order is only against the defendants therein, it cannot be against anyone else.
Correct. 2/3B is Venkatappa's.
2/3B was Venkatappa's earlier. He has other survey numbers also. He has other survey numbers
Crux
also.
of the matter.
Now, my lord,
2/3B is Venkatappa is wanting to retain 2/3B.
my lord, it is a register. 4 sale deeds have occurred after 1959. And the land is converted.
Then water has not flown after that.
My lord, land has been converted. We have purchased a converted land. Where, my lord, while conversion, there is a survey done.
That's why I said, after the decree we have purchased it.
My lord,
at
the
your
question
own
would be,
peril, what can be
therefore,
done?
my lord, I submitted, it was not a suit for declaration, it was a suit for bare injunction. Now, my lord, when a conversion has been done, there was a survey done.
There is no finding on title at all. It's only injunction.
Now, my lord, therefore, when there is a suit for bare injunction in respect of survey number 2/3D, they, my lord, now cannot say that injunction is against us also, and they, with the help of police, they cannot come and take possession of the property. Because we are in possession, as far as survey number 2/3B is concerned. Now, may I request your lordship to kindly turn to the OS which was filed by us, my lord, page 92. Page 92.
C suit.
Comprehensive suit.
The C suit. Yes.
92, my lord. A suit was filed by us for declaration and injunction. Now, page 94, if lordship may kindly see, we were represented by, my lord, our GPA holder, one BV Pramod. This suit, my lord, after an ex parte status quo order was passed, subsequently the respondents appeared, the respondents herein appeared.
What happened to the dismissal of this suit?
My lord, that suit, my lord, there was a status quo order which was pending.
But dismiss aitala.
Allah, then that was withdrawn by the general power of attorney holder. Therefore, my lord, we have filed without.
It is dismissed as withdrawn.
Dismissed as withdrawn by the general power of attorney holder of the petitioners herein. Therefore, my lord, we have filed a miscellaneous petition which is pending to recall that order, because a fraud was played on us. Because when there was a status quo order, they do not do anything about the execution. Now, my lord, this is withdrawn by the.
Where is the MA?
My lord, we have filed a miscellaneous petition, my lord, which is.
Elli. Page.
I will, my lord, I will just. Page 123, my lord.
You have filed a miscellaneous petition?
Yes, my lord.
In 6 years after the.
My lord, My lord, my lord, this order was passed, if your lordship may
On
kindly see,
31st January 2017.
on my lord 16/12/2022, my lord,
Where is that order?
page 122.
ಏನು withdraw ಮಾಡಿರೋದಾ?
Yes, my lord. Case advanced on today's board, the counsel for the plaintiff files a memo for withdrawal of the suit. The counsel for defendant so and so is
So what is
present.
this 92 page?
Page 92, my lord. My lord, that was the interim order of status quo. Then, my lord, that was a subsequently confirmation of status quo order. This is, my lord, the 92 is a status quo, my lord, which
is withdrawn later.
Yes, my lord, this was withdrawn in page 122 on, my lord, 16/12/2022.
All right.
After 7 years, my lord, it was withdrawn. My lord, our contention was the GP holder, my lord, without authority had, my lord, withdrawn it. Therefore, we have filed a miscellaneous petition immediately, and that is, my lord, pending for consideration. Now, my lord, notice has been served there. There we have sought for a stay. My lord, since the notice is not yet, my lord, served to some of them, the matter is being adjourned. Therefore, my lord, we have filed a suit for declaration, comprehensive suit for declaration and injunction.
Which is withdrawn.
Which is withdrawn by the general power of attorney by, my lord, fraud with collusion with the respondents herein.
Oh, what have you done to that GPA holder?
My lord, we have, my lord, first filed an application for recalling this.
ಅಲ್ಲ ಅದು ಬಿಟ್ಟು ಏನ್ ಮಾಡಿದ್ದೀರಾ?
ಅದು ಬಿಟ್ಟು ಏನು ಮಾಡಿರಲಿಲ್ಲ. Now, my lord, in fact, they file a criminal case against us, saying that, my lord, we are trying to interfere with the possession of the
Charge
property.
sheet is filed in that.
Where your lordship,
And
my
I
lord,
have
have.
directed now the observations in column number 17 of the charge sheet should not be relied on by the civil court.
Yes, my lord.
ಅದೇ matter ತಾನೇ ಇದು?
Yes.
Yes. Sir.
Lord, please notice the dates, my lord.
Now, my lord, if my lord, if for a reason, if the miscellaneous petition is ordered, my lord, if I am able to succeed that, if I am able to show to the court.
Very bleak.
My lord, that is up to the court there, my lord. Now, my lord, therefore, my lord, my only submission before your lordship is, let the decree, my lord, which is passed, is only in respect of 2/3D. Let them. They cannot, my lord, in the guests of the decree obtained in 2/3D, come and, my lord, take possession in 2/3B. When it is a suit for bare injunction, not even a suit for declaration. Now, my lord.
ಇದಕ್ಕೆ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅನ್ನೋ ಒಂದು ಪ್ರೊಸೀಡಿಂಗ್ ಇದ್ರೆ ಇವೆಲ್ಲ ಬರೋದು.
ಅಲ್ಲ ಸರ್ವೇನ
ಆದ್ಮೇಲೆ ಅಲ್ಲೇ ಆಗುತ್ತೆ ಅಂದ್ರೆ ಏನು ಆಗಲ್ಲ.
My lord, the known source of, my lord, how to execute, my lord, a suit for bare injunction, your lordship may kindly turn to.
PD, FDP.
Allah, order 21, rule 32. What is the procedure, your lordship may kindly see? It is not by way of filing an application for police protection, then going in a suit for injunction. Their case is there in possession. Now they cannot come and say, give me possession and police protection, but they cannot.
Police protection, give me possession ಅಂತ ಕೇಳ್ತಾ ಇಲ್ಲ, protect our possession ಅಂತ.
Allah, it is an indirect way of.
ಅಲ್ಲ, give me protection ಅಂತ police ಕೇಳ್ತಾರ. Give me possession ಅಂತ.
Allah, they have filed an
Possession
application.
protect ಮಾಡಿ ಅಂತ ಕೇಳಿದ್ರು. Police protection is for that. How do you say that give me possession ಅಂತ ಕೇಳ್ತಿದ್ದಾರೆ ಅಂತ ಅವರಿಂದ?
My lord, now, my lord, admittedly.
Which decree holder whose possession in a suit is confirmed and that is sought to be enforced in execution will tell the police, get me possession.
My lord, now, my lord, this is just an impleading application which has been filed. I have to, my lord, show that I have some right over the property where an injunction is being passed or where there is an execution, my lord, which is pending. Now, my lord, in their schedule itself, it clearly says new survey number 2/3B. In their schedule itself.
Will hear it.
Lord, the earlier suit, my lord, was for comprehensive suit.
ಯಾರ್ದು?
Our Hakkidu. There was an order of status quo.
Correct.
That is withdrawn on 16th of December 2022.
Correct.
Because there's a status quo binding on them. They wanted to forcefully enter. The day after that, my lord, they forcefully enter, which is why an FIR is filed. Yes, my lord, 18th of December. So therefore, my lord.
And 427, 447 crime charge sheet is also filed.
Yes, my lord. So therefore, my lord, it is not a case where, my lord, the GP holder withdraws it and they are, my lord, cheated. It is done, my lord, intentionally because, my lord, winter vacation is approaching. Please. So avaga nuggana anta nuggtare FIR agate, which is why, my lord, in the earlier round, my lord,
injunction ತಗೊಂಡ್ಬಿಟ್ಟು they file a complaint.
ಆಯ್ತು ಇರ್ಲಿ.
And then, my lord, in February they file an objector application because there is an FIR. Objector application is dismissed. They would come before this court. This court says in an injunction suit there cannot be any objector application at all, and therefore they would say, I will work out my remedies in the miscellaneous. After having said so, the very same application, my lord, old while in new bottle, they come and say, my lord, I want to implead myself. That is rejected.
Yes, sir. ಅಷ್ಟೇನಾ? Order is out.
Grateful. I've also filed.
ಇಲ್ಲ, ಇದನ್ನ ಬರೇ ಮಧ್ಯಾಹ್ನ ಆಗೋಗ್ಬಿಡುತ್ತೆ.
Because, my lord, the facts are.
Will answer this. No. ಹಾಕಿದಿರಲ್ಲ ಎಲ್ಲ?
ಹಾಕಿದ್ದೀನಿ, ಎಲ್ಲ ಹಾಕಿ. ತುಂಬಾ ಡೀಟೇಲ್ ಆಗತ್ತೆ, ಅದಕ್ಕೆ ತಾವು ಮಾಡಿದ್ ಬೆಸ್ಟ್ ಅಂತ.
ಏನ್ನ
ರಿಸರ್ವ್ ಮಾಡಿದ್ದು ಇಲ್ಲ ಅಂತ
ಇಲ್ಲ, ಡಿಬೇಟ್ ಮಾಡಕ್ ಸಾಯಂಕಾಲ ಆಗತ್ತಮ್ಮ.
ಕನ್ಸ್ಯೂಮ್ ದಿ ಟೈಮ್ ಆಫ್ ದಿ ಕೋರ್ಟ್. Grateful.
Yes. All connected matter, same, different sites, same facts alva.
Same facts.
ಎಲ್ಲದರಲ್ಲೂ 3B, 3D.
Only in 3 matters, they are not on record. Otherwise, notice issue ಆಗಿರ್ಲಿಲ್ಲ. In trial court also none appeared. Only
ಎಲ್ಲ 3D ಲೇ ಕಾಣ್ತಾ ಇದೆ. Yes. Next.
11.
In one of the execution proceedings, my lord, we are made a party. In one of the execution proceedings.
Why?
My lord, the decree holder have made us a party. So that clearly also shows.
Why one of the execution proceedings?
We are not representing them. Yaro innobba advocate iddo, they have made them a party, but then that.
So that clearly shows, my lord, if I may.
That is not the subject matter of the writ petition.
Writ petitions ಯಾವುದು
ಇರ್ಲಿ, ಕೊಡಿ ಪರವಾಗಿಲ್ಲ.
That's not the subject matter of the writ petition.
Ahala, it is the same order, same judgment, where, my lord, we have been made a party in one of the execution proceedings.
ಅವರೇ ಯಾರು
ನಾನು ಹಾಕಿರೋದಲ್ಲ, ಡಿಗ್ರಿ ಹೋಲ್ಡರ್ ಹಾಕಿರೋದು.
Venkatappa wants the property still.
No, we are, my lord, in fact, my lord, if I may say, we are bona fide purchasers of the property. One of them is a well-known sign actor also in this.
First petitioner.
Oh, sir. First petitioner.
First petitioner, my lord, before your lordship.
All right.
He wants to show his, my lord, movie.
No, that is what, my lord, they said in the settlement also. Since he is a superstar, we will not do it. They are, my lord, their demand is much more than whatever is the property. We have, my lord, paid more than 3 crores in the sale deed.
Superstar.
Superstar ಆಗಿದ್ರೆ law is the same.
ಅದಕ್ಕೆ ಹೇಳಿದ್ದು.
We have, my lord, by checks, my lord, we have paid more than 3 crores.
I will see. Yes.
We have no objection for him to recover it from Venkatappa with interest.
My lord,
For the
senior is
petitioner, my
engaged. Senior is engaged in court call number 6.
My lord, on
Kindly
the
pass
last
out.
occasion also.
Senior is engaged in court call number 6. Man, kindly pass out.
Engaged.
My lord, on the last
That's
occasion.
lieutenant.
On the, yes, my lord.
Yes, court call number 6 is
Nothing,
engaged.
sir. I have heard you completely.
Yes, my lords.
My lord,
No further adjournment. Passover ಕೇಳ್ತಾ ಇದೆ.
pass out.
Passover is not adjournment, but it's indirect. Reach ಆಗಲ್ಲ. ನೋಡೋಣ, we'll see. Yes.
12.
I'll take it at 2:30. ಯಾವುದು? 2:30 ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ I will pass orders. ನಿಮ್ಗೆ ಹೇಳ್ತಿರೋದು.
The matter was.
Serial number 12. ಅಲ್ಲಿ 12 ಇದೆಯೋ ಬೇಕೋ ಬೇಡವೋ ಅಂತ ಅಷ್ಟೇ.
ಹೌದು.
Yes, sir. Dhanbad and Patil Engineering. Yes, ಕೊಡಿ ಮೇಡಮ್. ಇದು ಅಷ್ಟೇ, I have heard you all.
Please.
ಆಯ್ತು. But stay ಏನು ಕೊಟ್ಟಿಲ್ಲ, heard reserve. ಏನಿದೆ ಕೊಡಿ, ಜಡ್ಮೆಂಟ್ ಕೊಡಿ.
ಅಲ್ಲ
ಒಂದು power of attorney, my lord.
authorization letter ಬೋದು.
Authorization letter was given by the erstwhile owner, husband of the plaintiff, to look after the entire property.
ಅದಕ್ಕೂ 12 ಏನು ಸಂಬಂಧ?
Please.
Yes.
Para 63.
Whether it should precede mediation or not, ಅಷ್ಟೇ issue. Yes. Next.
13.
Heard sound. General counsel ಅಂತೆಲ್ಲ.
It is posted on 24th for mediation.
ತುಂಬಾ ದೂರ ಆಯ್ತು. ಅಲ್ಲಿವರೆಗೆ ಇಟ್ಕೊಳಲ್ಲ ನಾವು.
One submission. Lord, the mediation which is referred by the civil court, Lord, it has been, the report has been sent to civil court saying that it has been failed. Twice they have not.
Let's see, I will
after
answer
notice,
it.
they have not appeared.
That's all right. Yes, next.
And ex-careers case, my lord, says, my lord, there should.
It's only jugglery of judgments, we'll see. Yes.
My lord, may I pass on one more judgment?
ಕೊಡಿ sir.
Yes, Not one is Patil automation case.
Patil ಇದೆ ಸರ್, ಆಮೇಲೆ.
ಇನ್ನೊಂದು ex-career But I will furnish, my lord. Wherein it says, my lord, when a plaint is rejected, sorry, plaint is returned, there should be a de novo inquiry. If that were to be
Not
taken.
objecting that. We are not objecting, you know, inquiry.
But our main contention is in view of Dhanabad, my lord,
No, ಅದು 12A ಕಳಿಸಿ ವಾಪಸ್ ಬಂದ್ಮೇಲೆ it should proceed de novo ಅಂತ ಹೇಳಿ. We will answer that, yes.
I will furnish.
We have no objection for that. It's a procedure directed to the court. We'll do that only. Then we'll close it on that. Why answer everything?
ಧನವಾದ ಕೇಸನ್ನ ಪ್ಯಾರ 63C ಅಪ್ಲೈ ಮಾಡಿದರೆ, my lord, it is suit is instituted subsequent to the amendment. Therefore,
I will answer.
Please.
13.
For respondent. Amendment application.
Order 6 Rule 17.
Please, my lord, that has been allowed.
For the respondent number 4, my lords. Respondent number 4 is undergoing CIRP, my lords. I am the interim resolution professional appointed insofar as that is concerned. Because my submission is this writ petition, in fact, has been filed after the institution of moratorium, my lords. Both the writ petition and the trial court proceedings, my lords, cannot be proceeded further due to the
Moratorium.
Yes, my lords. My lords, may I just pass on the admission order, my lord?
No, filing, going before the NCLT and NCLT directing or the automatic moratorium that ensues after NCLT's proceedings would arrest all civil suits?
Yes, my lords. My lords, the main reason I'm making this submission is because the partition suit that has been filed at the trial court, my lords, it comes out of one particular part of land which I have developmental rights over. That is specifically part
That is before the NCLT.
Yes, my lords. In fact, my lords, the petitioner has even filed a necessary application before the Honorable NCLT. That is also pending adjudication. Therefore, my lords, all the proceedings in the trial court and the before your
What is under challenge now?
My lords, this
Amendment application was preferred by challenging the release deed, which was executed by herself. Since I had taken that defense in the suit.
That particular property is subject matter before the NCLT?
Yes, my lords.
Yes, sir. You agitate everything there, or will this will get arrested till the proceedings are there?
Plus, there is already an application pending on their behalf in the NCLT.
The petitioner is before this court seeking, calling in question an order dated 17/1/2025, whereby an application filed under Order 6 Rule 17 by the, you are the plaintiff, huh?
I'm the plaintiff.
By the plaintiff comes to be allowed. The learned counsel appearing for the plaintiff would submit that the subject matter of the property that is now subject matter of this suit, hyphen the property.
Defendant number 4 in the proceedings.
Defendant number 4. You are the
Yes,
RP.
IRP.
The counsel appearing for the respondent number 4, the resolution professional.
Interim resolution professional.
Interim, yes. Correct. CIRP is that. Yes. Interim resolution professional submits that by virtue of the proceedings pending before the NCLT, the civil suits on the same on the subject matter of the property, which is the subject matter of NCLT, will automatically get arrested. In that light, the subject petition would not become entertainable, more so in the fact that an application filed by the petitioners against the moratorium.
Well, it's not against the moratorium. They're seeking to keep that specific land outside the scope of CIRP.
More so in the light of the fact that the petitioners have themselves preferred a petition, an application before the concerned court to keep before the NCLT or court?
NCLT.
Before the NCLT, to keep the subject property away from the proceedings before the NCLT. Therefore, reserving liberty to the petitioner to avail of all remedy available in law without interfering with the order passed by the concerned court. On the aforesaid reasons, the petition stands disposed.
The suit is being proceeded with by the trial court.
That you file necessary application. Yes.
Can it be kept pending? This writ petition kept pending.
No.
Pending disposal of this.
Which one?
This writ petition.
No. Yes. Next.
I'm obliged.
Here before the NCLT will not interfere. Yes. Next.
I'm obliged. Copy.
Yes.
Yesterday's.
Dead person.
Dead person.
Actually, that document, my lord, which you produced, the death certificate, was procured by the police from, my lord, during the investigation. In the
Nanjareddy sir.
I am filing this. First, court of.
ಎಸ್ ಇನ್ನೇನಾದ್ರೂ ಇದೆಯಾ?
ಇದು ಜಾಸ್ತಿ ಇದೆ.
ಹೌದಾ? ಇದ್ರಲ್ಲಿ ತುಂಬಾ ಇದೆ, ಅದ್ರಲ್ಲಿ ಸೂಟಲ್ ಮಾಡ್ಕೊಳ್ಳಿ.
ಇಲ್ಲ, ಸಿಂಪಲ್ ಅಲ್ಲಿ
ಎಸ್ ಸರ್.
Last may kindly see.
Liberty be reserved to revive the section in case of the disposal.
All liberty will answer, will observe that. No, yes.
To revive the section.
Yes.
But in this case, the suit, the suit for filed by the plaintiff.
Mike tawadi.
Mike. A plaintiff suit, the trial court granted an order of temporary injunction restraining the defendants from alienating the property. That page last we go to. Paragraph 23, trial court judgment.
First appellate court has reversed it.
Houdu.
Yes, sir.
Page 62, you lost me. Page 62. Reason why I am saying, sir.
Yes.
Regarding alienation, the plaintiff has alleged that on the basis of created documents by the first defendant, he is trying to alienate the suit schedule property in favor of the second defendant. It is further alleged that the first, either yakandre, why I am submitting blood.
In contentions act.
Allala, he has no locus standi at all.
Contentions finding ಹೇಳಿಸಿ.
Allala, ಅದಕ್ಕೆ ಹೇಳಿದೆ.
On your contentions, TI was granted.
ಹೌದು. ಅಲ್ಲ ಇವರು ಅವ್ರದ್ದು ಅದು ದಟ್ ಆಲ್ಸೋ ಅನೇಕ ಪೇಜ್ 20 ಪ್ಯಾರಾ 22 ಅಲ್ಲಿ ಹೇಳಿದೆ ನೋಡಿ ಸರ್. ಫರ್ದರ್ ಆನ್ ಪೆರಿಸಲ್ ಆಫ್ ವಿಲ್ ಡೇಟೆಡ್ 21/4/1980 ಅವ್ರ ವಿಲ್ ದೇ ಕ್ರಿಯೇಟೆಡ್ ದಿ ವಿಲ್ ಮಿಲಾಡ್. 80 ಅಲ್ಲ 80 ವಿಲ್ ಇದ್ರೆ ನಮ್ದು ವಿಲ್ ಮೇಲೆ ಹ್ಯಾವ್ ಮಿಲಾಡ್ ಪ್ರೊಸೀಡೆಡ್ ಮಿಲಾಡ್ ದಿ ದೇರ್ ವಾಸ್ ನೋ ಲ್ಯಾಂಡ್ ಅವೈಲಬಲ್ ಅಟ್ ಆಲ್ ಆಸ್ ಆನ್ ದಿ ಡೇಟ್ ಆಫ್ ದಿ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಆಫ್ ದಿ ವಿಲ್. ಯು ಲಾಸ್ಟ್ ಇಟ್ ಬೈ ಕೈಂಡ್ಸ್ ದಿ ಲ್ಯಾಂಡ್
ಅವೈಲಬಿಲಿಟಿ ಇರಲ್ಲ, ಇಟ್ ವಾಸ್ ಇನ್ ಲಿಂಬೋ, ಆಮೇಲೆ ಬಂದಿದೆ ಆಚೆಗೆ ಅಷ್ಟೇ.
ಅಲ್ಲಲ್ಲ ಪ್ರಾಪರ್ಟಿ ಇಲ್ಲ ಅಂದ್ರೆ ವಿಲ್ ಎಲ್ಲಿ ಬರುತ್ತೆ? Annexure F, you lost my kindly go just you lost my kind. Page 85.
Yes, sir.
85.
ಇದ್ರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ? ಇಲ್ಲಲ್ಲ,
ಎಂಟ್ರಿ ಮಾಡಿಲ್ಲ.
ಅದು ಏನಾದ್ರು ಕೊಟ್ಬಿಟ್ಟಿದೀವ. ಎಸ್.
ಅದರಲ್ಲಿ you lost my kind based on the GP executed by Meher Mehta, ಪ್ರತಿವಾದಿಗಳು. This land was forfeited, 64 acres was there in her favor. 58. Every land was forfeited, or the land. I fought as the GP holder. You last kindly see. Avaga, if the GP, that is will, if it was there, 1980, you could have challenged all these proceedings. But I only participated in all these proceedings and got the
land ನಿಮಗೆ ತಾನೇ ಬೇಕಾಗಿರೋದು.
ಹೌದು.
ಮತ್ತೆ
ಆಮೇಲೆ ಏನ್ ಮಾಡಿದೆ, ಆಫ್ಟರ್ ಓನ್ಲಿ 4 acres 15 ಗುಂಟಾಸ್ ಮಾತ್ರ ರಿಲೀಸ್ ಆಗಿದೆ. ರೆಸ್ಟ್ ಆಫ್ ದಿ ಲ್ಯಾಂಡ್ ಮೇಲೆ ಪರ್ಮಿಟೆಡ್ ಅಂಡರ್ ಸೆಕ್ಷನ್ 66 ಆಫ್ ದಿ ಕರ್ನಾಟಕ ಲ್ಯಾಂಡ್ ರಿಫಾರ್ಮ್ಸ್ ಆಕ್ಟ್. ಸೊ ದಟ್ ಇದಾದ್ಮೇಲೆ ಅವ್ರು ಕ್ರಿಯೇಟ್ ಮಾಡ್ಕೊಂಡು ದೇ ಹ್ಯಾವ್ ಕಮ್ ಪರ್ಮನೆಂಟ್ ಅಂಡ್ ಕ್ರಿಯೇಟೆಡ್ ದಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್. ನೆಕ್ಸ್ಟ್ annexure.
ಸರ್,
annexure G.
ಸಿಂಪಲ್ ಕ್ವೆಶ್ಚನ್ ಕೇಳಿದೆ. ಯು ಆರ್ ಬೇಸಿಂಗ್ ಯುವರ್ ರೈಟ್ ಅಪಾನ್ ಎ ಜನರಲ್ ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ.
ಹೌದು.
ಆಲ್ ರೈಟ್. General power of attorney which is executed in the month of March 2007 of a person who had died in 1999.
It is yet to be proved. It is no last kindly say
prima facie documents
with good faith it is said it was registered. Yes, unless that
came and executed the documents.
GP holder only. GP holder only executed. ಅದಕ್ಕೆ ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೆ. I lost my kindly.
ಅವರು 99ರಲ್ಲಿ ಸತ್ತೋಗಿರೋರು 7 ಬಂದು ನಿಮಗೆ GP ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿ ಮತ್ತೆ ಹೋಗ್ಬಿಟ್ಟು.
ಇಲ್ಲ ಅದೇ GP 98 GP ನೇ I am saying blood. GP 98 ಇದೆ. blood for
ಅದಿದೆಯಲ್ಲ ಆಸ್ಮಾನ್ ಸೆ ಆಯ ಫರಿಶ್.
ಹೌದು ಅಲ್ಲ ಈ ಡಾಕ್ಯುಮೆಂಟ್ you lost my kindly.
Yes sir.
ಡಾಕ್ಯುಮೆಂಟ್
ಈ ಕೊಟ್ರಾ?
ಕೊಟ್ಟಿದ್ದೀನಿ.
ಮೆಮೊ ತೆಲುಗುಲಿ ಇದೆ. ನಿಮಗೆ ಗೊತ್ತಾಗುತ್ತೆ, ನಮಗೆ
ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಮಾಡಿದ್ದೀನಿ.
ಮಾಡಿದ್ದೆ.
With regard to the above subject, is here confirmed that the so and so Hyderabad has made request to provide, that is the legal air certificate our he has produced. When I applied for, it is not there. They have created. So therefore, our legal hair alla. ಅವ್ರು ಹೇಳೋದು you last my kindly see even ಅವ್ರು ಪ್ರೊಡ್ಯೂಸ್ ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರಕಾರನೇ
ಅದೆಲ್ಲ ತೀರ್ಮಾನ ಆಗ್ಲಿ ಬಿಡಿ, ಇದು
ಅದೇ
temporary
ಅದೇ
injunction
ತೀರ್ಮಾನ ಆಗಲಿ.
ಅಷ್ಟೇ.
That is the status quo
Let the
maintained.
suit be decided.
Yes, that
Prima facie, the right flows in favor of the respondent, will confirm the order of the first appellate court and direct the court to conclude it.
ಇಲ್ಲ ಫಸ್ಟ್ ಅಪ್ ಅಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಗ್ರಾಂಟೆಡ್ ಇಂಜಂಕ್ಷನ್.
ಅದನ್ನೇ ಹೇಳಿದ್, ಫಸ್ಟ್ appellate court has reversed it.
ಈಗ ನಾವು ನಾಟ್ ಟು ಎಲಿನೇಟ್, ಐ ಆಮ್ ನಾಟ್ ಸೀಕಿಂಗ್ ಫಾರ್ ಇಂಜಂಕ್ಷನ್, ನಾಟ್ ಟು ದಿಸ್ ಪರ್ಸನ್. ಸ್ಟೇಟಸ್ ಕೋರ್ಟ್ ಟು ಬಿ ಮೇಂಟೈನ್. ದಟ್ಸ್ ಆಲ್.
ಕೋನು ಇಲ್ಲ.
ಅದರ್ವೈಸ್ ದಿಸ್ ಬಿಕಮ್ ಮಿಲಡ್.
ಏನು ಆಗಲ್ಲ. If I grant status quo, I will be putting a premium on that Aya, Gaya. Yes. As simple as that.
Then you lost notice to second respondent.
ಅವ್ರು ಯಾರು?
ಅವರು is the purchaser.
ಅದು ನೀವು ಎಂಟರ್ಟೈನ್ ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ ನೋಟಿಸ್ ಕೊಡ್ಬೇಕು.
That is cancelled. That can't be. That's
ಅಲ್ಲ ನೋಡಿ,
agreement to sell is cancelled.
ಅಲ್ಲ ಈ ಮಾಡಿ ಇಂದ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. You lost my kind conduct.
ఏం లేదు సార్.
ఉంది దానికోసం.
ఏం లేదు. ఇంకేముంది, ఏం లేదు. Yes.
The trial court has sorry apply first appellate court.
ಇಷ್ಟೇ ಸರ್ ಈ ಆನ್ಸರ್. 99 ಅಲ್ಲಿ ಸತ್ತೋರು 2007 ಗೆ ನಿಮ್ಗೆ ಯಾವಾಗ ಕೊಟ್ಟು?
Is yet to be proved, my lord.
Prima facie. Yet to be, I'm not saying it is confirmed.
Even the trial
Prima
court also
facie
says,
to be proved.
No.
So he is right.
Even otherwise, what is the locus standi of the second?
But you filed the suit against me. I didn't file the suit.
You are the plaintiff.
Injunction.
I guess you are the plaintiff. ಮತ್ತೆ sir.
I am the plaintiff.
ಲೋಕಸ್ ಅವ್ರದ್ದು ಕೇಳಿದಾರ, ಡಿಫೆಂಡ್ ಮಾಡ್ಕೊಳ್ಳೇಬಾರ್ದು.
To challenge before the first appellate court, what is his locus standi?
So I should accept an injunction and say I'm bound by this.
ಹೌದು.
ಅಲ್ಲ, ಇಂಜಂಕ್ಷನ್ ನಿಮ್ ಫೇವರ್, ಅವರು ಡಿಫೆಂಡೆಂಟ್. ಯು ಸೆಕ್ಯೂರ್ ಅನ್ ಇಂಜಂಕ್ಷನ್ ಅಗೇನ್ಸ್ಟ್ ದೆಮ್. ಅವ್ರಿಗೆ ಲೋಕಸ್ ಇಲ್ವಾ ಚಾಲೆಂಜ್ ಮಾಡಕ್ಕೆ?
ಅಲ್ಲಲ್ಲ, locus on the ground,
whatever ground, he is the defendant who has suffered an order.
Therefore,
does not have locus to challenge an appeal, file an appeal.
ಅಲ್ಲ, to preserve the property as it is, let the status quo.
ಅಂದ್ರೆ ಅವರು ಅಪೀಲ್, ಡಿಫೆಂಡೆಂಟ್ಸ್ ಅಪೀಲ್ ಹಾಕಬಾರ್ದು.
ಹಾಕೊಳ್ಳಿ, ಬಟ್
FIR ಆಗಬಾರದು.
ಇದು ಇರ್ಲಿ, ನೋ ಪ್ರಾಬ್ಲಮ್.
So we have no locus standi.
If that is the case, let the Millard be interest be protected, not in respect of.
I think it's time for lunch. We'll resume at 2:30. 1:30 ಆಯ್ತು.
Oh, sorry. I'm so sorry.
It's seriously time for lunch.
No, we are actually still at 10:30.
ಅದು started at 12 ಅಲ್ವಾ, ಅದಕ್ಕೆ.
ಅಲ್ಲ, ನೋಟಿಸ್ ಹೋದ್ರೆ ಒಳ್ಳೇದು ಅವ್ರಿಗೆ, ಯಾಕಂದ್ರೆ
ನಾನು ನಿಮ್ ಪೆಟಿಷನ್ ಎಂಟರ್ಟೈನ್ ಮಾಡ್ತೀನಿ ಅಂದ್ರೆ ನೋಟಿಸ್ ಕೊಡ್ತೀನಿ. ಡೆಫಿನೆಟ್. ಅವರು ದೇ ಆರ್ ಆನ್ ಕೇವಿಯೇಟ್, ರೈಟ್?
They are on caveat.
Then if it is entertainable,
there is no entry ಮಾಡ್ರೆ ಅಪ್ಲೈ ಮಾಡಿದೆನಲ್ಲ ಬೇರೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಗೆ. ಮಂಡೇ ಆರ್ ಟ್ಯೂಸ್ಡೇ ಯು ಲಾಸ್ಟ್ ಮೈ ಕೈಂಡ್.
ಮತ್ತೆ ಯಾಕೆ ಅಡ್ಜರ್ನ್ಮೆಂಟ್?
ಅಲ್ಲ, ಅದು ಯಾಕಂದ್ರೆ ಅದರ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್
ಮತ್ತೆ ಇನ್ನೇನ್ ಬರ್ಬೇಕು? ಈಗ 2 ದಿನ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದಕ್ಕೆ ಏನೋ ಅಂತ ತಂದಿದ್ದೀರಾ?
ಕರೆಕ್ಟ್. ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಗೆ ವೆರಿಫೈ ಮಾಡಕ್ಕೆ ಕೊಟ್ಟಿದ್ದೀವಿ, ಬಿಕಾಸ್ ಇನ್ ಬಾಂಬೆ ಅದು
ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇಸ್ ಬೈ ದಿ ಪೊಲೀಸ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್.
ಆಯ್ತು, ಅದೇ ನನ್ನ ಲಾಸ್ಟ್ ಪಾಸ್
No, we have spent so much time. I'm not going to 2:30. I'm going to dictate.
Very well.
ನಾನು
My lord. My lord, I'm the petitioner, party in person in this case. A
Which
plaintiff
case?
petitioner.
Which
No,
case?
not in this case. I have a memo for posting, my lord.
Monday.
My lord, on Friday, my lord, because I'm jobless since 8 years and my life is on the end of the line, my lord.
End of the line. What happened?
Because I've been terminated by fraud and misrepresentation. He's dragging the case since 8 years, my
What
lord.
GMCPC alva?
Yes,
What is
my
the-
evidence is about to get dismissed there at the trial court.
So complete the evidence.
No, my lord, it's because I wanted to challenge the IAS here before this honorable court.
No problem. We'll get it on Monday. Friday is half a day.
Oh.
It's a half day, you will not be able to reach.
Much obliged, my lord.
Will grant, don't worry, yes. ಲಂಚ್ ಅವರ್ ಏನೋ ಸಿಕ್ಬಿಟ್ಟಿದ್ಯಾ? ಲಂಚ್ ಅವರ್ ಏನಾದ್ರು ಸಿಕ್ಕಿದ್ಯಾ?
ಹೌದು.
ಅಯ್ಯೋ, ಅವಾಗಲೇ ಡಿಕ್ಟೇಟ್ ಮಾಡ್ಬಿಡ್ಬೇಕಾಗಿತ್ತು.
Permitted to withdraw there.
ಮೆಮೋನ ವಿಡ್ರಾ ಇಲ್ಲ,
ಅದಕ್ಕೆ ಲಂಚ ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದು ಒಳ್ಳೆದಾಯ್ತು.
Counsel for the petitioner, after arguing the matter at length, would seek leave of this court to withdraw the petition. Memo reads as follows: petition disposed as withdrawn.
Please.
Dismissed, disposed as withdrawn. Yes. That's why lunch bitre wisdom dawns. Yes. Yes. ಇದ್ಯಾವ್ದು ಮೇಡಮ್? ಇದು ಯಾವುದೋ ಕೇಸ್ ಬಂದ್ಬಿಟ್ಟಿದೆ.
Suit for partition is decreed, my lord.
ಗೊತ್ತಾಯ್ತು, ನ್ಯೂ ಸ್ಟಾಂಪ್ ಪೇಪರ್.
ಹೌದು.
ಅದು
She is being a.
ಬಟ್ 10 ವರ್ಷ ಆದ್ಮೇಲೆ you have sought for.
She was not aware that it is to be produced before the sub-registrar for the purpose of registration.
We will have to ascertain who are the contesting respondents here.
ಎಲ್ಲ ಕಾಂಪ್ರಮೈಸ್ ಆಗಿರೋದು ಎಲ್ರು ಬಿಟ್ವೀನ್ ದಿ ಫ್ಯಾಮಿಲಿ.
Between family, ಅವ್ರದ್ದು ಯಾರ್ದು objection ಇರಲ್ವಾ?
ಅವ್ರದ್ದು ಯಾರ್ದು objection?
ಯಾರದ್ದು?
They took already they took
ಅಲ್ಲ,
their
ಅಲ್ಲಿ
respective shares.
who were they represented there?
Yes.
Where?
ಅಲ್ಲ,
ಅದಲ್ಲ ಕಾಂಪ್ರಮೈಸ್ ಅಲ್ಲಲ್ಲ, ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರಲ್ಲ ಈಗ.
ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ಲ, ಸರ್ವ್ ಮಾಡಿಲ್ಲ, ಅಡ್ವಾನ್ಸ್ ಮಾಡಿ ಜಸ್ಟ್ ಇದು ಮಾಡಿ.
ಡಿಫಿಕಲ್ಟ್. ಇಲ್ಲಿ ಗವರ್ಮೆಂಟ್ ಯಾರಿದ್ದಾರೆ? ಗವರ್ಮೆಂಟ್ ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಕೊಡಿ. Give a copy to the government. Now what happens is a compromise petition is arrived at, compromise is arrived at in a suit in 2013. It is drawn on a particular stamp paper. When the revenue entries are to be changed or whatever benefit has to be taken, then it is indicated that is an old stamp paper. The court has accepted it, and now court, he files an application seeking the compromise to be drawn on a new stamp paper. Court says you have come after 10 years, we will not do it. Just look into it. ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಕೊಟ್ಟಿರಿ. No other contesting respondents.
Yes.
I'll take it on next Friday, 20th. List on 20th.
Hearing for the petitioner. This is a matter of partition of the property. Lord, in this case, I am arguing that as per section 2 and 3 of Partition Act, they have asked for sale of the property. Hence, the court must follow the law and offer it for sale to the other sharer, that is me.
That is what the co-sharer will have a right to
Co-sharer.
purchase the property under the Partition Act is what you are saying. That's all. We'll hear the other side. ನಿಮ್ಮನ್ನು ಕೇಳಿದ್ದೀನಿ ನಾನು.
Illa, just a few more points.
ಹೇಳಿ.
Apologies. Just a few more
No
points.
problem.
The original suit is filed by the mother and the two sisters. That some of the facts prior to the suit is that they had actually entered into an arrangement with my client, with the son, saying that they are selling the property, they are giving up their rights, and they signed NOC also, and the property came to be registered in my name. I have given them money also. And I was working in Bahrain. My mother was staying in this property. When I came here, I used to stay here. I used to look after my mother. She was supposed to join me. All this while, there was no issue. There was no request for partition. Suddenly, out of the blue, they filed the partition suit. So I have contested the partition suit saying that the property entirely belongs to me. At that time, that was my claim. So I have not asked for any mean profits or anything at that stage. Thereafter, the court decreed it, and
Is your share recognized by the court?
the 1/4 share is yes now recognized.
Fine, that's it.
So the court said 1/4 share. Then I challenged it in High Court, Supreme Court. I came back now. 1/4 share is finalized.
You challenged
Thereafter,
everything and went back to Byron.
The courts have confirmed the position of law that there was no release deed registered by the parties. Hence, even though I have paid the amounts as agreed, there is no release deed, so you are not the rightful owner of the entire property. Now I am bound to that 1/4 share. Thereafter, 2011, the FDP came to be filed. In 2011 itself, along with the FDP, they filed an application asking the court to sell the property and give them their proceeds. I have filed that application also along with a memo. Thereafter, in 2013, again, there was a court commissioner who was appointed. When the court commissioner has given a report, again, they filed a memo which is signed by the three parties. Petitioner 1, 2, 3 themselves have signed it. In that also, they are seeking for sale of the property and the sale proceeds to be divided amongst them. At that stage itself, my contention is that at that stage itself, Section 2 of the Partition Act is triggered. Thereafter, both the parties, the
No,
court
instead
said,
of selling it to the third party, you want to purchase it.
exactly, obliged. Thereafter, in 2014, the court had ordered that the property should be demolished, the house should be demolished. Against that, all of us came up to the High Court, and that High Court RFA took several years to be disposed. Only in 2021, it came to be disposed. In 2022, when we went back to the courts for inquiry, I filed my application for mean profits. 2022 and 2023, by March, there was an order recognizing my share under for mean profits. They challenged that also, saying that you have not sought for mean profits or your share of the rents in the original suit, so you cannot ask for it in the FDP.
Correct.
But the court said that there are judgments to support my contention, and the court has passed a very detailed order recognizing my share, saying FDP is a continuation of the suit
All right,
proceedings.
now you have got
Yes.
those mean profits or
Thereafter,
whatever, that's a different
by
thing.
October 2023, I had finished my arguments. I've submitted the memo of calculation. I've submitted all the citations on which the mean
Now,
profits have
I
to be
am only
calculated.
asking, how can you stop them from selling the property?
I'm
First
not-
thing, you're not stopping. How can you impose upon them that it should be sold only to you?
I will just point out a
The
few
Partition
citations.
Act, you said.
Partition Act and the interpretation of that in a few citations.
Aye.
I've already submitted the list of citations on 29/4.
All right. Yes.
In that, the courts have consistently held.
Power to order sale instead of division of properties. Now the court has ordered.
My lord, before that, Section 2, in Section 2 of Partition
Section
Act,
2 itself.
yes, whenever in any suit of for partition, etc., it appears that by reason of the nature of the property to which the suit relates, or the number of sharers, or of any special circumstance, a division cannot be reasonably or conveniently made. And that a sale of the property and distribution of proceeds would be beneficial, then the court may, if it thinks fit, on the request of such shareholders, interested individually or collectively, direct the sale of the property and distribution of the proceeds. So in this case, they have triggered Section 2 because they have asked for the sale of the property.
Correct.
Section 3 says, if in any case where the court is requested under the last foregoing section to direct a sale, the court is requested by them
Okay.
to direct a sale. Any other shareholder applies for leave to buy the valuation of the share or of the party, or the party is asking for a sale. The court shall order a valuation of the share in such a manner as it may think fit, and offer to sell the same to such shareholder at the price so ascertained. So it is a mandatory provision. When they ask for a sale, after valuation, the court shall offer it to such shareholder who is offering to buy. Now, all three parties, petitioner 1,
Now,
2,
if
3,
you say you don't want it, then to someone else.
then it may go to a public auction. But I am not saying I don't want it. In 2014 itself, I offered to buy. In 2014, they were ready to sell it to me.
Right.
The negotiations had come to such an extent where one of the parties had to take a power of attorney from her child who's living in the UK, based on which the case was adjourned. Suddenly, out of the
Now,
blue,
what
they
is that
turned it.
under challenge?
The order under challenge is that of the honorable, that of the trial court, which is at page number
53?
73.
73.
From 73 onwards, there are 2-3 orders they pass consistently. The trial court hastily, first there was a report on the order of the court commissioner report. That court commissioner report is very vital. That court commissioner report is at page number.
Now all applications are rejected.
There are no applications. They've only been filing applications for sale of the property. I have not filed any other application except my determination of my share. That is still pending. On a certain date, at page number 73.
Come to page 76.
Yes. The court has declined to consider my mean profits request till the sale of the property, which is wrong.
Now warrant is issued to the commissioner to sell
the
auction
property. That is wrong. In my opinion.
This is what you're calling in.
This entire process of
so auction is wrong and offer should have been made to you.
Yes, according to section 2
and 3.
2 and 3. And also the determination of the mean profits has to be done first. Without that, how can I deposit any amount towards their share?
Well,
and the valuation of the property also may kindly be considered. The valuation report filed by the commissioner.
What are these judgments now?
At page number 127, kindly, valuation report of the commissioner. The court commissioner was suggested by them, advocate commissioner. I had suggested a court commissioner who is a company which specializes in valuation. They quoted 1 lakh rupees to do the valuation. As opposed to that, they suggested a court commissioner. The court has picked that court commissioner who is suggested by them, who has gone to the property and given a valuation at page 127.
Right.
He says that as per guideline value, it is 4 crores and he's added 25% escalation to it. And he's added the building value, page 127.
All right.
He's added the building value, he has taken 25% escalation and he has given a final valuation. And the court observes on the very next date that both the parties have accepted this valuation. Once the valuation is accepted, I am ready to purchase at this valuation. That is my simple contention. On the very next date, I filed a memo stating that I am ready to buy at this valuation. Yes. Instead of accepting that memo, the court has gone ahead.
All right. Yes, sir.
The citations before.
You want to rely on?
Yes. I've submitted a bunch of citations on 25th April.
Yes.
In that, in the very first citation at page number 8, internal page number 8.
Yes.
At paragraph number 16 and 17, the court has gone into detailed analysis why public auction is different from auction between the co-sharers, and it says the very at page number 8, internal page number 8.
Yes.
The court says the very object of Partition Act is to authorize a court to divide the property in some exceptional cases where an equal division is not practicable, then to award compensation, etc., etc. Then Partition Act supplies this defect in law by giving proper safeguards, a discretional authority for sale where a partition cannot be reasonably made. Now, in this, the court has clearly examined Partition Act section 2 at paragraph number 15 also. If a sale is directed under section 2, it presupposes that the sale is not by auction and it is not warranted, it is only confined to co-sharers.
Yes.
If they invoke section 2, it has to only be confined to the co-sharers. Now at page 16. At page number 16, paragraph 15. This is a Supreme Court judgment. It says that it will be noticed that section 2 sale refers to sale of the entire property.
Yes, solid. I have seen
Very.
all the judgments.
I'll just point out one more paragraph in one judgment which will go to the root of the matter. Page number 36.
Root of the matter.
Page number 36, para 12. It says
interpreting 2 and
interpreting. It says it is sine qua non for directing a sale because such a request necessarily signifies his willingness to have his share converted to money. So when they have asked for their share to be converted to money, they are not interested in the property. And because of the sentimentality attached to property in Indian law and under Partition Act and the interpretation, the person who has offered to buy the portion of the property and is already having a share in the property must be given precedence. And this is not a case where they have asked for sale of the property in 2024. Now in 2024, they filed memos saying, I will buy the property. In 2013 itself, they have filed a memo which is signed by the parties saying that they are only looking for the sale proceeds. That is there in the other memo which I have filed at page number 6. In 2013, all the three parties have signed. Petitioner 1, petitioner 2, petitioner 3. They have in person signed. The objection in this honorable trial court's order is that parties have not signed the memo. The amount is stated vaguely. So there are three issues in my humble submission. One is that they are stopped from making a bid at this stage because they have triggered section 2 by asking for sale proceeds to be given to them. So by consequence of section 3, the sale proceeds, the sale of the property has to be offered to me. I'm willing to purchase the property, there ends the matter. The second point is that the mean profits is yet to be determined by the trial court. Once my share of the mean profits, that is they are in possession of the property from 25 years, I have not been in possession. So for that 1/4 of the share of the possession and enjoyment of the property and the rentals derived from it has to be calculated and 1/4 of it has to be given to me. Without that determination, there cannot be a determination of how much money I have to deposit. Third point is on valuation. The court has already directed a valuation as recently as 2024 October. And based on that valuation, which is accepted by both parties, there is a number fixed. And I'm willing to purchase at that property, at that rate. These are my three submissions.
Yes.
None of the facts which he has said are fact. 2003, this property belonged to our father, Satish. He died. Subsequently, I her mother of both of us. Satish had 10 children. One son who's in Bahrain, and 2 daughters. What happened was, mother was living there, daughters were living there, his son was in Bahrain. He will not tries to usurp this property. Ultimately, the mother ultimately wanted to give some share to the daughters also. She filed a suit of party in the year 2003. From, I tell you what is why, contact is a relevant factor which you have to bear in mind when you are not to fix the From 2003, please see how many years have passed. 2013. 24 years this son has harassed the mother. In fact, can I persuade you not to look at my objection statement? Son was directed to pay mother 25,000 rupees. Not one rupee was paid. And the son says no waxing around it. And my learned friend gives evidence on their behalf. But please look at the order passed by this on to the court. Please turn to page 67. What happened was, I'll thereafter go sequentially. But this I want to tell you, because my learned friend said, oh, I love my mother, I love everybody. I didn't see. In fact, I can tell you about it. My father, he was such a frugal person and he was very, very rich.
Yes.
He acquired one flat and one plot, my mother had one listing. Land which was allotted by the immediate. He asked me what should I do. At the end,
Yes.
about 2 years ago. He said, give it to my sisters. I have 2 sisters. This is the Sadhara who says I want everything, but I point out. Please come to our page 80. Same order. Last time is Lordship decision number 7.
Yes.
See, partition as aforesaid, pay a sum of rupees 25,000 for Nelson to the mother. Srimati Vinoda, starting from 1st of December as maintenance and continue to pay the aforesaid sum in the disposal payment. Not one penny was paid by his son. Then, Lord, please come to Lord, what had actually happened. Please come to the 6th, we filed a suit for partition. My husband, please take note this objection statement.
Yes, sir.
The suit was not, the contention in the suit is, I have got perfected my title by adverse possession. Please come to Lord, running page 8. Yes. This is what the decree, suit was decreed for partition filed by the mother and the sisters. This for our son, for our deputy, for our respondent. Please come to Lord, issues with the key.
Yes.
Issue number B, whether the defendant proves plaintiff will receive 3 lakhs. not given at all, doesn't matter. And receive, plaintiffs to receive 2 lakhs, 2 lakhs each. Whether the defendant proves he has perfected his right by adverse possession. Now please come to the plaintiff.
Adverse possession is.
Yes, my lord.
All right.
All kinds of contention. In fact, what is not anything, I'll give you a what's management. Supreme Court has said, conduct the petitioner for in the writ petition before and after the lord the petition will have to be taken into account. Paragraph 20 and page 24. Paragraph 24. For the foregoing reason, this court considers that the defendant failed to establish that plaintiff one has received 3 lakh, plaintiff to receive 2 lakh, each in lieu of their share release their right in favor of so and so. Then, paragraph 21. He says not adverse possession, that is also rejected. He files a written plea. Please come to RFL. Please come to page 26. Dismissed with cost of 10,000 rupees. Please come to running page 15. 50. Order.
Yes.
Present every filed by the defendant to the Supreme Court by the divide of merit on cost of 10,000.
SLP dismissed.
SLP next page. Then what happened was the we filed the FTP proceeding. In the FTP, not a lot was dragged on. Ultimately, what happened was on there was not the commissioner was appointed to see whether there is an article easily. He files a report saying that it is possible to not divide it into 50-80 side. He says 20 by 50 will not 4 sides can be formed with a passage in between of 6 feet.
Oh, this is one site, is it? 58 each. Huh?
One side is 58.
58. Yelling. Where?
Commissioner's report.
Yes.
He says what at paragraph 8. Accordingly, if we divide the property from the road, each party will get 12.5 feet, not the south. Then he says what para 9, page 55. 2050 there are not 4 sides master. 2050 doesn't matter.
Passage ಕಟ್ಟಬಹುದು ಅಷ್ಟೇ. Yes.
That was challenged by all of us. And it came up by a lot. Sent it aside.
And sent it back.
Yes, sent it back.
ಅದೇ ಅಲ್ಲೇ ಇದೆ.
This after writing or some sent it aside. Then what happened was he advances the matter.
No, application under section 2 is filed by whom? Yes.
No, not us.
Please come to before that order please come to see 81 of the
I am there, sir.
81 of the objection.
I am there. And 82 is the order. Yes.
81 there is the report.
That is 82.
Then what he does is proclamation says like Yahweh is in 2022. He files an application for about knee problems.
No. Proclamation is on 27/1/23. Yes.
He files 2 applications. One lot for reopening, other lot being 79.
Yes.
Page 79 lot is for reopening. Page 80.
Reopening what?
Reopening the
Inquiry.
And secondly, my lord, to read 81 in the please come to Parasi, because this is the department. I state that the profits from the estate, civil property, even the respondent is now a co-sharer, to the extent of one co-share, forms a part of the partition. Same is required to determine partition, adjacent share of the respondent. Say proceeds in making next page now 100. Para 11, last 4 lines, 3 lines. The respondent has been living knowledge, embroidered this litigation, has not received any so. And therefore, Lord, he says, I must get mean profits. Then para 13, another department. It is submitted since the property has been settled for sale by the sum court and for diligence sale proceed. It is appropriate for this court to conduct inquiry, determine the response share and income from the responses also, in order to take just the same towards the respondent share. So he agrees to not exchange. Then 2 years Lord, he drags it on. Then in the meanwhile, mother said, good application happened, but one of the sister, whose LRs are there, as respondents 3 to 5, they are not parties to it. They have not asked for sale. Mother got out to sheer desperation because 25 years.
The mother wants to sell her share. Then ಎಲ್ಲರಿಗೂ passed away.
He passed away also. That's why I said 25,000 crore.
But how do you wriggle out of the? Yes. Yes.
What happened was, we did not ask for sale. Mother asked for sale. Therefore, Lord, I am entitled to Lord say that I also Lord gave it. And then now in this connection, please come to Lord turning page 75. He wants to come Lord and acquire it at 5 lakh, 5 crores. Please come to page 74.
Yes. Willing to purchase 6 crore 40 lakhs.
We offer to purchase the property at 6 crore 40 lakhs. Then what does he do? He says last minute. I think paragraph last. Respondent has not shown consideration amount. He shall show the same next day.
Morning
session, he says 6 crore 80 lakhs. Then the mother and other said 7 crore 20 lakhs. Page 75.
ಇದೇ ಪಬ್ಲಿಕ್ ನೀವೇ ಆಕ್ಷನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
Now he wants to acquire it at 5 lakhs, 5 crores. We look at the quantum.
No, if it is 6 crore 80 lakhs, you're ready to give?
No, 7 crore 20.
7 crore 20 lakhs.
I'll buy.
Wait. No, morning session, the son says 6 crore 80 lakh. Respondent yaru?
Now.
Respondent says 6 crore 80. And mother in the afternoon session says 40 first, 80 next. 40 lakhs, 40 lakhs ಜಾಸ್ತಿ ಆಗ್ತಾ ಇದೆ. So it is interpretation of 2 and 3 is not necessary. If you sit across and decide it, ಅದು 680 ನೋ 640 ನೋ 7 ಗೋ ಮಾಡ್ಕೊಂಡ್ಬಿಡಿ. ಅಲ್ಲ, now you have agreed that if it is 720 they will purchase. You are prepared to sell it to them. No, that's what 720 ಕೊಟ್ರೆ you are ready. ಆಯ್ತು, ಅವರು 680 ಅಂತ ಇದ್ದಾರೆ, ಮಧ್ಯದಲ್ಲಿ 7 ಮುಗಿಸ್ಬಿಡಿ. ನೀವು ಯಾರು ಸರ್? ನೀವು 20,000 ಅಂದ್ರೆ ಎಷ್ಟು? So the public auction is better. Why? Who is he?
We are not offered to purchase the property and sell the property. We did not say that as far as I represent 3 to 5. We are not saying that we will be only the other 5.
Now, to understand, Now, a co-sharer will have a right to purchase the property. All right. Now there are co-sharers who are now wanting to purchase the property. In a circumstance of conflict between the persons who are entitled to purchase the property, ಅದು public auction ಯಾಕೆ ಬೇಕು? ನೀವೇ ಮಾಡ್ಕೊಳ್ಳಿ. 3(2). If no such shareholder is willing, 3(2), if two or more shares, this here already, yes. Yes. ಇದೊಂದು, you sit across, all of you, decide what's to be done. We'll close everything. ಇಲ್ಲೇ ಇದ್ದು ಅಲ್ಲೂ ಎಲ್ಲ ಕ್ಲೋಸ್ ಮಾಡ್ಬೋಣ. 20 ವರ್ಷದೆಲ್ಲ ಖಾಲಿ ಆಗುತ್ತೆ.
Just one submission. This exercise has happened multiple times. And
no, the buck should stop here. We'll see. Yes.
I completely agree. But the difficulty is that 3(2) hogak munche 3(1) has to be satisfied, and 3(1) nalli they have given up the share. There is no two words about it.
No, you don't worry about it. 3(2) or 3(1).
We are ready to purchase.
If you want interpretation, we will definitely give it. No, at which point in time your conduct with regard to the Justice Shyam Prasad's order,
show
definitely.
their conduct also. There is no question of
now
conduct
see,
here.
It
We
is
have not dragged
co-sharers versus co-sharers, conduct versus conduct, not necessary.
We are ready to buy.
You sit
We
across,
learned
you are ready to buy, he is also ready to buy.
I am ready to, but I am saying that legally only I am entitled to buy. That
Where has he given up? Where has he given up his share?
There is a memo filed by.
That is what you are basing your argument or right on the strength of a memo that was filed. You sell
all
the
of
property.
Them. Memo
they have signed. True, they have signed. Memo you have filed, you have shown, they have signed. No problem. If they are relinquishing their rights on the basis of a memo.
No. Yes. The basis of the memo is that it triggers section 2. They have relinquished their right based on section 2.
It's all right. Now, if you want to answer in this case to go on for another 10 years, no problem. Give a quietus to it, sit across, and whichever, all of you are siblings now.
Yes.
Just because you are in Bahrain, you have not lost that sibling tag.
No, absolutely. Just because I'm in Bahrain, I have not lost my right also in the property.
No, I'm not saying that at all. I did not get into the right issue at all. Now, all three of you sit and close it. That's better. Yes, sir. That should. You are at 720. He is at 8 crores.
We'll match that.
So 3(2). Whoever gives the higher value will get the thing in terms of section 3(2), subsection 2 of section 3. All right, we'll pass some order. Auction illa. Between the councils you do. Sorry? No, make it happen now. Either I will pass orders on merits, not just give a chance, because this is definitely resolvable. It is definitely resolvable. It does not require pages of orders to be passed. It only sit together. Ili dialogue alla, trialogue. 3 of you are there, do it. Yes. The petitioner, I'll just pass a small order for my reference later. The petitioner is before the court calling in question the action of the concerned court seeking to put up the property for public auction. The property in the case at hand is the share that has fallen to the respective siblings of the property, and the property is a 50 into 80 square feet area site, is it? Residential house in Koromangala. The issue is whether the concerned court could have put up the property for public auction in the teeth of section 2 and 3 of the Partition Act. The learned counsel for the petitioner would vehemently contend that section 3 cannot be given a go-by by the concerned court, and a shareholder and the co-sharer in a partition, in a decree of partition, is entitled to the first choice of purchase of the property. The learned senior counsel, Uday Holla, appearing for one of the respondents, would seek to place reliance upon subsection 2 of section 3, which permits if 2 or more shareholders severally apply for leave to buy the property as put up for auction under subsection 1, the court shall order the sale of the shares to the shareholder who offers to pay the highest price above the valuation made by the court. The valuation made by the court has jumped 3 times, which began at 6 crore 40 lakhs and 6 crore 80 lakhs and now stands at 7 crore 20 lakhs. The learned senior counsel, Kiran Javadi appearing for the Kiran Javadi appearing for the respondent would submit that he is ready and willing to pay 8 crores to the said property. Therefore, the issue now boils down to subsection 2 of section 3. Since all the 3 are siblings, I deem it appropriate to direct them to have a trialogue between them and arrive at a figure which is the mandate of subsection 2 of section 3 as well. In the event of nothing coming forward from the aforesaid observation, the matter would be considered on its merit. Yes. ಎಷ್ಟು ದಿನ ಬೇಕು? ಒಂದು ವಾರ?
I'll take instructions. We'll discuss
ಅದನ್ನೇ
with
instruction.
senior.
List the matter on 20th. Yes.
Published.
Yes.
Defendant's petition against concurrent findings.
Correct, sir.
Concurrent findings. What has happened?
We're
ಅಲ್ಲ,
already-
ಅವ್ರು ಇನ್ನೂ ನೋಟಿಸ್ ಆಗಿಲ್ಲ they have filed ವಕಾಲತ್.
He is sure that a notice will be issued.
Very well, my lords.
Learned counsel, serve a copy.
I will serve a
Counsel
copy.
for the petitioner to serve set of papers upon Keshavamurthy. B. Keshavamurthy, counsel appearing for the respondent. Monday?
Monday, please, my lords. In the same stage.
Monday irade adu.
ಅಲ್ಲ, in the same stage ಅಂತ.
Monday irade ಆ stage.
Please, my lords. I'm great.
Section 10,
Please.
entirely different.
No, madams. Property is the same. They are claiming that their father did not have the right to sell, and therefore they sold it to the present plaintiff.
Where is
I have filed a suit.
suit? 2 suits you have.
My lords, the suit filed by me is OS number 7385 of 2019.
7385 of 2019.
And the suit filed by the respondent is 7707 of 2019.
7707 of
2019.
2019. Which is the suit you are seeking arrest of?
7707 of 2019.
Filed by the defendant.
Filed by the defendant, plaintiff respondent.
Go to the suit schedule.
Plus,
Prayer and schedule.
plus, my suit, my lords, will
Page.
find at page prayer at 112, my lords.
This is your suit.
My suit, my lords.
Injunction.
Declaration and injunction.
Declaration and injunction.
And then
Schedule
was their plaint and schedule at page 120.
site property number 13. Aurdu?
Page 122, my lords.
Thirteen bar A.
That's the number created afterwards.
How created? ಶ್ರೀಗಂಧದ ಕಾವಲು ಅದು ಅದೇ
And the Kavalu 84/11, no, all same.
Who is the plaintiff there?
One purchaser from my vendor. I have to bring to my lord's notice one more aspect. My suit has been rejected under order 7 rule 11 and RFA is pending before my lords.
ಮತ್ತೆ ಹೀಗಿರೋದೇ ಒಂದು ಸೂಟ್ ಆಗಲ್ಲ.
ಅಲ್ಲ.
RFA is pending.
RFA is pending. Therefore, it's a continuation of the appeal.
I'm not saying it's not a continuation.
Continuation of
Appeal
the
is
suit.
always a continuation. But how to arrest this suit, I don't see. The parties are different.
No, parties are same.
Same.
Kindly see, my lords, in my suit, the present plaintiff is 7th respondent, 7th defendant, page 101 at 102.
The petitioner, defendant, number 2 in OS 7707 of 2019 is before the court calling in question an order of the concerned court which rejects the application filed by the petitioner under section 10 of the CPC seeking arrest of the proceedings in OS 7707 of 2019 on the score that a suit on the same cause of action between the same parties is pending in which he is the plaintiff in OS 7385 of 2019. The counsel for the petitioner would take this court through the parties in both the plaints, the suit scheduled properties in both the plaints to demonstrate that they arise out of the same cause of action, but slightly, but differently worded. In that light, in the light of the purport of section 10, the ingredients of, and the purport and the ingredients of section 10 being met, there shall be an interim order of, ಈಗ ಯಾವ ಸೂಟು ನಡೆಯಲ್ಲ ಈಗ ಅದು RFL ಪೆಂಡಿಂಗ್ ಇದೆ.
Yes.
Difficult. Anyway, ಬರ್ಲಿ ಅವರು. In that light, there shall be an interim order of stay of further proceedings in OS 7707 of 2019. So according to you, nothing should go on. We'll see. Yes. Petitioner to serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement. The interim order till the next date of hearing ಅಂತ ಮಾಡಿ. List on 25th.
Pending in RFA ಅಂತ ಒಂದು ಹೇಳ್ಬಿಡಿ.
ಅದೊಂದು separation ಆಗಬಾರ್ದು. ಅದೊಂದು ಮೇಲೆ ಒಂದು ಲೈನ್ ಬರ್ಕೊಳ್ಳಿ. The learned counsel for the petitioner submits that the suit in OS 7385 of 2019 has been rejected on the score that on an answer to an application filed under Order 7 Rule 11 by the defendant therein, and the same is pending before this court in
RFA 1059. 1059.
RFA 1059 of 2023. The matter would require consideration. Therefore, there shall be an interim order of stay till 25th. Yes. ಅಷ್ಟೇ ಅವತ್ತವರೆಗೆ ಯಾವ ಸೂಟು ನಡೆಯಲ್ಲ ಅಂದ್ರೆ ಕಷ್ಟ. Yes. ಎಷ್ಟು?
Petition seeking
19. Compromise challenge.
Yes, Lord.
Issue notice. Why?
My lord, after the compromise decree has been arrived, we have found that the access road which was given by the plaintiff
is not even there.
Is not.
Correct.
Is unusable, my lord. There's
unusable because of the floods.
Floods and also because of the boundary pillars that
is
are
not
erected.
a permanent thing.
The boundary pillars are erected alongside the road, my
Let's
lord.
see. Petitioner to serve on the counsel who represented the respondent before the trial proceeding, before the concerned court in the trial proceedings. Yes. Again, section 10.
Yes, my lord.
Then same ಏನಿದೆ?
Oh, my lord, my daughter has filed a suit for partition. My sisters have filed a suit for partition, a comprehensive suit. Unless share ನನಗೆ allot ಆಗೋವರೆಗೂ my daughter will not get. This property belongs to my father's property. Same schedule, my lord.
Emergent notice to the respondent. Petitioner shall serve on the counsel who represented the plaintiff before the concerned court and file an acknowledgement to that effect. Same day, 25th. Till such time further proceedings shall remain in OS
7012
of
2022.
22 shall remain state. Yes.
Much.
I appear for the petitioner. Matter was been heard on the last date of hearing.
Order 1 Rule 10.
Order 1 Rule 10 allowed. And I took up a contention that this public status is.
Chandrappa. Late Chandrappa.
Same Chandrappa.
Nothing.
Kindly, I think, may kindly make one observation. That thing is, I have challenged the status of the that lady, and it is pending consideration in another suit. That is what exactly my contention is, because in this suit that would not be an issue. That is the reason.
That's all right. But anyway, we are answering Order 1 Rule 10.
May kindly.
We'll answer.
But because in the order, course of the order, it has been noted she is the daughter, therefore she is entitled to be a party to that, and we are not conceding that.
If there is any problem, you move it. I will dismiss. Yes.
May kindly.
ನಿಮ್ಮ ಹೆಸರು ತೋರಿಸ್ಬೇಕಾ ಅಷ್ಟೇ ತಾನೆ
Okay.
ಬರ್ದ್ಕೊಡಿ. ಎಸ್
Okay.
During disbursement of compensation amount, my lord.
ಅಲ್ಲಿ ಕೇಳಿದ್ರೆ ಡಿಸ್ಪೋಸಲ್ ಡೈರೆಕ್ಷನ್ ಕೊಡೋಣ
Yes, ma'am.
ಅಷ್ಟೇ ಸಾಕು.
ಅಲ್ಲ ಅದರಲ್ಲಿ
ಆಲ್ಟರ್ನೇಟ್ ಇಸ್ ದಿ ಮೇನ್. ಇದೆಲ್ಲ ತೋರಿಸ್ಬಾರ್ದು ನಮ್ಗೆ.
ಅಲ್ಲ petitioner appellant 3 and 4 is nothing to do with the application made by
No,
the.
not only the prayer. You come to page 5.
Yes, ma'am.
Your narration there. ಏನ್ ಹೇಳಿದ್ದೀರಾ ನೋಡಿ. Page 5 ಪ್ರಕಾರ we'll close it.
Yes, ma'am.
We'll direct conclude. Order, ಈಗ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದಾರಾ ಇಲ್ವಾ?
ಇಲ್ಲ ಪೆಂಡಿಂಗ್
Pending.
We'll direct close.
I humble submission, my lord. Meanwhile, my lord, at least so far as point number 3 and 4 is concerned.
She has not made any claim against 3 and 4, my lord.
I leave all contentions open. If I have to consider, then everything will have to be considered. Yes. The petitioner is before this court seeking the following prayer. The main prayer of the petitioner is for a direction by issuance of a writ in the nature of mandamus, directing the concerned court to hear and dispose IA number 6-8.
7, my lord.
IA number 7, filed by the third respondent under Order 21, Rule 97 of the CPC, before holding an inquiry on the claim of the third respondent. It is the case of the petitioner that the concerned court is not passing the order on the application and is now wanting to direct holding of an inquiry. In the light of the said prayer, I deem it appropriate to direct the concerned court to pass necessary orders on the application in IA 7 of 2025, filed on 3/2/2025, in accordance with law, within an outer limit of 4 weeks from the date of receipt of the copy of this order.
2 weeks, my lord. Already there.
2 weeks. 2 weeks from the date of receipt of the copy of this order. Yes, next.
23.
Ordered accordingly, all other contention shall remain open to be considered there.
Since matter is
Before the
tomorrow, hand delivery may be ordered.
Final order hand delivery. ನೋಡ್ ಅಪ್ಲೋಡ್ ಮಾಡ್ತೀನಿ.
Please.
Yes. ಮೇಡಮ್ ಅದನ್ನು ಅಪ್ಲೋಡ್ ಆದ್ರೆ upload.
Please, for the appointment of court commissioner is under challenge. The suit for declaration and
pleadings ಜಾಸ್ತಿ ಆಯ್ತು.
Lord, may kindly turn to the impugned order.
Anyway, we'll see. Yes. The emergent notice to the respondents. Petitioner, contesting ಯಾರು?
Lord,
One,
1,
two.
2, they are the plaintiffs. So 1, 2.
Plaintiffs ಮಾತ್ರ.
Please. And,
Emergent notice to respondents 1 to 5. ಅಲ್ಲ 1 to 6.
1 to 6.
1 to 6. Petitioner shall serve on the counsel who represented the plaintiffs 1 to 6 before the concerned court. List on 27 till such time there shall be an interim order. Stay further proceedings before the concerned court. Yes, next.
24.
ಅದಕ್ಕೆ ಜಾಸ್ತಿ ಪ್ಲೀಡಿಂಗ್ ಮಾಡಬಾರ್ದು. ಎಸ್ ಅಂದ್ರೆ ಏನ್ ತಪ್ಪಿಲ್ಲ ಇದರಲ್ಲಿ. ಪೂರ್ವಾಂಕಾರ ನೀವು ಚೇಂಜ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟು ಯು ಕಾಂಟ್.
I have not changed. My lord, your lordship may kindly see the plaint. The party, my lord, is not a legal entity at all. Purva Zentech Business Park ಅಂತ ಮಾಡಿದ್ದಾರೆ. That is the name.
ಅವರು ಎಕ್ಸಿಕ್ಯೂಷನ್ ತೊಂದರೆ ಆಗುತ್ತೆ ಅಂತ ಕರೆಕ್ಟ್ ಮಾಡಿರೋದು ಈಗ ಅಷ್ಟೇ. ಅದ್ರಲ್ಲಿ ಏನ್ ತಪ್ಪೇನಿಲ್ಲ.
ಕರೆಕ್ಟ್ ಮಾಡಿರೋದು ಕೂಡ my lord, this
ಆಯ್ತು, ಇಲ್ಲೇ
project,
ಐ ವಿಲ್ ಪರ್ಮಿಟ್ ಹಿಮ್ ಟು ಕರೆಕ್ಟ್ ಇಟ್ ರೈಟ್ ಅವೇ. ಕರೆಕ್ಟ್ ಪಾರ್ಟಿನ.
no, let him file an appropriate application for impleading. The reason is this, my lord. This has
Why?
been done under an application for amendment. Now, my lord, if a party is
Tomorrow
impleading-
he secures a decree.
Yes.
Execution time ಅಲ್ಲಿ you will take up ಇದು ಪೂರ್ವ ಅಲ್ಲ.
ಅಲ್ಲ ಅದಕ್ಕೆ if he corrects, my lord, the cost title, it is beneficial for him only. My lord, I have said, my lord, Purva Ruby Properties is the legal entity. Now, instead of filing an application to implead that particular legal entity, some other legal entity is sought to be impleaded.
So if a correct legal entity is sought to be implemented, you will not object.
No, let them file an application, my lord. Because, my lord,
No, you
insofar
say,
as
if
implement is
if it
concerned,
is the correct legal entity, you are not going to object?
no, let him file an application.
I'm asking a
My lord,
straight question.
my lord, I cannot on record, I cannot concede. Let him file an application, my lord, court will pass orders. My lord, because the reason is implement adre, limitation will start, my lord, the suit will commence from the date of implement. Amendment will relate back to the date of the suit.
All right, yes, sir. He wants it to be related to the date of the suit because it's an error on his part, he says.
Entity is completely different. So let him
Yeah.
file an appropriate application.
Yeah, who is the plaintiff? Yaar ನೀವು?
My lord, plaintiffs are the owners of the suit schedule property. My lord, they claim that because of the construction done by the defendant in the neighboring property, their properties are damaged. So therefore, they are seeking compensation and injunction.
Implicate the proper party, sir. ನಿಮಗೆ ತೊಂದರೆ ಆಗುತ್ತೆ. ಈಗ ಹೇಳ್ತಾ ಇದಾರಲ್ಲ ಕರೆಕ್ಟ್ ಎಂಟಿಟಿ ಯಾವುದು ಅಂತ.
ಇಲ್ಲ ಅಲ್ಲಿ ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳಿದ್ದೇನೆ. ಮಿಲಾಟ್ ಪ್ಯಾರಾ 4 ಆಫ್ ಮೈ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್
ಅವ್ರನ್ನೇ ಮಾಡಿ
ಪೇಜ್ 40.
ನಿಮಗೆ ಕಾಂಪನ್ಸೇಷನ್ ಬೇಕೋ ಬೇಡ? ಮತ್ತೆ ಇಂಪ್ಲಿಟ್ ದಿ ಪ್ರಾಪರ್ ಪಾರ್ಟಿ.
No, that is not correct. I think my learned friend has not gone through the written statement.
ಅವ್ರು ಇನ್ನೊಬ್ಬರನ್ನ ಎಕ್ಸ್ಟ್ರಾ ಮಾಡ್ಬಿಡಿ, ತೊಂದರೆ ಇಲ್ಲ. ಜಾಯಿಂಟ್
ಎಕ್ಸ್ಟ್ರಾ ಅಲ್ಲ, ಮಿಲಾಟ್ your lordship may kindly see page 40.
ಅದ ಅಲ್ಲಿ ನೋಡ್ಕೊಳ್ಳಿ.
ಆಯ್ತು, ಅವರು ಮಾಡ್ಲಿ, ಆಯ್ತು.
ಎಸ್.
ಆಯ್ತು. Page 4 of my written statement. That is very clear.
ನಿಮಗೆ ಕಾಪಿ ಇಲ್ವಾ?
ಕೊಟ್ಟಿದ್ದೇನೆ.
What do you want now? He is cutting at the root of the matter. Yes, sir. Not maintainable. Why?
Not.
ಅದಕ್ಕೆ ನಾಟ್ ಮೇಂಟೈನಬಲ್ ಚಾಲೆಂಜ್ ಮಾಡಬಾರ್ದು ಅವರು. ಎಸ್ ಸರ್. ನಾವು ಈಗ ಪ್ರಾಪರ್ ಎಂಟಿಟಿ ಯು ಫೈಲ್ ಸೇಯಿಂಗ್ ದಟ್ which is that Purva?
Lord, the para 4 Purva Ruby Properties Private Limited.
Purva Ruby na.
Howd. Properties Private Limited. It's a company incorporated under the Companies Act. First ಹೇಳಿದೆ ನನ್ನ written statement ಅಲ್ಲಿ. Lord, the internet, everything, address ಎಲ್ಲ ಸಿಗುತ್ತೆ. Just a matter of filing one proper application for implement. That is all.
No, ಅದರಲ್ಲಿ ಕೆಳಗಡೆ ಕಂಡೀಷನ್ ಸಪ್ಲೈ ತರ ಹಿಡನ್
ಇಲ್ಲ ಸ್ಟಾರ್ ಏನು ಹಾಕಿಲ್ಲ.
Will you do that? Allah, will you do that? No. If you do that now, it may help you in compensation. Answering on merits is not a problem. We'll answer it.
Kindly see para 4.
If you want to do that, we'll close this and permit you to file an application. Aita? We'll say you will file an application. You will withdraw this application and file a fresh application there.
So our amendment plain to hakidare. So this order may have to be set aside.
Which order?
The impugned order whereby the present amendment has been.
No, I will set this aside and permit him to file a necessary application.
Yes.
The petitioner is before the court on the calling in question an application, allowing of an application filed by the respondent plaintiff under Order 6, Rule 17 of the CPC. The learned counsel for the petitioner submits that in the written statement, it was clearly indicated who is the entity against whom the plaintiff should proceed, notwithstanding the same. The entity that is now sought to be bought in by way of an application under Order 6, Rule 17 is entirely different. A learned counsel for the petitioner places reliance upon paragraph 4 of the written statement where the name of the entity is clearly indicated. The learned counsel for the respondent at this juncture submits that he be reserved liberty to implead the appropriate entity as it is the case of a demand of compensation from the hands of the entity. Therefore, an appropriate entity should be made a party to the proceedings. In that light, I deem it appropriate to permit the plaintiff respondent to file a fresh application in accordance with law to bring in the appropriate entity which is indicated at paragraph 4 of the written statement. In the light of the said submission, the order impugned is necessarily to be obliterated. In that light, the following order: the petition is allowed, allowed in part, so and so stands set aside. Matter is the liberty is reserved to the respondent plaintiff to implead the appropriate entity in a manner known to law. Ashte sir.
In accordance. All contentions.
All other contentions, the one, except the one considered here and above shall remain open.
Okay.
Yes.
25.
Please, my lord, this is the matter where the court commissioner's application was rejected. My lords had also pointed out last occasion that there are no reasonings whatsoever. The honorable trial court only says, no, you cannot collect evidence. So which is why I'm rejecting the application. Here, this is a case where trial was.
Paragraph 10 bitre ಏನು ಇಲ್ಲ ಇಲ್ಲಿ. Oh.
But before that, may I just point out, because since it's my writ, I just pointed out in about 3 minutes, but not what my grievance is.
ಏನಿದು? ಲೆನ್ಸ್ ಕೊಡಿ ಮೇಡಮ್. ಎಸ್ ಅಲ್ಲ, ಇದು ಓದಕ್ಕಾದ್ರೆ ಇದ್ರಲ್ಲೇ ಆಗಲ್ಲ, ಇದ್ರಲ್ಲಿ ಸಾಧ್ಯ. ಎಸ್ ಈಸಿಯರ್ ಇದಾ? ಇದು ಯಾವುದೋ ಒಂದು ಬೂತ್ ಕನ್ನಡಿ. Which other color? Brown.
Is the property of Krishna. Now Krishna Reddy has gone sites, and he has sold one of the sites, but to plaintiff. Now the portion in difficulty is the yellow part. What has happened is he has gone the site at night.
Now the application filed by him is rejected.
Yes.
ಇದನ್ನ ನೀವು ಇಲ್ಲಿವರೆಗೂ ಅವ್ರ ಕೇಸ್, ಒಂದು ನಿಮಿಷ, ಇಲ್ಲಿವರೆಗೂ ಅವ್ರ ಕೇಸ್ ಇರಲಿಲ್ಲ. ಇದು ಕೊಟ್ಟ ಮೇಲೆ ಡೆಫಿನೆಟ್ ಆಗಿ ಕೇಸ್.
What is this document? Let me just tell.
Yes, sir.
Look, now first he files a suit, which is 6592 of 2004. This is a bare injunction suit. There, he applies for appointment of a court commissioner. He gives a specific instruction to the court commissioner to identify whether his property lies in this green portion or the brown portion. Now, that court commissioner report is this. Now, this court commissioner,
there is already a determination about his property.
Determination of his state.
When in the same suit?
Earlier suit, he filed,
what is that earlier suit for?
earlier suit he filed for bare injunction.
All right.
Now that suit is dismissed. RFA is dismissed.
Now what suit is this?
Now he filed a suit for declaration. Second suit is not maintainable as a different thing. But what I'm submitting is, this is the
This is the report of the commissioner in the earlier suit,
in that suit,
where the property of the petitioner is already identified.
already identified that it is in my property.
Now what is the stage of the proceeding?
But it is a final hearing. Evidence is led. This document is already marked in this suit. The evidence given by the
Our petition.
May I just submit?
Yes, sir.
My lords, may kindly take my application, my lord, at page 48, because I have extracted the cross-examination of the defendant himself, defendant number 1. He admits, my lord, saying that yes, I am the absolute owner insofar as 10/1A2, which is my property. He says that 10/2, he is the owner, my lord, no dispute. Now, my lord, insofar as my first prayer is concerned, suit for declaration, yes, it will be decreed. Second prayer is for mandatory injunction to remove the encroachment. Now, my lord, tomorrow to execute this, I'm saying, my lord, insofar as the first prayer is concerned, there's no difficulty. Second prayer, how do I execute this? Because tomorrow then becomes
Confidence,
a
okay. Over confidence, yeah. One suit agle hogide, idu decree
that is for injunction, man, because there are observations made. It is not so that because there was an encroachment in the previous suit. When we came before this honorable court made an observation saying that insofar as part of the scheduled property you are in possession, the other part of the scheduled property there is an encroachment. File a comprehensive suit for declaration. There was liberty given to me. I filed a comprehensive suit. It was very much given to me. When there was liberty given to me, saying that yes, you file a comprehensive suit, I file a comprehensive suit before this honorable court. Now here there is an admission. Now what happens here, my lord? My predecessor entitled.
This is marked.
It is marked, my lord. May I just point out, my lord?
Where is the impugned order now?
Impugned order, my lord, it starts at page 29 in the Shuru Agate, but my lord, the operative portion.
As he said, if it was paraphrasing the earlier finding to paragraph 10.
Please.
Reasonings.
Please, my lord, may I just then point out what my difficulty is? Now here, my predecessor entitled purchased it in 1980. There was a Hissa Tippany of the year 1980. It is on that basis that I purchased the property. My lord, in the previous suit, court commissioner is appointed. My lord, he says that he's prepared the report based on a sketch which is marked in a writ petition, which I'm not a party to. That
Which
sketch,
marked in a writ petition.
writ petition
Which writ petition?
between different number 1 and different number 3.
All right, that has nothing.
So on the basis of that sketch, he prepares this.
That's all right. The earlier suit was between the same parties.
Yes, but then this is based on that sketch, my lord, where I am not even made a party.
Auditor.
It will not apply because here this is a suit for declaration. Declaration, my lord, I have sought for liberty, my lord, then thereafter it is disposed of. The observations made in the RFA also are there. May I just point out, my lord, my lords may kindly take annexure L, page 169. This was the writ petition which was filed between different number 1 and different number 3.
169.
169. Our collude act bitu, they form a sketch. It's based on that sketch that this commission report is formed.
Well, court will consider it.
Please, my lord.
What will commissioner do?
Court commissioner no, here, my lord, because my second prayer will not go. Because my second prayer, if there's an encroachment, what happens to it, my lord? Because tomorrow I will say that yes, the honorable court will say yes, you demolish whatever it is.
Now,
but the question is,
what happened to OS 6592 of 2004?
That was dismissed, my lord, because on RFA, the judgment is here, my lord.
RFA also dismissed. That's become final.
RFA, only I'll point out, my lord. My lord,
Where is the order in RFA?
It's there, my lord. Next page 169 is what, my lord, I took, my lord.
That is just Anand Berede or the RFA, yes.
160.
That is also 160. What liberty is
162.
given?
My lords may kindly see, my lord. My lords may
Suit
kindly
being
come
one
to
of bare injunction, the court has not entered upon this. It could not be possible to reverse it.
leaving open
any
such
remedy available to the
plaintiff may
plaintiff
be entitled
entitled
to
to
appeal is
appeal is
dismissed.
dismissed.
My lords may kindly see para 5, the starting, my lord. Given the above circumstances, while the learned counsel for the appellant is right in his contention that the suit could not have been dismissed, even in respect of site formed over land in survey number 10/1A2, that is my land. The finding that the plaintiff has not established his possession over the entire extent of land described in the suit shall property cannot be faulted. Therefore, the plaintiff would do well to file a comprehensive suit to seek possession over the entire extent described in the sale deed, subject to the defenses that may be available to the respondent. It is there. We have got a specific observation to that effect. So, order 2 rule 2 will never apply here.
No, I am not on that, sir.
I'm just saying that is a contention which is taken by the learned senior counsel. It will never come. So when this
contention, not clarification.
So here, insofar as one portion is concerned, because what the Honorable High Court observes is, my lord, I am in possession of one portion. So the remaining portion, there has to be an inquiry.
The learned counsel is right in contention that the suit could not have been dismissed even in respect of a site formed over land in
10/1.
survey number 10/1/2.
That is mine, my lord. That is mine.
The brown area.
Brown area.
All right. Now, what is the doubt about the?
So there is encroachment.
Which encroachment?
My lord, no, it's in this observation itself. So there is encroachment.
Where is the observation?
My lords may kindly see why my suit for bare injunction did not survive is because one portion was already encroached, my lord. So which is why I cannot.
Where is the finding there, here, sir?
My lord, over here, given the circumstances, where so and so could not have been dismissed even in respect of the site formed over land and so on and so on. So the finding that the plaintiff had not established his possession over the entire extent of land described in the suit shall property cannot be faulted. I have not, because I was not in entire possession. So my possession, insofar as injunction is concerned, I cannot maintain a suit for bare injunction once my possession is already encroached. This encroachment comes into my property. That is why, my lord, where the coordinate bench has laid down certain guidelines to say if there's an encroachment, if there's a boundary dispute. I'll just give the judgment to coordinate bench. This was also a case, in this also, the observations made by the Honorable Trial Court was that you cannot collect evidence.
The report not got it. Yes. Come to the guidelines.
Please, my lord. My lords may kindly come to page 22, para 21.
Yes.
Having examined the provisions referred to above and given the facts on
You have seen this?
I have referred to it also, my lord.
Extensively considered, and on what at what times it should be permitted is what is said.
Yes. Point 2, dispute relating to boundary encroachment.
He appears to have some grievance.
Let's see what is order 26.
No, if justice, order 26 rule line, nodi. Please.
It means you see some matter in issue.
Correct.
Now, what is he asking for? Please identify where my site is situated. This is the exact same question. Please have this earlier.
No, if the RFA court had not permitted him to all over agitate again, it has. Would do well with a comprehensive suit.
All contentions open.
Maybe. No, it may not be liberty, but would do well with comprehensive suit is exercise that liberty.
What is he asking for? Please see page 1. What is he asking?
Now.
Before I can, I'm not trying to intervene. Before, I just want to point one aspect. ಇದರಲ್ಲಿ ಏನಾಗುತ್ತೆ ಮನೋಟ್ 1980 ಹಿಸಾರ್ ಟಿಪ್ನಲ್ಲಿ 468 chain links, just one second, sir. 468 chain links from east to west on the southern portion. Manoit gets interchanged. 468 becomes 240. Ulta ಮಾಡ್ತಾರೆ.
But
that's in the second report.
We'll do this. I'll set this order aside, send it back to consider everything. Nothing is considered here. Otherwise, you want me to consider, I'll consider. He appears to have a case.
Please.
In terms of, I will say the court will consider it in terms of Shadaksharappa and pass
Please,
this.
please. I have referred to the judgment, Manoj. In fact, the honorable court refers that I have given this judgment, but no observation. Otherwise, I have produced it.
No, where is the reference to the judgment?
My lord, it's there. My lords may kindly come to page 36. 36 ಅಲ್ಲಿ ಇದೆ.
Reasoning alilla.
Reasoning alilla. I produce all of this. My lord, 3 judgments are produced by them. So that's also not considered.
I think both of you should be aggrieved by this order.
And 6 months, my lord, because 6 months to pass this order.
ಇದಕ್ಕೆ
6 months. 39/2024 ಗೆ.
Yes.
Counsel for the defendant government to do copy of filed by the present plaintiff under order 26/9. Read with the 51 CPC seeking appointment of court commissioner, assistant director of land, invoice number so and produce the sketch and memo. So not just taken into account that there is already a document on record which not identifies where his property is. Now please see page 41. What is this prayer? For appointment of a court commissioner as to
No, generally I'm slow in allowing these court commissioners to come in, only to drag the proceedings.
Yes, and it is what stage it is and stage
That's another thing. Yes.
Previously, Manoj, there was a judgment.
No, I will direct the court to pass an order within 2 weeks from today. Well, let there be some reasons. Nothing is done. Nothing is done. None of both of your contentions finds place here. Judgments don't find place here. Alla high court judgment kotra adan refer madala andre henge. Where is it? No, not applicable. You should not, it is referred to in the narration of facts.
Previously, in fact, the ratio was that, Manoj, before evidence is even commenced, you cannot file an application for commissioner because that would then amount to collecting of evidence. But now that's clarified by virtue of this judgment.
Evidence is over now.
Please,
it's at the stage of final argument.
I'm not collecting
anything here. Evidence collection stage.
I'm not. That's exactly. We're only trying to elucidate what is in dispute. Where is the encroachment?
No, because I'll tell you. Yes, the petitioner is the plaintiff in OS 5689 of 2015 is at the doors of this court calling in question an order passed by the concerned court rejecting an application filed by the petitioner under Order 26 Rule 9 seeking appointment of a court commissioner to identify the property of the petitioner. The present suit is the second in line. The petitioner is the plaintiff. Petitioner had instituted a suit in OS 6592 of 2004 for injunction against the same respondent, the respondents, defendants 1, 2, and 3. The said suit comes to be dismissed. The dismissal of the suit leads the plaintiff petitioner before this court in RFA to 428 of 2009. The said appeal comes to be disposed by the coordinate bench in terms of its order dated 5th January 2025 by the following observation.
15.
Oh, 15. Appeal comes to be dismissed, affirming the findings of the concerned court in OS.
That's 6592 of 2004.
OS 6592 of 2004. While rejecting the appeal, the coordinate bench has observed that the plaintiff would do well by filing a comprehensive suit to seek possession over the entire extent as mentioned in the sale deed. The suit being one of bare injunction, the court could not have, the court cannot enter upon the issues with regard to title. Taking cue from the observation made by the coordinate bench as quoted supra, the petitioner, the plaintiff has presented the subsequent suit in OS 5689 of 2015. The issue is not with regard to two suits, but the petitioner filing an application under Order 26 Rule 9 at the stage of arguments of the case to get a court commissioner appointed to identify the property of the plaintiff. As a matter of fact, the plaintiff in the earlier suit itself had filed an application under Order 26 Rule 9 and a court commissioner had been appointed. The court commissioner had submitted his report drawing up a sketch with regard to the properties of the plaintiff and the defendant. The court now considers the same and rejects the application filed by the plaintiff under Order 26 Rule 9, observing that the court had already appointed a commissioner and the report of the commissioner is already in place, except the The observation of the concerned court is as follows, page 39. Except the aforesaid paragraph, there is no reason worth the name as to why the application of the petitioner should not merit consideration. The learned counsel for the petitioner and the defendant both would contend that they had relied upon certain judgments, including the judgment of the coordinate bench, which has extensively considered the purport of Order 26 Rule 9 as to when it should be permitted and when should not. And that also does not bear consideration while rejecting the application of the petitioner. In that light, the concerned court shall now reconsider the application filed by the petitioner by passing necessary orders within 2 weeks from the date of receipt of the copy of the order. It is made a copy of the order, bearing in mind the observations made by the coordinate bench in the case of Shadakshara.
Please.
Even then, he ought to have relied on. The observations made in the course of the order is only for the purpose of consideration of the case of the petitioner and the submissions so made with regard to the order suffering from non-application of mind. None of the observations would become binding upon the concerned court to now pass an order in a particular manner on its particular manner in terms of what is afore directed. That should
as long as the direction is there in terms of the coordinate bench's directions.
That will. 2 weeks, yes. 2 weeks from the date of receipt of the copy of the order.
Please.
Yes.
Order set aside one because ಅದು ಲಾಸ್ಟ್
Order set aside.
ಅಲ್ಲ ತಾವು ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಡಿಕ್ಟೇಟ್ ಮಾಡ್ತಿದ್ರಿ ದಟ್ ಐ ಡೋಂಟ್
ಅದಕ್ಕೆ ಡಿಸ್ಟರ್ಬ್ ಮಾಡಬಾರದು.
ಅದಕ್ಕೆ ಅದೊಂದು
ಅದು ಮಾಡ್ತಾರೆ.
ಪ್ಲೀಸ್
allowed question.
Please.
Operative person ಬರ್ಕೊಂಡು writ petition is allowed in part. Order dated so and so stands set aside. The matter is remitted back to the hands of the concerned court to pass necessary appropriate orders on the application of Order 26 Rule 9 of the CPC, bearing in mind the observations made in the course of the order. The order shall be passed within 2 weeks from the date of receipt of the copy of the order. All other contentions other than the one considered herein above shall remain open.
Please, grateful.
ಯಾವ್ದು ಸರ್ ಈಗ ಹೇಳ್ತಾ ಇದ್ದೀರಾ ಇರ್ಲಿ ಆಮೇಲೆ
26
Happy for the petitioner.
Yes.
That's the case where your lordships considered in the last occasion relating to the rejection.
Order 1 Rule 10.
Order 1 Rule 10 by the pending lite purchases in a final decree proceeding. The court says they have independent right, they have to pursue other remedies. That is what I use patently wrong is my submission.
FDPL impleading ಹಾಕಿದೆ.
FDPL impleading application. ಅದೇನ್ ಮಾಡಿದ್ದಾರೆ ಇವಾಗ my only submission is this, I just want to draw your lordship's attention to certain facts. What has happened is these respondents 10 to 18 million.
Sir, you have suit for partition?
Suit for partition, correct.
Suit for partition.
How?
So you have purchased it from a particular member of the family and that share.
Yes, madam. In what I'm only
Why do you want to implead in these proceedings? Separate suit against others. Partition suit al stranger.
I am not a stranger. That's what
Then
I'm
what's-
submitting.
You're a
I'm
purchaser,
a
right?
Purchaser, pending purchaser. Yes. And Millard, the law is Millard well settled in the sense in 1983 only the Supreme Court has said that Millard, if a pending purchaser is there, in a partition suit is a necessary party and he can even claim equities. May pass on the judgment. That has been followed by
In FDP or preliminary decree?
in FDP proceedings.
Yes, further answer.
That's correct. Millard. I'm not disputing that. What I am trying
Then
to
we'll close it by recording both the statements. That's
by
all.
the only difficulty is this, Millard. My learned friend is appearing for other respondents. Millard,
Well, that we will direct.
no, I am ready for even early disposal. I am also anxious because there are innocent purchasers who have purchased small sites during 96.
Don't get worried about sir. ಅವ್ರದ್ದೇನೋ ಹೇಳ್ತಾರೆ ಅವ್ರು
Before even I submit, my learned friend is
ಇನ್ನೋಸೆಂಟ್ ಅಂತ ಹೇಳ್ಬಾರ್ದು ಅಂತ.
Yes, Millard, what has happened is this, Millard. According to him, I am not innocent. According to my clients, Millard, in 96, 97, the property was sold by the predecessor in title of respondents 10 to 18, who was the Chandrasekharaya and his sons, Millard. They did not disclose about the pendency of the partition suit. According to us, we came to know about it only during the final decree proceedings. In 2022, we have filed
You
implementing.
step into the shoes of your
That's
vendor.
correct. That's right. There is no dispute about it. My only submission is, in addition to the land that is allotted in item number 9 of the suit schedule properties, in which the sites have been sold. Millard, what has happened is, this respondents 10 to 18 have been allotted equal share in other items of the property also. For any reason, Millard, if the sites purchase the equities while adjudicating the equities, if the extent that is allotted to the share of this predecessor in title of respondent 10 to 18 falls short, we can make a claim in respect of the other portions which have been allotted to the same branch. I can proceed against that particular person and not against
You
other
proceed
person.
against your vendor, sir. Other,
What I'm submitting.
see, other persons who are
No, I
entitled,
am
to share, you
not-
can't
I-
enter into
no, I
their
am not, that's why I'm, for a moment, I'm not saying that. Your lordship may kindly see what I am trying to submit to your lordship is, in addition to 1/6 share that is given to my vendor, that is vendor's branch, in item number 9 of the suit schedule property, in which I am supposed to claim my rights. In addition to that particular property, this particular very branch has been allotted. Kindly see the partition decree in RA, Millard. Kindly see the RA decree.
We are on
In
order
that,
one,
Millard.
order one, rule 10, you are entitled to come into the
Yes, your lordship may kindly allow the
proceedings.
application.
In FDP proceedings, where everybody's right are now being determined on an inquiry.
That's correct. My only request is I may be permitted to proceed against my vendor's branch only.
That he has no problem.
That's correct. But what I am submitting is,
If he is given permission to proceed against his vendor, how can you be aggrieved?
that's correct. That's what.
Huh.
9.
Hmm. Huh. Hmm. Hmm. Huh. Hmm.
That's correct.
Survey number 68. Block number? Block number? Hello, survey number 68 FDP should come to an end.
No, what?
That's
What has happened is this. I mean, my learned friend is not representing those persons against whom I am seeking my relief. For a moment, Millard. Correct.
Sorry.
ಅಲ್ಲ ನಾನು ಹೇಳ್ತಾ ಇರೋದು ಇಷ್ಟೇ ಸ್ವಾಮಿ. Let my learned friend, if we give.
Now, 1 minute, sir.
Yes, ma'am.
Survey number 68 is what you are claiming.
That's right.
That is where you purchased from
Right.
one of the persons whose now share will be
That's correct.
determined.
That's correct.
Now you proceed against that FDP insofar as 68 is
understand.
concerned,
What
will close.
That's correct, madam. My learned, I am.
Will close saying reserving liberty
I am
to proceed
trying to-
against the vendor.
I am
Other,
trying-
where than a acts taken.
I am trying to make one more submission relating to those respondents, not my learned friends' clients. What has happened is this, Millard. Earlier, in the earlier petition filed before this honorable court by my vendor's branch, they had sought for a adjudication of their rights under wills as against respondent number 1, Jayamma, who is also allotted a share in the same property. What had happened, this honorable court directed in the final decree court to hold an inquiry in respect of those wills. After that order came to be passed, respondent number 1 and respondents 10 to 18, they have entered into a compromise. They filed a compromise petition in respect of this particular property alone. While my application was pending for impleading,
That does not stop them from proceedings.
No, what I am
Your
only-
application is pending only against survey number
That's
68.
correct, that's correct. In
ಅದಕ್ಕೆ ಯಾರು compromise enter ಆಗಿದ್ದಾರೆ?
ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟವರು. What they have done is they have entered into a compromise among themselves.
Including survey number 68?
In respect of survey number 68 alone. That is respondent number 1 and respondents 10 to 18.
Yes, sir.
He is not representing
No,
them.
he is, ಅದು ನೀವಲ್ಲ, but he is the purchaser of survey number 68. If you enter into a compromise and defeat his rights, then he has right to defend.
Correct.
They are not a party
They are
here.
parties here, Miller. That is the reason why I submitted, Miller, in the last occasion. But I wanted.
Compromise, you are not a party. Who is that Chandrasekhar? That is 5, respond number 5, is it?
Respondents 10 to 18 are the persons before your lordship.
You serve on them.
I will serve on them, Miller.
Council, they are represented by councils, right?
But here they are not, in the trial court they are represented.
Trial court.
Yes, I will do that.
Serve on, the
Including
petitioner
respondent
shall
number
serve
1 also.
on the council who represents the respondent in, respondents, yaru?
Your lordship may kindly say respondents 1 to 18.
Respondents 1 to 18 before the trial court and file an acknowledgement in the next 2 days. When is the next date?
Miller, 16th is the case and it is posted for arguments.
List the matter on 19th.
In the
The
meanwhile,
concerned
there has
court
been interim
shall
order.
defer its proceedings
Yes, ma'am.
till the next date. We will, survey number 68, next time close ಮಾಡ್ತೀನಿ ನಾನು.
68 year ನಾನು ಕೇಳ್ತಾ ಇರೋದು. ಅಲ್ಲ.
ಇಲ್ಲ ಅವೆಲ್ಲ ಆಗಲ್ಲ. ಅದು 19th we will close it, no further deferring.
ಅಲ್ಲ ಮತ್ತೆ ಅಲ್ಲಿ ತೊಂದರೆ ಆಗುತ್ತೆ ಅಲ್ಲಿ. ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ
ಒಂದ್ ನಿಮಿಷ.
my submission this minute. I have nothing against my learned friend's
One
client.
ನಿಮಿಷ. At the learned counsel, Shri Varadarajan would undertake that he would himself seek an adjournment on the 16th of June 2025 before the concerned court. And ಬೇರೆಯವರು ಇದಾರ ಅಲ್ಲಿ?
ಬೇರೆಯವರು ಇದ್ದಾರೆ, ಅದಕ್ಕೋಸ್ಕರ ಹೇಳ್ತಾ ಇರೋದು.
ತೊಂದ್ರೆ ಇಲ್ಲ.
It is better I serve copies
ಮುಂಚೆ
on them.
ಆರ್ಡರ್ ಇರಲಿ 19th. Yes.
The lordship may kindly.
ನೀವು ಒಬ್ಬರೇ ಅಲ್ವಲ್ಲ ಅಲ್ಲಿ?
The order may kindly be uploaded.
ನಾಳೆ ಇದೆಯಾ?
Not
16th ಇರೋದು.
2 days.
16th ಅಲ್ಲಿ ಸೇಮ್ ಸ್ಟೇಜ್ ಸರ್.
Same stage ಅಲ್ಲಿ. I will serve the
16th
copy.
ಇರೋದು ಇವತ್ತೇ ಹಾಕ್ಬೇಕು.
ಅಲ್ಲ ನಾಳೆ ನಾಳಿದ್ದಲ್ಲ ಆದ್ರೆ ಅದು ಸಾಕು ಅಂತ.
ನಾಳೆ ಇನ್ನು 12 ಸರ್.
Because only difficulty is they are trying to, because they enter into a compromise.
They'll get it,
And the
don't
court
worry.
passes a decree on that.
You
That
will
is the
get it.
problem.
That is 16th ಬರ್ಬೇಕು.
Much of it.
Next.
87.
And for the petitioner, my lord. Lordship may please pass an order staying execution. Lordship may please pass an order staying execution case at Annexure B till disposal of RA 67 or 24.
ಏನು?
Otherwise, it leads to demolition of gigantic existing wall. My lord. Because
What do you want?
staying execution case at Annexure
For the
B.
judgment debtor, sir.
I am the judgment.
But then where is the question of staying the execution? Can't tell. ಎಲ್ಲಿವರೆಗೂ ಮಾಡ್ತೀರಾ? No, no, no.
Sorry. It was taken, the execution case is posted to 24/6/24.
Correct. Rightly
To
so.
execute the judgment decree of the trial court.
What is the problem?
They may lead, that may lead to demolition of
That may lead. The consequence of it is that only. In demolish ಮಾಡಬೇಡಿ ಅಂತ, what is the use of execution then?
Till disposal of regular appeal, because I have already filed appeal.
ಅರೆ ಹಾಕಿದ್ದೀರಾ?
ಹಾಗೆ ಹಾಕಿದ್ದೆ sir.
ಯಾವ
ಅದರಲ್ಲಿ
stage ಅಲ್ಲಿ ಇದೆ?
I have also filed application under order 41 rule 5 seeking stay of the execution proceedings. Along
Before,
with that,
before the first appellate court.
first appellate.
What did the first appellate court
First,
do?
ಅದರಲ್ಲಿ there was delay of 92 days in filing appeal. Because of that reason, I filed application under section 5 of limitation act also. That is posted for evidence and it posted for cross examination on IA section 5 limitation act. For that,
The petitioner is the judgment debtor. He suffers a decree in OS 234 of 2016 in terms of the order dated adalla. In that, is it?
Yes, sir.
OS 2016.
OS 234 of 2016.
2016.
I have suffered decree in that.
Suffered a decree and challenges the order passed by the concerned court before the first appellate court in MA RA 67 of 2014 and also files an application under order 41 rule 5 of the CPC
That is
seeking
pending, sir.
seeking stay of the judgment and decree. The said application is said to be pending consideration at the hands of the first appellate court. In the interregnum, the judgment, the decree holders file an execution case 196 of 2024 seeking to execute the decree in OS 234 of 2016. The learned counsel submits all efforts that is made to get the application under Order 41 Rule 5 heard at the hands of the first appellate court has not yielded any result. And the consequence is that the property of the petitioner would be demolished and would frustrate the rights of the petitioner in the first appellate court. Therefore, to preserve status quo or the rights of the petitioner, to preserve status quo on the rights of the petitioner, the proceedings in the regular appeal, the will stay the demolition or execution.
Stay the demolitions.
The property of the petitioner shall not be demolished as a consequence of any order passed in the execution case till the next date of hearing. List the matter on 4th July. Petitioner to serve on the counsels who represent the respondent in the trial proceedings and file an acknowledgement in the next 2 days. Next 3 days. Yes.
28.
My lord, I appear for the petitioner in this matter, my lord. The petitioner
Child
educational
right.
please, my lord. The petitioner educational institution, my lord, was issued a summons by Karnataka State Commission.
Learned AGA is directed to accept notice for the respondent. Accept notice for the respondents. Two separate idara nimagena. The petition for the first respondent, emergent petitioner shall serve on any panel counsel representing the second respondent and file an acknowledgement to that effect. List the matter on 27th till such time there shall be an interim order spread for. Next.
Please.
Yes. Next.
29.
For the petitioner, my lord. The impugned order, my lord, is at page 23. Possession delivery has been issued. Page 23, my lord. Page 24 is the reasons which have been assigned. The court says that, my lord, against the order passed in RFA, we have not filed a SLP and it has become final. Therefore, my lord, possession. Now, my lord, your lordship may kindly turn to page 4. Objections, my lord, which we have filed to the application. Page 33. We have stated, my lord, we have filed the SLP. Page 33, my lord.
SLP hakidira?
Hakidira. Paragraph 4 of the objections. My lord, now court vacations.
Whole problem is SLP is preferred. One nimsha. Purti nanu helbidtini. SLP is preferred. Apex court has now, in terms of the notification, said execution cases are not the ones that are important to be listed in the vacation. Immediately we'll stay till the Apex court reopens. Correct. Correct.
My lord, now application under order 21 rule 26 is also filed. My lord, my instructions are 36 lakhs have already been deposited. My lord, 36 have already been deposited. 36 lakhs have already been deposited. Check has been paid. Now, my lord, what we are agreed by is an order, my lord, for delivery.
1 minute. We'll protect you till the Apex court reopens.
I have produced the notification also.
I know that. Not unconditional, but conditional.
My lord, 36 lakhs has already been deposited, my lord. My lord, it was on.
What Surana sir says is correct.
My lord,
you can be protected, but not without conditions.
My lord, as of now, my lord, the delivery possession.
Yavat 36 laksha ಕೊಟ್ಟಿದ್ದು?
11-10-20.
ಅಲ್ಲ ಅದಿರ್ಲಿ, that Supreme Court will look into, but
my lord, on 11-10.
in view of the vacation in the Supreme Court and execution cases in the classification that they are not urgent.
How much is due?
In this piquant circumstances. No, so the Apex court reopens on 15th July.
30th.
I will grant an interim order subject to condition of his deposit.
My
Correct,
lord,
sir, I will direct them to deposit.
my lord, the order was passed in the RFA.
Sir, if you want
But I will
an
submit.
order, you have to deposit.
Yes, my lord, I will suggest submit.
36 ಲಕ್ಷ ಯಾವತ್ತೋ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದಲ್ಲ
I will-
ಆಗಲ್ಲ.
My lord, the RFA was dismissed in the court, High Court vacations on 15/5. My lord, 15th of May. We have, my lord, filed a SLP, my lord, on 26th, 28th. The court vacations of the Supreme Court, my lord, has started on 26th. My lord, it is not that, my lord, there was a delay.
ಇವತ್ತು ಇದೆಯಲ್ಲ, ಇವತ್ತು ವೆಕೇಶನ್
ಅಲ್ಲ, ಈಗ vacation ಇದೆ. Therefore, my lord, our submission was, no, my lord, the reasoning
That's
given.
all right, but deposit you'll have to make. ಅಲ್ಲ, ನಿಮ್ ಕ್ಲೈಮ್ ಇರುತ್ತೆ ಬಿಡಿ, ಒಂದು ಅರ್ಧ
Lord, that there's an inquiry, my lord, which is being held as far as.
Deposit will not be taken by him, sir.
What is the amount, my lord, mean profit that has to be established?
ಅವ್ರ ಕ್ಲೈಮ್ 2 ಕೋಟಿ, ಐ ಆಮ್ ನಾಟ್ ಸೇಯಿಂಗ್ ಈ 36 ಲಕ್ಷ ಕಟ್ಟಿದ್ರಲ್ಲ, ಇನ್ನ 75 lakhs ಡೆಪಾಸಿಟ್ ಮಾಡಿ.
My lord, it is in a dwelling house, my lord, we are staying in there.
Whatever, you have suffered the order.
Therefore, my lord,
Not once, but twice, he says.
My lord, therefore, my lord, a SLP is filed. My humble submission before your lordship is, till, my lord, the Supreme Court opens, let there be a stay. Because, my lord,
Deposit ಮಾಡಿ, sir. Nobody is going to take away the money, it is your money. Then seek a direction, appropriate direction, Supreme Court.
My lord, till 2023, we have deposited 9,000 is the order, my lord, per month it has to be paid.
Ah.
Till 2023, it has been paid. That is what my learned friend
That
says.
is the deposit of rent, I think.
9,000. 9,000. Now from 2023, my lords, or not still now, my lord, it is. Just a- My lord, so it will come up to, my lord, around 2.5 lakhs, 3 lakhs. That, my lord, we will deposit. My lord, that is the, my lord, till 2023, we have deposited. That is the order, my lord, which has been passed.
We'll do one thing. Now, you deposit about 25 lakhs.
My lord, he is a 32-year-old advocate, my lord,
ಯಾರು?
who is staying, who's petitioner number 1, my lord, who is living with his sister. And my lord, he has no father and mother also, my lord, he is a 32-year-old.
Don't string that cord at all.
No, I'm just bringing to the facts, my lord. Now,
No, I am only on the apex court listing it, directing there is no urgency in that matter. He has a right or not, the apex court will see. And the order now that is impugned observes that he has not challenged it before the apex court. Correct.
he has filed an application for police protection.
ಆಯ್ತು, ಒಂದು ನಿಮಿಷ. 9th of?
9th of June.
ಹಾ.
On that day, they have taken time to file objection. Let them file objection, let the court consider.
ಮತ್ತೆ ಅದೇ ತಪ್ಪು ಮಾಡಕ್ಕೆ ಆಯ್ತು. ಅದು your claim is there, sir, we'll see. Yes, the heard the learned counsel Bipin Hegde appearing for the petitioner judgment debtor 7 and 8 and the counsel PD Surana representing the decree holders. The issue in the list revolves around a delivery warrant being issued for the purpose of executing the decree. The delivery warrant is objected to and the concerned court rejects the application on the following reasons. Page 22. Ade alva? Which
24.
Which is the impugned order?
Page 22, annexure A, my lord.
Page 22 to
Page
24.
22, my lord, order starts on page 22.
22 to ಇದು ಮಾಡಿ, ಅಲ್ಲದೆಲ್ಲ ಬೇಡ. From 23 and 24 mark portion. The the concerned court observes that the judgment debtors have not produced any document to show that they have filed an appeal before the apex court and there is no stay from either the apex court or this court. Therefore, there is no impediment in reissuing possession delivery warrant as it is the duty of the court to execute the decree. There can be no qualm about what the court has said with regard to execution of the decree, but the observation that there is no appeal filed by the judgment debtors before the apex court appears to be incorrect. The petitioners have produced.
My lord, page 33, my lord, is the objection in paragraph 4.
Page 33?
Page 33, objection to the application filed.
SLP, ಇದೆಲ್ಲಿದೆ sir?
My lord, page 471.
471. The learned counsel takes this court through the specially petition presented before the apex. ಎಲ್ಲಿದೆ?
Page 472, my lord, diary number 30997.
So and so.
Of 2025.
the counsel for the petitioner takes this court through the SLP preferred before the apex court, which is now registered as diary number
30997.
30997 of 2025. 2025. ಯಾವತ್ತು ಆಮೇಲೆ ಹಾಕಿರ್ತೀರಾ ನೀವು?
On 31/5/2025.
Is having preferred it on 31/5/2025. ಇದು ಯಾವತ್ತು ಆರ್ಡರ್ ಆಗಿರುತ್ತೆ?
15/5.
The concerned court, though the objection was, though the pleading was available to depicting that the petitioner's judgment debtors have preferred an SLP before the apex court, the court observes that there is no SLP preferred, therefore the delivery warrant is being reissued. The observation is on the face of it erroneous. The other circumstance is that the apex court is now on vacation. A circular is issued by the apex court depicting that cases of matters relating to execution are not urgent matters which can be moved in the vacation, moved before the vacation judge. It is that is the root of the matters. Execution and the adu ashte appeals, same thing. And all incidental matters are not urgent. In that light, the right of the judgment debtors would get frustrated if everything is over by the apex court reopening. Therefore, I deem it appropriate to stall the aftermath of the reissuance. Reissue agogidya? Stall the reissuance of delivery warrant to execute the judgment and decree till 20th of July 2025, as the apex court would reopen on 13/7/20. As the apex court would reopen on 13/7/2025 in terms of the circular. The interim order on 20th July 2025 would get automatically vacated if the petitioner would not secure any order at the hands of the apex court.
I request till 27th, my lord. 20th.
27th, fine. The interim order shall be on a condition that the petitioner would deposit 10 lakhs. 1 crore. New claim, sir. ನಿಮಿಷ.
2.5 lakhs will be deposited till. My lord, he has
Deposit
no capacity.
Deposit of rupees 5 lakhs. Yes. Which property? I think ಯಾವ property?
I do not know, my lord, what my friend.
Correct ಆಗಿ ಹೇಳಿ.
My lord, I have no instructions.
You say you're an advocate, don't tell lies. ನೀವಲ್ಲ ಸರ್, ಅವ್ರಿಗೆ ಹೇಳಿದ್ನ.
We will take it up on 27th, my lord. We will see that, my lord, it is not. No property has been sold, my lord. That is the instructions which I have. 2 scheduled properties are there. Both the properties, my lord, we have not sold.
We'll see. Supreme Court will decide all that. 27 July, ashte.
Yes.
This is 25 lakhs. 5 lakhs. 5 lakhs. 5 lakhs within the next 4 weeks. In the event the deposit is not made within 4 weeks from today, the interim order would get automatically vacated. List on 27th July. Sunday, na? 28th July. Yes. I saw June and saying 27. Yes.
30.
BWSSB disposed. Yes, Raju sir, disposed. Next. Neva madam, respondent again. Our ಬರ್ಕೊಂಬಿಡಿ. Yes. Yes, next.
Admission 31.
Covered,
Covered, my lord, because my lord's judgment itself is there.
Subramani.
I am supposed to be a broker in this.
Subramani.
Subramani, please. ನಾನು ಕೊಟ್ಟಿದ್ದೆ, I'll just pass it on again.
ಎಲ್ಲಿದೆ ಸುಬ್ರಹ್ಮಣ್ಯ?
Last time ಕೊಟ್ಟಿದ್ದೆ, I'll give it again. It's okay, sir. My office copy have made some markings.
ನೀವು ಯಾರು? Complainant.
Last time ತಾವು ಹೇಳಿದ್ರಿ, once they are served, my lords said that.
ಏನು ಇಂಟರ್ ಮಾಡ್ರಿ ಇದೆಯಲ್ಲ?
Interim order ಇದೆ, but my lords had said let them just come on record and then my lords will clash it.
ಇದರಲ್ಲಿ ನೀವೇ ಕಂಪ್ಲೇನೆಂಟ್ ಅಲ್ವಾ?
Same complaint.
ರಾಜಾ.
ಹೌದು, same complaint.
ರಾಜಾ ತಾನೆ?
Same, my lord, my lords has
ಮತ್ತೆ
made
ಅದ್ರಲ್ಲಿ ಹೇಳ್ತೀರಾ
observations.
ಇದ್ರಲ್ಲಿ ಹೇಳ್ತೀರಾ? ಇನ್ನೊಂದು ವಾರ ಬೇಕಾ? ಮತ್ತೆ ಕೊಡಲ್ಲ ಟೈಮ್, ಓನ್ಲಿ ಒಂದು ವಾರ. ವಾಟ್ಸ್ ಯರ್ ನೇಮ್? ಸರಿ, ಸೀನಿಯರ್ ಬರಲಿಲ್ಲ ಅಂದ್ರೆ ನೀವೇ ಓದ್ಕೊಂಡ್ ಬನ್ನಿ, ಏನ್ ಹೇಳ್ಬೇಕು ಹೇಳಿ. ರೈಟ್. At the request of the council appearing for the second respondent complainant, list the matter on 27th. Interim order subsisting will continue.
27th, madam, my lord,
26th.
26th.
26th. Interim order subsisting will
Please,
continue. to the
please,
next.
please. Great.
Notice order 7 rule 11.
Order 6 rule 17, Your Honor.
CRP ಯಾಕೆ?
My senior suggested.
Huh?
My senior suggested. So I filed CRP, Your Honor.
6 rule 17 CRP ಹೆಂಗ್ ಬರುತ್ತೆ? CPC ಹಾಕಿ. Yes, CRP ಹೆಂಗ್
Tomorrow is the.
What is all this? Tomorrow ಇದ್ರೆ ಕರೆಕ್ಟ್ ಆಗಿರೋದು ಹಾಕ್ಬೇಕು.
Yes, Your Honor. I will convert
it. Yes.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ entry ಮಾಡ್ತೀನಿ.
Then conversion ಆಗೋವರೆಗೂ entry ಮಾಡ್ರಾಗಲ್ಲ. No.
One
You can't file wrong petitions and ask the right order.
submission, Your Honor. One submission, because tomorrow is the stage is play.
What can be done, madam? You have filed a wrong petition.
No, I will.
Order 7 CRP 617 CRP ಹೆಂಗ್ ಬರುತ್ತೆ?
I will agree.
ಗೊತ್ತಲ್ವಾ? ಮಾಡಿ. ನಾಳೆ ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡಿ, ಕರೆಕ್ಟ್ ಮಾಡಿ.
Yes.
ತೊಗೊಳ್ಳಿ. ಒಂದೇನಾ?
33 marks. Order number 1, Chandrasekhar Reddy KP. Chandrasekhar Reddy KP. Withdrawn.
Thank you, sir. Yes.
Number 2, CRP from.
ಅದು
This case, Malad.
ನೀವು ವಿಡ್ರಾ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಇಲ್ಲ.
ಎಸ್.
ಅದು ನಾಟ್ ಸ್ಟಿಚ್ಡ್ ಪ್ರಾಪರ್ಲಿ ಅಂತ ಹೇಳ್ತಾರೆ.
ಓ, ಇದು ನಾಟ್ ಸ್ಟಿಚ್ಡ್ ಪ್ರಾಪರ್ಲಿ ಕೇಸ್.
Petitioner here in Malad filed suit for declaration and
ಕೇವೇಟ್ ಇದ್ದಾರೆ ಸರ್.
ಅವ್ರಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದೀನಿ ಬೆಳಗ್ಗೆ.
ಹಂಗಾಗ ನೀವು ಸ್ಟಿಚ್ ಮಾಡ್ದಂಗೆ ಆಗುತ್ತೆ ಅದು.
ಅಲ್ಲ, ಬೆಳಗ್ಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ ಅವ್ರಿಗೆ ಬರ್ತೀನಿ ಅಂತ ಹೇಳಿ.
ನಾಳೆ ಬೆಳಗ್ಗೆ ತಗೊಂತೀನಿ, ಬರ್ಲಿ. ಇಲ್ಲ, ನಾಡಿದ್ದು, ಸಾರಿ. ಎಸ್. ಲಿಸ್ಟ್ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಇನ್ ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್.
ಆಡ್ದೇನೆ ಇದೆ ಅಲ್ಲಿ.
ಇರ್ಲಿ, ಸೊ ವಾಟ್?
In the meanwhile, I will permitted to ಅದು processing ಅಲ್ಲಿ ಇತ್ತು ಫೈಲ್.
Objection comply ಮಾಡ್ತೀರಾ?
ಕಂಪ್ಲೈ ಮಾಡಿ.
In the meantime, office objections be complied with.
ಅದು ಯಾಕೆ processing ಅಲ್ಲಿ ಇತ್ತು, ಸಿಗ್ಲಿಲ್ಲ ಫೈಲ್, ಅದಕ್ಕೋಸ್ಕರ.
ಸ್ಟಿಚ್ ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡಿ.
Bill number 3, Abhimanyu Arjun Devi.
ದೇವಯ್ಯ.
That's the answer is appearing this matter.
What's the matter?
That's what has happened is that methods, the respondent number 1 has invoked the pledge methods which the petitioners have given of shares. Now methods, we moved a suit. The order methods, the impugned order is on the basis that.
No, that's what the pledge.
Yes.
ಬೆಳಗ್ಗೆ ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಹೇಳಿದ್ರಲ್ಲ ಅದು.
Methods may see the impugned order. I don't know if the impugned order has been.
They're not surfacey proceedings.
They're not surfacing. I may take my lords to the order itself. My lords may go to the impugned notice.
Now, what is the, today it will get exhausted, is it?
Yes, my lords, I show that how that. Annexure B, my lords, page 31.
Heard the learned counsel Mahesh Chaudhary appearing for the petitioner. The concerned court has now rejected the plaintiff.
Reject madida. Interim order has not been granted.
The concerned court has now refused to grant an interim order on the what is that amount of pledge?
IA number 1 and 2 to stay the invocation of pledge.
IA number 1 and 2 to stay the invocation of pledge.
And consequent actions.
And all consequent actions on the score that the court has no jurisdiction to entertain the petition on the petition as it arises out of certain surfacey proceedings.
I give the certified copy of the order.
Certain that ಬೆಳಗ್ಗೆ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದು ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಅಷ್ಟೇ. Certain surfacey proceedings. The learned counsel ಕೊಡಿ. A perusal at the copy of the order
Paragraph 8, my lords.
is indicative of the fact that the concerned court now declines to grant an order in commercial OS 781 of 2025 on the score that it has no jurisdiction to consider the issues relating to provisions of the Surface Act. The observation appears to be erroneous as there is no surfacey proceedings pending between the same parties or on the same cause of
And the
action.
notice has been issued under 176 of the Indian Contract Act.
The notice that is subject matter before the concerned court is issued under section 176 of the Indian Contract Act and not under subsection 2 of section 13 of the Surface Act 2002. In that light, no, ಏನ್ ಕೇಳಿದ್ದಷ್ಟೇ?
That's
In that light, there shall be an interim order as was prayed before the concerned court till the next date of hearing. Who's the contesting respondent?
That's three private respondents.
No, asset reconstruction company ಯಾರ್ದು?
That is ourselves.
ಅದು ಯಾರು? Who represented them?
Yeah, it was an ad interim ex parte order which we sought
The
for.
petitioner shall serve the respondents by way of hand summons and file an acknowledgement of such service in the next 3 days, lest the matter on Wednesday in preliminary hearing. Till such time, there shall be an interim order.
That's R2 is in Telangana, my lords. Sorry, R3 is in Telangana. So my lords may have it next week or something.
20th, serve, sir. If you want, you serve, otherwise I'll vacate the interim.
Agree.
Yes.
We'll serve the copy.
List on 20th. Yes. Only because today it will get exhausted and but
No, yes, my lords. Grateful.
This one continued. Orders 33.
Post immediately after service of notice upon the second respondent, interim order, if any, shall continue to the next date of hearing. Next.
34.
ಅದು ಇದಕ್ಕೆ interim order ಇದ್ರೆ ಮಾತ್ರ ಕಂಟಿನ್ಯೂ ಮಾಡಿ. Office objection. ಹಾಕಿದ್ದೀರಾ? Learned Counsel Akash Rao submits that he would file his wakalat in the next 2 days.
Please, my lords.
List,
My lords, subject to my lord's convenience. The Friday or Monday
list the
could
matter
be
on
had.
20th, yes.
My lords, 20th is the trial court nal appearance ಗಿದೆ. We are-
ಅಯ್ಯೋ,
Lords, we are-
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಎದುರ್ಕೊಂಡು ಡೇಟ್ ಕೊಡ್ಬೇಕಾ ಇಲ್ಲಿ?
ಅಲ್ಲ appearance ಗಿದೆ. We are seeking a stay.
ಕನ್ವಿಕ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅವತ್ತು? ಇಲ್ಲ ತಾನೆ?
My lords, on
List on
Monday
20th.
subject to my lord's convenience. Could my lords please
20th,
accommodate us?
yes. Office objection stands overruled ಅಂತ ಮಾಡಿ ಆಮೇಲೆ. Yes, next.
18th or 19th, my pray, my lords.
20th, yes.
Grateful.
35 and 36.
A week's time is granted to do the needful. Next. Interim order continue ಮಾಡಿ. 37. Vacating stay ಇದೆ?
Please, your lords.
ಏನ್ what are all these ಜೊತೆಗೆ?
Impending application
PF
has been
is not
allowed.
paid.
PF has been paid, your lords.
Learned Counsel for R6, 9, 10 and 12.
Please, your lords, we paid
Where
the
is
PF.
it? ಯಾವತ್ತು ಪೇ ಮಾಡಿದ್ದೀರಾ?
ಮೊದಲು ಪೇ ಮಾಡಿದ್ವಿ ಲಾರ್ಡ್ಸ್, ಈಗ ತಿರ್ಗಾ ಇವತ್ತು ಹಾಕಿದ್ದಾರೆ ಲಾರ್ಡ್ಸ್. We'll do the needful.
Interim order ಇದೆಯಾ? ಅದಕ್ಕೆ you taking it easy. We'll vacate it.
ಇಲ್ಲ, we'll
Rectification of voice raised in
impeding application.
who is impeding applicant? The Learned Counsel for the petitioner seeks a week's time to do the needful. The needful quay, all the objections be complied with by the next date. List the matter on 20th. Interim order subsisting would continue.
There's another
Interim order
connected
subsisting
matter,
will continue to the next
Another
date.
connected matter.
ಎಲ್ಲಿದೆ number?
Same thing with 87 12027.
ಬರ್ಕೊಡಿ.
ಬರ್ಕೊಡ್ತೀನಿ.
Yes, next.
38.
Post immediately after service of notice upon.
Interim order.
ವಕಾಲತ್ ಹಾಕಿದ್ದೀರಾ? Learned Counsel sons. R1 ಗಲ್ಲ madam. Learned. Ashok Patel is already there. ಮತ್ತೆ why is it rectification of office objections on what? Learned Counsel submits that the office objections, the application is complied with office to verify. Interim order ಇದೆಯಾ?
Yes, ma'am.
List the matter on 23rd. Monday ಅಲ್ಲ, Wednesday ಹಾಕಿ ಮೇಡಮ್. ಸರ್ವಿಸ್ ಆಗಿದೆ, ಬಂದಿದೆಯಲ್ಲ ಆಲ್ರೆಡಿ. Who is R2?
R2, another party, ma'am. Another party, ma'am.
Post immediately after service of notice upon the second respondent. Yes, next. Objections be complied with by the next date. List the matter. R2 ಸರ್ವ್ ಆಗದ್ ಬೇಡವಾ?
Please.
R2 ಬೇಡವಾ?
No, she is the.
No idea?
She is the contesting other
Yes,
party.
list the matter on 20th. ಅದೇನು ಮಾಡ್ಬಿಡಿ, list the matter on 20th ಅಂತ ಮಾಡಿ.
No, madam, there is no application, madam.
20th.
20th.
ಹೇಳಿದ್ರಲ್ಲ ಏನಂತ, no application. Yes.
Interim order.
Yes, that 39.
The petitioner
Rectification of office objections by R4.
Statement of objections of the cavator in. It's my petition, my lord. They are only the statement of
Office
objections.
statement of objections ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದ್ದಾರೆ.
ಅದರಲ್ಲಿ objections ಇದೆ.
ಹೌದು ಸ್ವಾಮಿ.
ಒಂದು ವಾರ ಕಂಪ್ಲೈ ಮಾಡಕ್ ಕೊಡ್ತೀನಿ. A week's time is granted to the respondent to comply with the office objections, square the statement of objection. Interim order ಇದೆಯಾ?
No, my lord. It's
Yes.
not considered.
List on 20, next Wednesday,
Grateful.
19th, sorry, 18th, next.
40.
Appearing for petitioner in this case, my lord.
R1 ಈಗ. R2,
R2 ಸರ್ವ್ ಆಗಿಲ್ಲ, my lord, I'll say.
furnishing of copies ಏನು ಕೊಟ್ಟೇ ಇಲ್ಲ?
I'll take by
Learned
hand, my lord.
counsel is granted a week's time to do the needful. Interim order ಇದೆಯಾ?
ಇಲ್ಲ, my lord.
Do the needful, put up the matter of needful is done. Next.
41.
Post immediately after service of notice upon
My lord, I have
respondents.
served the copy to the council appearing before the trial
Service
court.
of notice, yes, next.
R1 ಗೆ. Interim order, interim
Interim
prayer.
order subsisting will continue to the next date.
ಅಲ್ಲ, ಇಲ್ಲ, interim order ಇಲ್ಲ, ಕೇಳ್ತಾ ಇದ್ದೀನಿ, request.
List on 20th, yes. 42, same order.
Please.
40.
42 ಅಲ್ಲ. Learned counsel so and so submits as he has entered appearance for respondent 1 and 2. Registry to print the name of so and so is appearing for respondent 1 and 2. Interim order ಇದೆಯಾ?
Interim order ಇಲ್ಲ.
List on 20th, next.
43.
Post immediately after. ಆಗ್ಲೇ represent ಮಾಡಿದ್ದಾರೆ, ಏನಿದೆ?
Respondent, my lords. Lords, the copy has been not served to the petitioner, copy has been not served, my lords.
The learned counsel of the petitioner to serve set of papers upon the counsel for the respondent forthwith. Registry to delete the indication of awaiting service of notice upon respondent. Next.
My lords, one submission, my lords. There is a arrears of 3 crore 45 lakhs which has to be paid, my lords.
To whom? Asset reconstruction company.
No, my lords. There was a arbitral award of 7
We'll
crores.
see. Yes, let the petitioner
Kindly,
come.
take it on Friday, my lords.
No, list on 18th, yes. Interim order subsisting will continue to the next date of hearing. 18th bedanga. The 25th interim order subsisting will continue to the next date. Next.
44.
44, I was conditionally permitted to vote, my lords. They were directed to place the votes in the sealed cover before this honorable court.
The other day, my order.
The election, my lords.
Vote ಮಾಡಿದ್ದೀರಾ?
Vote I did, my lords. But they already.
PF ಕಟ್ಟಿಲ್ಲ?
My lords, no, somebody
Week's
appeared on the
time is
last.
granted to do the needful.
They already,
my lord. We have filed the wakalat and also presenting the sealed cover before this thing court. I'll file it in the counter. Now the order has been deferred to 26th, my lord. The lower court, what is deferred? So therefore,
We'll take it on 29th, yes.
My lords,
I'll file it in the counter, my lord.
The same point has been considered, so it has to be before the order of the trial court.
26th.
26, so ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಯಾವತ್ತು?
The list on 25th, yes.
Grateful.
You file it in the registry. Next.
Copy has not been served, my lord. For the thing.
I'll submit immediately.
Yes, next.
Hearing on A 45.
What's the defendant's writ petition, my lord? But suit for a declaration and my lord, the mandatory injunction. But seeking, my lord, when the matter is post listed for my lord, the pronouncement of judgment and IA came to be filed by the plaintiff, my lord, under order 26 rule 9. But
That is allowed?
That is been allowed.
Where is the order?
But the order is at
Interim order ಇದೆಯಲ್ಲ ಇಲ್ಲಿ?
Interim order ಇದೆ.
List on 25th. In preliminary hearing, B group as hearing the application on vacating the interim order and the main is the same. Yes, next.
46.
Appealing for, my lord, in this case, my lord,
Respondents
petitioner filed
7,
suit
8
for
and 9.
partition
Suit is
separate
filed
for-
against a dead
ಒಂದ್ ನಿಮಿಷ
person.
ನಾನೇ ಹೇಳ್ಬಿಡ್ತೀನಿ, ಮುಗಿಸ್ಬಿಡ್ತೀನಿ.
ಸತ್ತೋರ್ ಮೇಲೆ ಕೇಸ್ ಹಾಕ್ಬಿಟ್ಟು
ಒಂದ್ ನಿಮಿಷ ರೀ ಹೇಳ್ತೀನಿ.
ಅಲ್ಲ ಅವರೇ ವಿಡ್ರಾ ಮಾಡ್ತಾರೆ ಬಿಡಿ.
I have filed suit for partition separate position, my lord. During the pendency of the suit, defendant number 6, legal air filed memo stating that even before filing the suit, my lord, he died, my lord.
18 years before
I have
filing
filed
the-
application to bring the law, that application is dismissed. Now in view of the Supreme Court judgment, my lord, the application is not maintainable. I may be permitted to withdraw the writ petition with liberty to file necessary application to implement them and record, my lord. That's all.
Who are you?
I am the plaintiff, my lord.
ಅದು ನನಗೆ ಗೊತ್ತು ಸರ್. In relation to the defendant,
Depend number, the brothers and sisters, my lord. It is a joint family property, joint
No, no,
family.
we are
and
not the brothers. We are
Depend number
purchasers
6 is
25
the
years
purchaser
ago.
of the property, my lord.
From the,
Depend number 6
from
is
the members of the family.
from the members, depend number 1 to 3.
ನೀವು ಹೇಳಿಲ್ಲ, ನಾನು ಹೇಳ್ತೀನಿ.
Please,
Yes. Please.
please.
Please. Yes. You are the, he is the purchaser from one of the members of the family.
Yes,
Correct?
my lord.
18 ವರ್ಷ ಸತ್ತು 18 ವರ್ಷ ಆದ್ಮೇಲೆ ಏನ್ ಹಾಕಿದ್ದೀರಾ ನೀವು?
But at that I was not aware of the death of the purchaser, person who purchased the property from depend number 1 to 3, my lord. It is only when the notices are issued, the depend number 6 legal heir appeared and filed memo reporting the death of depend number 6, my lord. Then I have filed application to bring the legal heirs on record.
ವಿಡ್ರಾ ಮಾಡ್ತಾ ಇದ್ದೀರಲ್ವಾ?
ಹೌದು, withdraw the application to make necessary application.
Withdraw this petition.
Otherwise, my lord.
Otherwise, there is no other way.
No, otherwise, my lord, my right will be curtailed, my lord.
ಯಾವ ರೈಟ್? 18 ವರ್ಷದಿಂದ ಹೋಗಿರೋ ರೈಟ್.
No, that time I was not aware of the fact, my lord.
Yes.
And since the death of the respondent, depend number 6.
Counsel for the petitioner arguing the matter at length would seek leave of this court to withdraw the petition and avail of such remedy as is available in law.
Please.
The petition is thus disposed as withdrawn, reserving such liberty as available in law, if available in
Please.
law. Ordered accordingly.
Oblige.
Yes.
My lord, one more submission, my lord. Now, my lord, petitioner is also.
Dispose ಆದ್ಮೇಲೆ ಏನ್ ಸರ್?
ಅಲ್ಲ, I am sorry, my lord. Petitioner ಸತ್ತೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಅದಕ್ಕೆ no, my lord, your lordship kindly next ಎಲ್ಲಾರ application file ಮಾಡೈತದ್ದು ಇಲ್ಲಿ put up ಆಗಿದೆ. That is filed, my lord. That
Suit against dead person ಅಲ್ಲ. Writ petition also made by a dead person.
writ pending ಇರ್ಬೇಕಾದ್ರೆ ಅವರು ತಿರೋದು ಎಲ್ಲಾರ application ಹಾಕಿದೀನಿ. That may be allowed and thereafter matter may kindly be disposed.
ಆದಿತ್ತು.
Petitioner ತಾನೆ.
Petitioner ಎಲ್ಲಾರ್ಸ್ ಬರೋದು ಬರ್ಲಿ, then withdrawal. I have no objection.
Yes. The first separate order sheet ಬರ್ಕೊಳ್ಳಿ. IA 1 of 20, ಯಾವ್ದು IA? IA 1 of 2025 to bring the LRs, during the subsistence of the subject petition, the petitioner has died and the petitioner has preferred an application in IA 1 of 2025 to bring the legal representatives of the deceased petitioner on record for the reasons indicated so and so, allowed amended cost rate like first.
Please,
ಎಲ್ಲಿದೆ?
ಅಲ್ಲ ತಂದಿಲ್ಲ. Tomorrow I will file. ಇದು ಅಲ್ಲ ಆದ್ಮೇಲೆ ಹಾಕ್ಬೇಕಲ್ಲ, amendment ಮಾಡಿ ಅಲ್ಲ.
ಈಗಲೇ ಮಾಡಿ. Petition ಈಗಲೇ ಮಾಡಿ ಇಲ್ಲ
ಈಗಲೇ ಮಾಡ್ಬಿಡ್ತೀನಿ.
Yes. So and so. ಅದು ಅಲೋ ಮಾಡಿದ್ಮೇಲೆ ಸೆಪರೇಟ್ ಆರ್ಡರ್ ಆಮೇಲೆ ವಿಡ್ರಾವಲ್ ಮಾಡಿ. ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ?
3 ಜನ ಇದ್ದಾರೆ.
ಪರವಾಗಿಲ್ಲ.
3 1 2 3 4 ಜನ.
ಅದು 1 2 3 4 ಹೇಳ್ತೀವಿ.
1A to 1D.
ಎಲ್ಲದರಲ್ಲೂ ಕನ್ಫ್ಯೂಷನ್ ಇದೆ.
Sorry. 1A to 1D.
1A to 1D ಅಂತ 5 ಆಯ್ತಲ್ಲ? ಇಲ್ಲ.
4 ಜನ. 1 2 4 ಜನ.
47 and then 48.
In this case, appear for the respondent.
So
I'm questioning the order passed by the executing court, my lord, wherein, my lord, the executing court accepted the Lebanese sketch and ordered to issue delivery warrant, my lord. My lord, in this case, my lord, 2 agriculture properties are in dispute. My lord, the decree holder, my lord, are decreed and is entitled for 1 acre.
I will hear it on 20th. Just on 20th.
Up to Supreme Court is afforded the order.
We'll see. 20th, yes.
And my lord, since 1 year, my lord, proceedings have been stayed, execution proceedings.
20th ಅಷ್ಟೇ, ಅದೆಲ್ಲ ಇನ್ನು ಮುಂದೆ ಹೋಗಲ್ಲ ಅಲ್ಲಿ. 20th in preliminary.
May I make one submission, my lord? You are ready to give 1 acre and 2 acres, my lord.
1 acre and 2 acres. So 3 acres.
2 survey numbers, my lord.
3 acres.
3 acres. First, they are claiming particular part wherein, my lord, 4 bore wells are situated. They, my lord,
if you still want to settle,
they are ready to settle the matter, my lord. The particular boundary they are asking for particular, we cannot give, my lord.
Nodi, if you can settle it.
My party is here, my lord.
ಹಾಕ್ತೀನಿ ನಾನು. ಅಷ್ಟರಲ್ಲಿ want to settle it. Right?
Please. Interim order may kindly be extended.
Interim order subsisting will continue to the next date of hearing. Next.
For the respondent number.
I filed the
A first. By way of the impugned order, my lord, the learned trial judge stay the dispute proceedings pending before the deputy registrar, my lord. My learned friend obtained an interim order from this honorable court to the interim impugned order passed by the learned trial judge. Then they prosecuted the dispute petition, my lord. In the event he prosecuted the dispute petition, both suit and writ petition become infructuous. Therefore, I moved the matter, my lord.
List on Monday.
17th.
Interim order may kindly be extended.
Based on Monday in preliminary hearing. Interim order subsisting will continue to the next.
16th, my brother-in-law's
Brother-in-law?
18th, brother-in-law's marriage, my lord. And 16th.
Marriage, ah? Brother-in-law's marriage.
Brother-in-law's marriage, 18th.
18th, all right. Interim order will continue. Next.
50.
For the petition, the respondent number 5 has died. Got an application to bring his LRs on
File
record.
the wakalat for 5A and B also. Learned Counsel R.S. Umesh undertakes to enter appearance.
No, I have already filed a wakalat.
For submits that is already entered appearance for R5A and B. Application allow ಮಾಡೋಣ ಆಗ್ಲೇ ವಕಾಲತ್ ಹಾಕಿದಿರಲ್ಲ. In that light, the applications, but continuation of delay ಆಗಬೇಕಲ್ಲ setting aside. ಮೂರು ಎಲ್ಲ allow ಮಾಡ್ಬಿಡಿ ಮೇಡಮ್. All applications for the reasons indicated so and so allowed. ಆಮೇಲೆ already entered appearance ಕೊನೆಗೆ ಹಾಕ್ಬೇಕು. Yes, next. ಗೊತ್ತಾಯ್ತಾ?
51.
Yes.
One submission. Very
Beginning
short
stage.
matter. It's a partition suit, compromise has been entered and final decree has also been drawn.
What's the problem now?
What's happened is subsequent to the final decree being drawn, my lord, on the basis of the compromise decree, 40 proceedings have been has taken place and sub numbers have been given. When the final decree was presented for
ಈ
registration,
stage ಅಲ್ಲಿ ಏನ್ ಕೇಳಲ್ಲ.
only for amendment of the decree on the basis of the 40 proceedings. my lord.
You have no objection.
ನನಗೂ ಹೆಲ್ಪ್ ಆಗುತ್ತೆ.
ಸರಿ ಹಾಗಾದ್ರೆ ಫ್ರೈಡೆ ಹಾಕಿ preliminary hearing day after tomorrow.
Please.
Yes. ಎಲ್ಲ ಅಲೋ ಮಾಡಿ preliminary hearing ಎಲ್ಲ ಹಾಕಿ. We'll close it on that day, Friday. Yes. ಈಗ amendment ಹಾಕ್ಬಿಡಿ. Yes. ಈಗಲೇ ಕೊಡಿ ಮೇಡಮ್. Next.
51.
My lords, I appear for the respondent number 1 in this matter. I have filed an application for vacating the interim order, my lords.
My lords, I kindly seek time, my lords. Matter may be taken up tomorrow, my lords. This one is
Tomorrow
clear.
ಆಗಲ್ಲ. We'll take it on Wednesday.
Please, my
Very
lords.
well.
Wednesday 18th.
Very well.
List on 18th.
Interim order may be kind.
Interim order subsisting will continue to the next date. Next.
Please.
I'm great.
Lord, I appear for the petitioner, my lord. What is before this honorable court is the proclamation order, my lord, in execution of a decree. My lord, this may be disposed of today. My lord, I had undertaken to pay 4,60,000 to the auction purchaser, out of which I have paid already 2 lakhs. 2,60,000 is what is pending. I have already deposited the decree amount before the execution court, that is 25 lakhs. So if this honorable court pleases to order 2,60,000 to be paid out of that to the auction purchaser, and if they go out of that, the decree holder and the judgment debtor can file their respective memorandum of calculations and close the matter, because what rests is to
You are the auction purchaser.
No, my lords, I'm the decree holder.
Decree holder. Auction purchaser yaar.
So 2,60,000 is what is pending, my lord. That is the 5% of
To
the
be
amount.
paid to the auction purchaser.
Yes, my lord. I have already paid 2 lakhs.
One minute. We will direct him to pay 2,60,000 to the auction purchaser.
Very well.
So auction purchaser goes out
Please, my lords.
because gets money.
Please.
Now what remains is between two of you. Memo of calculation you file and court will pass necessary order.
Very well, my lords. The amount deposited by him, let me be permitted to withdraw that. That is my
What is
application.
that amount?
25 lakhs was deposited by him
All right.
as a condition to the interim order.
He is entitled to that amount. Let him
Let them file memo of calculations and withdraw, my lord. I don't have any problem, because my contention is they have taken the.
All right, memo of calculation will be filed.
But what he is saying is, out of that 25 lakhs, 2,60,000 should be paid to her.
Please, my lord, that is my
No, that
submission.
is
Let him-
auction purchaser's amount.
Please, my lord, if
You
they
are,
go.
you are the judgment debtor.
Yes, my lord.
You can't impose conditions.
No, I'm not, I'm requesting, my lord, before the executing court, I have deposited 25 lakhs. 2,60,000 had to be paid to the
What
auction
is
purchaser.
the auction amount?
92 lakhs, my lord, that they have deposited.
92 lakhs is deposit.
Deposited.
5%.
5%.
5% deposit ಮಾಡಿದ್ದಾರೆ 92 lakhs.
ಇಲ್ಲ 92% they have deposited. 4,60,000 I undertook to pay on top of it.
So that is between you.
That between before this honorable court.
How can you deduct it in the money belonging to the?
No, I'm not asking, my lord. It's not a matter of right, my lord, because we can close this dispute here.
That you want to settle with him with that amount. I cannot pass a judicial order saying 2,60,000 will be deducted from the amount that the decree holder is entitled to.
This is the fourth
No,
round of
it is not
litigation,
any
my lords.
specific.
It has gone up to Supreme Court, my lords. Till 5 years, it has gone up to Supreme Court. They have not paid a single money. At the instance of this honorable court, they deposited that amount, my lords.
Single money, single penny.
Single rupee.
Okay, my lord, the-
Adela illa. First we'll close one by one. The learned counsel for the petitioner undertakes to pay rupees 2,60,000 that he has to pay. That she has to pay, which is the remainder of the 4,60,000 that was undertaken to be paid to the auction purchaser. The submission is placed on record. Therefore, the auction purchaser is now satisfied that the amount is returned back to the amount of 4,60,000 as agreed is returned back. ಅಲ್ಲ ಯಾವಾಗ ಕೊಡ್ತೀರಾ ಅದು?
ಇಲ್ಲ, ಅದು we are requesting for some time, lord. ಅದರಲ್ಲಿ ಇನ್ನು 2,60,000 ಕೊಡಕ್ಕೆ ಅವ್ರ ಹತ್ರ ದುಡ್ಡಿಲ್ಲ.
The claim of the auction purchaser would thus get satisfied. The learned counsel would further submit that the petition can be disposed on the score that the memo of calculation be filed by the decree holder, and then the court could
The executing court.
The executing court could proceed with the matter. Counsel for the decree holder submits that 25 lakhs is already in deposit before the concerned court, and the court must be there, and this court should issue a direction permitting the decree holder to withdraw the amount. The learned counsel for the petitioner submits that memo of calculation be filed and the amount be permitted to be withdrawn. On all these reasons, the counsels are granted time up to next Wednesday. Yes, you will get the DD to pay. We will send the auction purchaser 25. I will permit no 2,60,000 reducing from that. You can't deduct that. That I will not permit.
On instructions ಬರ್ಲಿ.
ಯಾವ
ಅಲ್ಲ petitioner ಇದ್ದಾರೆ, on instructions ಬರ್ಲಿ, whatever makes sense.
ಆಯ್ತು. The aforesaid submissions are made on instructions of the petitioner who is present before the court. Yes.
Please.
Next. Appointment of receiver.
IA1. The respondent in this matter
filed an application for appointment of receiver, my lords. During the pendency of the, my lords, this writ petition, when there are totally, my lords, 3 suits that are pending before, and 2 suits, my lords, have been clubbed with regard to 2 properties, my lords, which are adjacent to each other. Lords, one property is 35 guntas.
Yes.
Another property, my lords, is 14 guntas. It's a composite property. If my lords may take the application, my lords, we have produced the photos along with the application.
One submission. So before that, my lords, regarding the maintainability of this petition, my lords, the interim order was passed by the trial court ex parte, my lords. Ex parte interim order was passed. On that, my lords, the petitioner had also filed his objection and argued
hear him and pass out.
Yes.
Ex parte interim order.
Ex parte interim order was
Had
granted.
argued.
We entered appearance, my lords. We filed our objections and we requested that the matter was advanced. After hearing our arguments, my lords, then the application suit was adjourned, my lords, beyond the vacation period. That was beyond 30 days. So we approached this honorable court. Those orders have been stayed. No, my lords,
I will direct the concerned court to hear both of you and pass orders in 15 days.
my lords, ex parte orders have been stayed by my lords.
That will continue till 15 days. Hear and pass orders.
That is all, my lords.
Lords, what had happened is the high-handed action. I just wanted to bring it to the notice of the court. If my lords may kindly take the photographs for a moment, my lords, what has happened?
High-handed action.
My lords, what they have done is during the pendency of this suit, when there is an interim order operating here, as well as my lords, there is an order of status quo operating, my lords, in 2 different suits. If my lords may kindly see the photographs, my lords, for a moment.
ಏನು trespass ಮಾಡಿದಾರಾ?
ಇಲ್ಲ, trespass ಮಾಡಿ possession ತಗೊಂಡು, and now my lords, they are trying to sell my generator. They are trying to sell all the mobiles, and therefore ಅಲ್ಲ, injunction stay ಇದೆ, but in violation of that, my lords, there is also an injunction operating against him. But despite that, my lords, he is just entering the property, and therefore I'm seeking for appointment of receiver.
I have to seek instructions, my lord. I saw the
and I've stated specifically that we have given multiple complaints. Police is not taking action because
let
of
these be, my
influential
lords,
person.
in the trial court, my lords, time,
now I
time
will
bound may be
observe
given.
that they will also not precipitate with the matter till the matter is heard before the concerned court. And if done, liberty would be reserved to you to initiate appropriate action. Criminal case register madilva?
ಇಲ್ಲ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ರು ತಗೊಂಡಿಲ್ಲ. And Milords, he is an influential person. Milords, this is Mysore jurisdiction property. Now what he is doing is, I have a status quo also in respect of this property by a different jurisdictional court. Milords, and there is a, in respect of his ex parte injunction order, there is a stay by this honorable court. Kindly just, Milords, page 16 may kindly be seen for a moment, Milords.
I think dispose ಮಾಡಕ್ಕಾಗಲ್ಲ.
Milords, kindly have
We'll take it on Monday.
Please.
Yes.
The time board was proper, my lords.
Monday, yes.
Otherwise, my lords, I'll lose the.
ನೀವು ಬೇಡದ್ದೆಲ್ಲ ಮಾಡಿದ್ರೆ ಇದೇ ಪ್ರಾಬ್ಲಮ್. You say you undertake not to precipitate, we'll
I'll
close the
undertake, my
matter.
lords, not to precipitate, my lords.
We'll close
Let
the
it be
matter.
disposed, let the trial court
Let it
hear
come
on
up on
merits.
Monday, Milords. Let it Monday barely.
Monday.
Let him take proper instructions with regard to the fact of how he is not, he'll say he's not precipitating, but at the end of the day, he's already barged in, Milords, and sold the properties.
Crime register ಮಾಡಿ.
Allah, we have already, Milords, given complaints, none of them are taking. I understand, Milords, I have the option of a PCR and other options also.
Yes.
Please, Milords, can it be on Wednesday instead of Monday?
All right. No, Wednesday, yes.
Please.
54.
That will continue.
Please. Yes.
My lord, it's my rejection of the clubbing application. I've sought for clubbing of 18 cases together. I'm the defendant in the original suit. The plaintiff is a common plaintiff in all the 18 cases.
That is rejected.
Yes, the clubbing application is rejected. And the issues to be tried between the parties are one and the same in all the 18 cases.
Defendants are.
Where is the section 24 application?
In all cases, defendants are different.
Where is the section 24 application?
Section 24 applications.
Clubbing ಅದೇ ತಾನೆ. Where is the application?
All cases, defendants are different, my lord. Even suit scheduled property also different. The evidence ಬಂದು 2023 ಅಲ್ಲಿ ಆಗುತ್ತೆ, ಕ್ರಾಸ್ ಮಾಡೋದಿಲ್ಲ. ಆಮೇಲೆ ಈ application.
I have filed this application at the time of when when it was posted for plaintiff evidence. The PW1's witness, the plaintiff witness in all the 18 cases is one and the same, and the documents marked in all the cases is one and the same.
In all 18 cases, defendants are different, my lord. Even suit scheduled
If
property
I
also
can
different.
bring your honest kind attention to the plaint, which is annexed A.
Now, who is this impleading?
Impleading application, there was an office objection that let all the other defendants also of the other cases also be impleaded anta. So hence I filed this impleading application in compilation of the office objection.
Let's the matter on Monday.
Yes, it's coming up before trial court on 13. Let there be an interim order to that extent, my lords.
Yes. We'll see whether 24 is maintainable or not. Next, yes. List on 16th, yes.
55.
Appearing for the petition is prepared. Your Lordship, this is the case where the defendant.
Recalling the order.
Also, sorry?
Go, it is non-prosecution, huh?
Non-prosecution, illa,
The
sir.
petition was dismissed. I am the respondent number 3. It has to be placed before the court.
Registry to post the matter before the application is called to recall a particular order which is rendered on its merit.
Not on merits, sir.
Merits on the final, it's a final order, my lords.
It will not cause any prejudice to the petition. No. The application is preferred to recall the order in IA2 of 2025. The order is passed by Honorable Justice H.T. Narendra Prasad. The matter be placed before the same Honorable Judge. Yes.
Please, my lords.
2 minutes, sir.
No, 2 minutes alle madi. 2 courts away, this side. Yes.
56, Sergeant, 57.
My lord, in 57, my lord, I appear for the respondent. My lord, an application that was filed for recasting of issues in a specific performance suit has been rejected by the court below. My lord, I file a caveat on that. The caveat is not served. My name is shown in the cause list instead of the caveator's counsel, and an interim order is passed on 16th of April. There is a direction passed by this court in MFA as per Exhibit R7, saying that the suit should be disposed of within a time.
Now you have the copy?
Yes, now I have a copy. I have also filed a stay vacating application.
Oh, vacating stage, yeah.
But there is a difficulty with respect to the senior counsel is engaged in this matter. Kindly have it tomorrow, my lords.
Tomorrow agala. We'll have it on Wednesday. List on Wednesday.
May I just request one indulgence from the court. My lord, let the evidence go on, my lord, because nothing is going to happen. He has to just step in.
We'll dispose it on Wednesday. List
Monday,
the
Your
matter on Wednesday in preliminary hearing. Yes.
Equally obliged.
Yes.
58.
I am for the petitioner.
R235 ಯಾರು?
For respondent number 4 my lords.
They are the defendants before the trial court.
You are for 5.
For 4 my lords.
5 ಅಂತಿದೆ ಇಲ್ಲಿ. ಅಲ್ಲಿ ಹರ್ಡ್ GL ವಿಶ್ವನಾಥ್ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಅಂತ ಹಾಕ್ಬಿಟ್ಟು ಆಮೇಲೆ
They are the defendant number 3 and 4 before the
ಇದು
trial.
ವೆಕೇಟಿಂಗ್
Vacating they filed.
Yes,
I
my
want to
lords.
file up.
ಎರಡು ವೆಕೇಟಿಂಗ್ ಇದೆ.
ಇಬ್ರು ಹಾಕಿದ್ದಾರೆ ಇಬ್ರುನು. I will file objections.
Learned counsel for the petitioner seeks a week's time to file objections to the application seeking vacation of the interim order. List on 20th. In the event the objections would not come about by then, the application for vacating stay would be answered. Yes.
Interim order.
Interim order existing shall continue till the next date of hearing.
69.
ಏನಿದು?
The Sharda Education Trust and this Tirupurali Education Trust, the share agreement was entered into between the parties.
In this, what has happened is, there was, my lord, I was running a school. I was allotted a land, I constructed a school. Then, my lord, a fee sharing agreement was entered into. Thereafter, my lord, with one Tubarahalli trust, they filed a suit. They obtained an interim order. That, my lord, was stayed by this honorable court. So, my lord, what they do is, another suit is filed through, my lord, in the name of the school, represented, my lord, if your lordship look at, my lord, the cost title of the plaint, please come to, my lord, running page.
Yes.
Here is the plaint, madam.
Cost page, sir.
If your lordship come to, my lord, page 6, our yaru anta heli Sharda Vidyaniketan, managed by Tubarahalli Foundation Trust.
What is the order under challenge?
Order, my lords, get that at, my lord, running page 21. Interim order has been passed
39 rule 1 and 2.
by a
TI is rejected.
He is granted.
Granted.
Granted. Against that, your lordship will see, instead of filing an MFM, my lord, they filed a writ petition and obtained stay.
Here.
Here.
Yes.
plaint ತಾವು
ಅಲ್ಲ ಬಟ್
81 ಗೆ ಬನ್ನಿ.
ಫಸ್ಟ್ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಹೋಗ್ಲೇ ಇಲ್ವಾ?
ಫಸ್ಟ್ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲ, ಇದು ex parte interim order was granted. Suit
No. Sorry, my lord, it is on merits.
Can I?
ಒಂದ್ ನಿಮಿಷ.
On merits. Please.
Please come to, my lord. Let us have a look at the order, my lord. Plaint to 81 ಗೆ ಬನ್ನಿ. ಒಂದ್ ನಿಮಿಷ. I'll tell you lordships why. ಬನ್ನಿ ಅಮ್ಮ. ತಾವು
we'll take it on Friday if you want.
That's your lordship.
Friday.
Adi.
The Friday afternoon, I think there is no sitting.
No, I will take forenoon.
ಆಗ್ಬೋದು.
Please, please.
Yes, ಇವತ್ತು afternoon ಆಗಿರೋದು because forenoon was 1 hour away. Yes. Yes.
ಅಲ್ಲ ಇವತ್ತು ಪಾಪ
Friday.
ಅವನು ಸ್ವಲ್ಪ ಯಾಕೋ ಸ್ಲೋ ಇದ್ರಿ, ನಾವೆಲ್ಲ ತಮ್ಮನ್ನ ತಡೆ ಹಿಡಿತಾ ಇದ್ವಿ.
ಇಲ್ಲ, ಇದು ಬೋತ್ ಸೈಡ್ಸ್ ಇರ್ತಾರಲ್ಲ, ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. Slow ಆಗೇ ಆಗುತ್ತೆ.
ಅಲ್ಲಲ್ಲ, ಅದಕ್ಕೆ ನಾನು ಹೇಳಿದ್ ನಾವು ತಡೆ ಹಿಡಿತಾ ಇದ್ವಿ, ಬೇಕಾಗ್ತಾ ಇದ್ವಿ.
Yes. ಬಿ ಗ್ರೂಪ್ ಎಲ್ಲ ಒಂದು ಡೇಟ್ ಕೊಡ್ತೀನಿ. ಇಂಟರ್ ಮಾಡರ್ಸ್ ಇದೆ ಎಲ್ಲದರಲ್ಲೂ.
Serial number 65, my lords. My lords had heard the matter, my lords, and posted it for dictation of orders, my lords.
ಏನದು?
My lords, order 6, rule 17 application, my lords. I filed vacating stay application, my lords.
ಇದು 65 ಮಾತ್ರ. ಪೋಸ್ಟ್ ಮ್ಯಾಟರ್ ಅದು ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ ಇದೆ. ವೇಟ್ ಸರ್. ಪೋಸ್ಟ್ ದಿ ಮ್ಯಾಟರ್ ನೆಕ್ಸ್ಟ್ ವೆಡ್ನೆಸ್ಡೇ ಅಂಡರ್ ದಿ ಕ್ಯಾಪ್ಷನ್ ಹಿಯರಿಂಗ್ ಆನ್ ಇಂಟರ್ಲೋಕ್ಯುಟರಿ. ಯಾರಾದ್ರೆ ಏನ್ ಸರ್, ಡಿಕ್ಟೇಷನ್ ತಾನೇ ಮಾಡ್ಬೇಕು. ಆಯ್ತು, ಫ್ರೈಡೆ, ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ.
Your lordship, if I may be permitted.
All B group matters will fix a date. ಎಲ್ಲ ಹೇಳಿದ್ರಾಗಲ್ಲ. Page wise ಕರೀರಿ. Yes.
Page 12, 60 to 63.
60 to 63. We will list it on 25th. ಆಮೇಲೆ 64.
64. My lord, serial number 64.
Interim orders will continue. Please don't make it.
67, my lord. 64, my lord.
1 minute. 64 ಏನು?
I appear for the respondents.
I am
my
for
lords. I filed
petition.
an IA for vacating. Suit is of the year 1981. my lords.
64,
One small
list
submission.
on Wednesday under the caption interlocutory application. Yes.
My small submission.
65 was same.
64 all on
65 matra next Friday.
My lord, 64 all on submission. Previous that DCL appear connect ಆಗಿಲ್ಲ interim order action.
ಯಾವುದು interim order will get, don't worry, interim order will
date all
get,
appear ಆಗಿಲ್ಲ.
interim order extend ಆಗುತ್ತೆ.
Oblige.
Yes. Next. 66. Merits ಮೇಲೆ ಹೇಳ್ಬೇಡಿ. ಅದು ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ಯಾವತ್ ಬೇಕು ಅಂತ ಹೇಳಿದ್ರೆ ಮೆರಿಟ್ಸ್ ಸೇಮ್ 25th.
67. My lords have noted, no, my lords have, 1 minute. My lords have noted urgency in the last order because they had engaged the senior counsel. The trial court is holding on to the matter. It's only for them to file an affidavit of assets. There's urgency, my lord.
List 67 ಅಲ್ಲ?
Please.
List 67, 20th. Yes.
Please.
Unavailable on 20.
You're not available.
I'm not available on 20th. Milord. I'm traveling for 1 week from 13th.
Then 18th. Yes.
Please.
Milord, I'm not there on 18th. From 13th to 20th, I'm traveling.
You're not there.
My lord, they are dodging and
25th, my lord. Senior has also said
make
to
alternate arrangements. Yes. List on 20th. Yes. 68, 25th.
Appearing for the respondent, my lordship. We will file objection request for 1 week time.
69, list on 1st July. Yes. Interim order ಇದ್ರೆ continue ಮಾಡಿ. Yes. 17 is same 1st July.
17.
Sorry.
Wait.
Past over ಯಾವುದು ಇದೆಯಾ ಮೇಡಮ್? ಒಂದಾ? We'll see. Wait. Yes. Dictating order, same stage will continue. Yes. Tomorrow, day after, continue agli. 73. Ayyappa.
It's okay.
Bharat. Yes. 73. 25th. Yes. Further hearing will repeat on Monday.
Your lordship.
Hmm.
Your lordship, if I may be permitted to make a
Wherever
mention.
interim orders are there, they'll continue.
This is regarding a hand delivery of the order that the 230 list moved matter, your
Ivattu.
lordship. Serial number 3, the pledging of shares, the matter.
That
Can I
you'll
move, get a
you'll
hand
it.
delivery?
Where is the memo?
Just right.
Mentioning on sari, memo on sari.
No, your lordship, apologies.
Hold the memo and make a mention.
No, apologies.
Yes.
74, Monday, 34. Lord, serial number 71, my lord.
All these further hearing matters will repeat. Yes.
There's one submission in
ಅದು
76.
dispose ಆಗೋವರೆಗೂ repeat ಆಗ್ತಾ ಇರುತ್ತೆ.
One submission in 76.
Yes, Rajat.
But it's the investigation, 76. The investigation papers were called for in July 24.
Not yet come. The government ಯಾರಿಲ್ಲ. The learned additional SPP shall secure the investigation papers and place it before the court on the next date. Yes.
79 also, my lord.
79.
Doctors. Bharat, adu Bharat. Yes. It will be repeating. Yes. Next. Monday ಇಂದ ಮತ್ತೆ ರಿಪೀಟ್ ಆಗುತ್ತೆ. ಇದು ಫ್ರೈಡೆ ಹಾಫ್ ಡೇ ಇರೋದ್ರಿಂದ ಮಂಡೇ ಇಂದ ಫ್ರೈಡೆ ವರೆಗೂ ರಿಪೀಟ್ ಆಗುತ್ತೆ.
List number 2, first time matter.
My lord, item number 3, I am the caveator. List number 2, item 3. I'm the caveator. The matter is infructuous.
Why?
My lord, the order that they have challenged is from November 2023 during plaintiff's evidence. Now the matter is at the fag end of the trial.
That does not make it infructuous.
My lord, it has been languishing for 2 years.
That's all right. That does not make it infructuous anyway. Yes.
May I make one?
1 minute.
Serial number 3 will comply within 1 week.
1 to 26, 2 weeks time is granted to comply with the office objections. If not already complied, and if complied, list the matter on the ensuing Monday. Next, yes. 9, wherever withdrawal is at home. Yes.
Number 1, urgency, my lord, the attachment warrant is issued.
ನೀವು ಕಂಪ್ಲೈ ಮಾಡಿ ಮಂಡೇ ಬರುತ್ತೆ.
Tomorrow I will comply.
You do it, it will come on Monday. Attachment warrant and ನಾಳೆ ಮುಗ್ದೋಗ್ಬಿಡಲ್ಲ. Yes.
Well, serial number 18, second least 2, my lord. Advocate submission is there in that. Just the name that case number is wrongly typed. That is submission.
Case number wrongly type ಮಾಡಿ ರೈಟ್ ಆಗಿ ಮಾಡಕ್ಕಾಗಲ್ವಾ?
ಅಲ್ಲಿ ನಮ್ದಲ್ಲ
ಅದಕ್ಕೂ ಸಬ್ಮಿಷನ್ ಬೇಕಾ?
ಟ್ರಯಲ್ ಕೋರ್ಟ್ನಲ್ಲೇ ಮಾಡಿದ್ದೆ, ಸಬ್ಮಿಷನ್ ಬರ್ದಿದ್ದೀವಿ, ಅದು ಎಕ್ಸೆಪ್ಟ್ ಮಾಡಿದ್ರೆ ಸಾಕು ನಾವು.
ಅದು ಕರೆಕ್ಟ್. 16 ಆಲ್ಸೋ ವಿಡ್ರಾಯಲ್ ಇದೆ ಮೇಡಮ್, ಮೆಮೋ ಫಾರ್ ವಿಡ್ರಾಯಲ್. ಆಮೇಲೆ 17, 18 ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಷನ್ accepted, overruled Monday. Next.
Grateful, my lord.
Second time matters 27.
10 days.
Number 22, my lord.
10 days time is granted to do the needful. Same order, 10 days. Yes, next.
Third time 35, 40. My lord, 37 and 38, my lord. It is regarding maintainability, my lord. Next week I'll have to look.
Next week ಎಲ್ಲ. Yes.
18th or 19th, my lord.
18th ಇಲ್ಲ. 16th, 18th, yes. Madam, maintainability ಮಾತ್ರ next 18th ಹಾಕಿ. Third time 1 week. Fourth time 1 week, same order.
May I make one submission, my lord, in between?
Office objections ಅಲ್ಲಿ
ಅಲ್ಲ. Further hearing, my lord, serial number 83.
ಇವತ್ತಿದೆಯಾ?
ಇವತ್ತಿದೆ.
ಏನದು?
On Monday it was listed. This court has expressed opinion that a stay will be vacated. That M.N. Madhusudan is appearing
this
on.
matter. ಇದು ಮಾತ್ರ ನಾಳೆಗೆ ಹಾಕಿ. List tomorrow 83. Tomorrow.
Please.
One submission, Your Honor. Serial number 32. I will now itself I will convert the
Unconversion.
tomorrow maybe.
You should file a fresh petition.
I will convert it to.
You file a fresh petition, madam. You can't do that. ನಿಮಗೆ ಹೆಂಗ್ ಬೇಕು ಹಂಗ್ ಮಾಡಕ್ ಆಗಲ್ಲ. Yes. ಪಾಸ್ವರ್ಡ್ ಕರೀರಿ.
Seal number 7, passed or seal number 7.
And delivery.
For the petitioner. Regarding dismissal of my appointment of court commissioner application.
So this will, you take it on Monday.
Friday.
Friday half day, sir. Again.
59. Matter
Next
posted for Friday.
Entry module.
Seal number 11.
Appearing for the petitioner and 11, my lord. This is the subtenant matter, my lords.
ನೀವೇ ಇರ್ಲಿಲ್ಲ.
Please, madam. He was held up in portal number 6. But kindly come to.
My lords, before my learned friend starts, there's just two submissions I want to make, my lords. My lords, he had filed a suit for injunction, my lords, on the same property. His temporary injunction has been vacated there and his lease deed has also been impounded.
I've heard you at length. Wait. List on Friday. Now it's time.
I want to make two more submissions with regard to
No,
section
few
4.
more, sir. I've already heard.
No, my lord, I want to only make submission with regard to
Aye,
section 4, section 43 of
My lord, serial number 59.
Under preliminary hearing on Friday, my lords.
My lord, serial number 59. Kindly the interim order may be extended.
Madam, 330 matter 85.
Madam, 11 Friday gala. Madam, serial number 11 Friday gala.
Further in date.
Ma'am, can you tell me the date in item 70, madam?
Yeah, I have.
70 corresponding.